right into the questions and answers. So, anybody have a start off with?
Yeah, Christmas from New Jersey. How you doing?
Good. How about you?
Good, thanks. Two things. One, you had a question Saturday about the gentleman caught in Connecticut about the IRS letter.
Yes. Was that where it's from, Connecticut?
Not from New Jersey, but he knew that he was the IRS was the trustee because they made him the grantor on communication.
Oh, so he didn't really have a documentation that stated that they were specifying that they were trustees.
I don't recall for sure, but it did indicate that he was the grantor, and so from that, we said that was a good thing because he gave him the authority to then ask them to prove trust.
Yeah, but I thought maybe he had a document that actually stated that the United States was trustee.
I can't say for sure, but I do know he said that he had a letter, a document of some type that said he was the grantor. I don't remember if, in fact, they said they were the grantee.
What was his name again?
He didn't say that he was calling from, I don't know, so it's Connecticut.
Connecticut?
Yeah.
A Christian? Was that a Tuesday call? Was it a...
No, it was on a Tuesday call.
Tuesday? Okay, so it would be... So maybe my
yeah, I think it was Tuesday because on Wednesday you read a lot about the duties of the benefit or trustee and beneficiary. And then the second question I have is I know you're having some growth pains and the website is being redone. But do you have a way? Do you need some support at this time?
My problem is that what they're doing is they're basically switching on the website. They sent me up for stuff that was unlimited and supposed to be for a set price, and now we call them that they're trying to switch these to a more advanced or more costly service to pay for advanced for users. And that wasn't the deal to begin with when we went into this.
Okay.
So, all the downloads would come off of there if everybody would say we set it up for payment. I would have done that right off the bat. It's like a big switch program that that was the problem.
Okay.
And we will probably revamp the website to pay for the downloads to the PayPal button. If I'd have known that going in there, then we would have done that right off the bat.
Right, because now it takes more time to set that up.
Yeah. Right. So.
Okay, well,
Can we pitch in?
Yeah, I suppose we could, because I was playing on the way which way to go for we're going to make it more private and requested, or we're going to make it public and do the downloads.
Or you could mix and match. You could have different levels.
Yeah.
You should definitely make it private.
What was that?
You should definitely make it private.
Oh. Yeah. Because these are issues that we weren't planning on doing right away, but then now we're kind of forced into it. So that's the thing.
Christian, how do we get an address to send the money over?
I have to set up something there too. So I'm not telling you take donations or a payment.
How about we just send money orders or whatever?
Yeah, that'll be more effective if you send money orders. Money orders are, liquid cash. Household money orders.
Well, I'll work on it this week and send it at the hopefully the post office box or something.
Yes, give it Dropbox.
Yeah. What about Desert Owl? Did he buy you?
Yes, but I like to keep everything in-house under my own control.
Oh yeah, sure. Sorry. Okay.
Okay, so I couldn't get on Saturday to ask your question. Are we finished with the financial stuff now? Can I report
Yeah.
Okay. So I had two minor questions. it's called that once we set up we terminate the trust and everything in order, we're going to take I guess the asset interest to the public side, vis-a-vis an LLC. And of course, just why these LLC will be using trust.
Yeah, you could, but on the private, or excuse me, from the public side, it might be more like for an LLC.
I asked the question because in Rice's book, he claims that that the trust is as stronger than a state incorporated entity.
If I'm not really trying to create a private entity on the public side, I really want a public entity that they can recognize and operate through it. A statutory LLC or a statutory something like that would fit right in.
Okay, so what you're saying is you just want it to look all public.
Yes, because we're going to interface with the public through this LLC. LLC is in the public.
I get
you. Something public that they'll recognize. That would be an LLC or corporation or maybe even statutory trust.
Okay, so we could still use a trust.
Another entity, say like another LLC that does trust on. But it's a statutory trust, what's the point?
All right, that's why I was asking. If it's a statutory trust, it's still recognized by the public, right?
Yeah, but then there's really no that much protection. It's covered by statute. I really don't want a trust that's covered by statute. I want a private trust, and I already got one of those on private anyway. So what I need is to interface into the public, and that comes back down to the public LLC or the public corporation.
Okay. So okay. And then the other thing is, I'm reading that the treatises on mortgages and trust deeds, the one that you have.
Uh-huh.
And maybe I'm not reading it correctly, but it seems that I get that there's a distinction between common law and the equity, and to see that the writer leans more towards the equity, being that the common law was unforgiving. At the same time, I've heard conversations, calls about, the value of the common law, but I'm a little confused because if it's unforgiving, then why are we seeking to have that?
Why are we seeking to have common law?
Yeah, because it seems like the equity, without equity, common law would be overbearing.
Yeah, common law does not have the power to prevent something from happening. That's why they had to come up with equity. Because equity was the power to prevent something. And equity was the power to compel you to do something that you breached them. So it's actually like the common law has no enforcement. It's like deems you guilty or not guilty. But then the power to compel you to do something came through equity.
So then why are we waving the flag around common law?
Well, I'm not waving the flag around common law. I'm waving the flag around equity.
Right, okay. Okay. I guess I misunderstood.
Equity is where trust is. Equity is trust.
Right. That's right. Okay. And I think it's a very good, I like that treatise. It's very informative.
Because really I brought my law form to be dated 1976, so I want my law form to be the Bible. And I only need one commandment.
Right.
What you got with all your heart, soul, and mind. This new one stands as first, is love your enemy as yourself.
True that, right. And it also in that publication it says, in that book it says that mortgages are securities.
So it doesn't have to.
I'm sorry?
It says mortgages are securities in there, yeah?
Yes, because actually they make a distinction between the two types. One type is that the mortgage is security for, the debt. The land is pledged as a security, like a pawn. And right now, I heard you say it's 3 years you can redeem your property, after it's been foreclosed.
That's under common law?
Yes, it was under the equity common law scenario. Even back into the Roman days, they had a redemption period that was 2 years.
Well, see, now under this code, statutory law states, I know here in Florida, that until the time of the transfer of the title, then the equity of reduction period is cut off.
Oh, okay.
And some states have it different, like they may have 1 year designation after that, or 6 months. I've seen some places have 6 months to a year. But here in Florida, you got until the transfer of the title, and then cut off on the back of the redemption. But now that's statute code now. If we went into chambers and we could do an enforcement, come back under common law and claim that 3-year redemption period.
But I think I think it's just a very interesting read, and it includes a lot of stuff that we're talking about, and a lot of the conversations people bring up about mortgages. They may want to go in and check a few pages out.
Yeah, because I keep saying that really everything that's still functioning today in that realm is really being run by that old practical treatise on the law of trust.
Yes.
With new names on it.
That
God must deviate and form a parallel path under debt of creditors.
Right. It's under the
law system under trust.
It's the Roman civil law.
Yeah, well, yes, under admiralty, say, for that debtor creditor path, yes, Roman civil law. But I'm saying that the real path that they never left, they got us to deviate from that path. That real path is still, always has been, that feudal law system set up from the beginning of 1367, where the trusts were feudal trusts.
Right.
They're still operating that way today, except with new updated terms, or labels for the terms. They're still using the same definitions as feudal. They don't call it fiat use.
Right. Well, I agree with you, Tony. We have to keep our eyes.
We're going to agree they caused us to do a divergence off of that same path, and we formed a parallel path, 33 on, under this debtor creditor admiralty statute code, Roman civil law, fiction, all fiction.
Right. Well, just some comments I had about those issues. Another thing. Can we send in a promissory note, the amount of claim, market non-negotiable, as trust rests, giving it to the trustee to make the payment?
Yeah, market negotiable. And never try to negotiate it.
No, right. That's what I'm saying. That would put you in a difficult situation. But if it's a promissory note, non-negotiable, how does that work? I mean, the trustee guys would say, well, I'm not going to take this. How does that work?
Well, you have a right to disclaim, but then resulting trust form, that's pointed as a trustee. Then you have to go to court. Tell the judge that you've got to appoint a new trustee.
Well, what I mean, let's say that he's already accepted trusteeship, and we have
what he's bound by duty and by an obligation to the grantor to complete the transaction according to his will and his intent.
So then at that point, if he failed to accept or take the non-negotiable promissory note as payment, he would be allowed. Okay. And that would be a cause of action. That would be a cause of action to go to court.
Yeah, yeah.
Okay. I'm good. Thank you.
Just make sure you got the records to prove the trust after claiming the trust.
all the records for the, especially for the non-negotiable issue. Prove the trust, claim the trust, prove the trust, and two other ones, whatever it is.
Disperse the funds.
You have to prove the trust, express the trust, claim the trust, express the trust, prove the trust.
And then disperse the trust.
Disperse the res or disperse so terminate the trust. It depends what you want to do, right?
If I'm paying the trust, that disperse the funds.
Right. Yeah. Sometimes you don't want to terminate.
Right. Think of trust res, if you only have one trust res made in there, if you transfer that, you actually terminate the trust because that is the title. The trust is the res.
Oh, right, that's true.
So if there is no second deposit, there's nothing in the trust to keep the trust open.
Right.
If you prove that with trust res, then entitled to that, then you merge and terminate the trust.
Right.
That could be all one fell swoop. So, but if you had two deposits, and you could merge the titles on the one deposit, the other deposit is still in the trust still stays open. Terminated then. Whether it's through a payment with trust res, by merging the titles.
Right. Good insight. Thank you.
Tristan? Guess who's this?
This is Floyd.
Hey, Floyd, how are you doing?
Oh, fine. Thank you.
I don't want to be beating a dead horse here, but I'm still not quite clear on the what we're going to be doing as far as your website because are we going to get the updates on like for example last Saturday and last Monday the website that you have up right now that's not on there and
Right.
I'll check. Well, you have the talk. Well, the radio program that you had went back to November when you first started talking MTT, and you had A and B on there as far as the trust information, and then you have some others on there, but the latest updates you don't have on there. Yeah, I'm looking last Saturdays and Mondays and tonight will be missing. Right. And I was wondering, are those going to be included? Not going to be included until you get your websites straightened out, or decide what you're going to do. Probably so. Yeah, because I'm not that far from getting it straightened out. I'll put it that way. Okay. And then you said once you get it straightened out, that's when a whole new website someplace else. That's what I'll do. And then once you get that straightened out, is that when you're going to start your workshop? Well, for me to handle all this work on my plate now, kind of supposed to be a little bit more stuff. Yeah, I understand that, but I was just kind of wondering. I know that. Well, I was thinking today that if you charge so much a month from each one of us that's interested in listening to you, that would pay for your website, and then we would be paying the $300 for the workshop. That would be worth it to us. To have that information available to us. I know that because that was getting out to a lot of people. Because in order for it to choke the server down, that was a lot of downloads. I know that the figures are, and if I was to tell you, you'd be astounded really. You have no idea how much that stuff is being downloaded. now I'm not, I can get beat off site place else and pull this one down and forget about it. Yeah. What would be a domain name? Or another thing, they lock up the domain name for your, because now they got you between a rock on hard spot for 2 months. They won't release it for 2 months.
Christian.
And anyway, as quick as possible, I'm working on trying to get that resolved so we can get it back up and going.
Would it be also, if I ask Carlos what his email is again? I got cut off just as he was giving it to me.
Sure. Do something right. Carlos, you on?
Christian.
Yes, is Carlos in the background there listening? Could he come back on and give his address again?
I just came on.
Yeah.
Who's?
Is this Carlos?
Yeah, Carlos. I got cut off. You were giving me your address.
Okay, I'm coming. Real quick. It's Prosper. Number 4, LSPSA.hotmail.
Okay, at Hotmail. Okay, thank you.
Thank you.
All right, Christian.
Okay, thanks. Male's had a question. State your name, where you're from.
Christian.
Yeah.
Oh, can you hear me?
Pardon?
Can you hear me?
I can't quite understand. What did you say again?
Christian, can you hear me?
Oh, yes, I can hear you now.
It's Paul from Australia.
All right.
I've got a question. It begs the question what you were saying before. You've got so many people on your website. How can you do a workshop with so many people?
Well, we can't because the workshop's limited to about, I think, 150 max. We'd have to do multiple workshops.
Oh. So how do you split 150?
In a webinar style, computer-based access into a meeting room.
Yeah, but how do you select the first 150 people?
More or less, basically, who signed up first.
Oh, okay. Okay. Well, that's the question. Thanks very much.
Yes, if you haven't already, now for a registration application.
I did that about 3 months ago. I think I was number 3 on the site. I think you got a little counter down the bottom. I was number 3. I remember that now it's up to 20,000 or something the last I saw. So I did put in an application, but I said to him, asking for that.
I was Nathan was the thrown an email down. I've got it all.
Okay, great. Thanks very much.
Hey, Christian.
Yes, is it?
Christian, George in North Carolina. I went to send you a registration at MTT registration, and I got back a message that said your mailbox is full.
Okay.
I guess that's a pretty good success, huh?
Yeah, because that's it might be through the website, though, really.
Yeah. I got another question for you. If we're going to get started, I've listened to a bunch of hours of some of your recordings, and I was one of the people that downloaded all of the recordings that were available for my iTunes, and I'm gradually going through them. But I've never heard you say anything. It may be that I just may not have been able to listen to it yet, but I haven't heard you say what the first step is. So if we're going to use the UCC 1 and 3 to name the trust and then express the trust, what should be the first document or first title that we go after? Is it the birth certificate?
Well, I would say that the main thing is the real problem, and we need to go and attack the main root, which is, the dedicate trust, the birth certificate, form-sided trust, take control of the account, make claims in trust, so that you can either decide whether you're going to terminate it or whether you're going to just claim it.
And how would you go about doing that? I mean, I've got a certified copy of my birth certificate. Do I send that to myself in a registered mailing and then use the registered mailing number?
Well, actually, your birth certificate is, but what's the certificate certifying? Anybody make a stab at that?
It's a receipt. It's a receipt fee payment.
Yeah.
Payment receipt. Isn't it certifying the statement of birth, which is the record of an event?
We're talking about special deposits. We're talking about trust res, and that birth certificate is a receipt of their acceptance of your special deposit.
Yeah. Trust res.
Your mother deposited child into a trust, and they gave her a receipt back. The birth certificate was a receipt of a trust deposit, which was a special deposit, which was the record of the trust res. That was the formation of trust. That was never expressed.
Christian, pushing up a little bit. You're getting spotty with your comments and whatnot.
Let's if anybody's not talking, press star 5 to get out. So again, that receipt of the child being put into the special deposit, and after the formation of trust, that birth certificate was the record of that trust formation. So the trust res is the birth certificate, and that's in error form, really, until you endorse it. If you endorse it just like they endorse the note to the bank without recourse, you can make it in blank and use it as a deposit as a payment for any kind of a case or bill.
But do you actually put a limitations on the amount if it's for a set price?
Well, here again, trust res is collateral or chattel, and it has no set known value of it because it's a thing. So we're just taking one piece of paper, which is a thing, and using this other thing to form the counterbalance to it for the two titles and merging them, and the merging of those two things has nothing to do with value.
In other words, what you're saying is one of these mortgage companies receives a birth certificate endorsed by you. They can't take that and fractalize it and take all the $6.5 billion out of that account.
What we do, they put it into trust, and then they write the bond against that. You see that those proceeds are generated off all of the signatures. See, we're brainwashed into this debt of creditors thing to thinking that we have some kind of value. No, it's not value. It's a thing. And that's under trust. Value is under debt of creditors. So if we stop thinking debt of creditor, we stop thinking value and start thinking title. Start thinking get away from value thinking and start thinking just cattle. Thing, a red. like a one for one, in kind for in kind.
So what is it specifically that we're going to put on the UCC1 then? Is it a description of the birth certificate?
No, we just put on the UCC1 a specific number identifying the res.
I'm working on that currently, Samuel Ray in California. Question is, in the place of a secured party, that would be the grantor, that is your mother. In the other thing, we went through the U.S. to do the state of Florida, is the creditors and the debtor column, and then the U.S. Department of Commerce.
You're talking about the grantor, you're correctly identifying the grantor being the mother.
Yes. So also we have to make it a non-UCC filing, and I think I'll put a line up there. The grantor is equal to the secured party, and the trustee is then the debtor column for clarification. Then we are down in the district. Could we just put the Florida in the top box, the one who she contracted with, and then the U.S. Department of Commerce as an additional trustee? You could. Yeah. Now down at the expiration box, I'll put in here title and my name, and then put in here a 1953 Express Foreign Service Trust, non pro tonque. And then I put a line for parties, grantor, trustee, beneficiary. And then I go to next line is trust res, trust indenture from with unrestricted signature, hazard with the trustees on the date. And then under the second line of that, gross deposit receipt certificate of live goods, number such and such, held by grantor. The receipt. And under intent, following your layout, the trustee is to perform equitable duties, hold and improve trust res with all proceeds for use of the beneficiary as the intent. Purpose to fictionally operate in commerce in the limits of liability. I'm going to tell you on that one.
Let's go back to the res. Did you specify to be an in-kind deposit or segregated deposit?
No, I haven't said that yet.
Now, are you mentioning anything about all proceeds therefrom?
I believe so. Yes. And the beneficiary upon next line is under intent. The beneficiary upon attaining the age of majority may re-express this trust.
Yeah, basically you can make anything you want.
And then, purpose to fictionally operate in commerce in limited liability. Is there another purpose to this trust?
I think the private trust would be to operate in the public under fiction liability. I would think that's what would use the LLC for.
Okay. You said that we should state the parties, the roles, the intent, and purpose. Under purpose of a birth certificate trust.
Right. As long as you got the elements of the section.
And I added one more line, law form, America 1776, inequity.
Correct.
Does that more or less what we need to do?
I would say that's pretty good, yeah.
Okay. I just listened to a tape to try to get all the elements in there.
Yeah, for the other fellow that's on for you there, I didn't know if he was done with his questions.
Well, that's real helpful. It's just there's a lot of information that you gotta assimilate. And
based off that 127 call, January 27th,
right?
That call there listed as
I got a transcription of, I believe it was the 126 call. It was pretty good. I'm not sure who put that together, but somebody posted it on, I believe it was the Creditors and Commerce email group.
Yeah, that was the Monday, the 126, and I think the Tuesday was the 27.
Okay, I'll go review that one. Thank you. I'm done.
Okay. Well, the next follow-on question is we went to do a system on the UCC1. Who would be the trustee on that? Would that be the Social Security Administration?
The trustee could be anybody you really want, but I think the trustee is really their functioning and would be just the SF administration, yeah. If you're the grant, then you get the right to express who and what, where you're setting the law of the state.
I was thinking of throwing out the UCC1 on that. What the elements we want to put all the elements back in there. And what do we do to their trust once they become the age of majority? So you said that's like a remainder trust. How do we address that? Does Social Security follow on?
Well, after we made the payments and paid all the debt associated with the trust, then whatever remainder is going to be spilling over into the new private trust that we're going to be forming. I'm going to terminate that original one.
Yeah. I'm just saying, how do we
goes over into this new trust that we're going to have them form. That will cross over into the public again from the private, which is LLC.
My question is really quite simple, and that is I think it is, on the UCC1 and expressing the Social Security trust. What the elements we need on that? The same basic four elements, right?
Yes, same thing.
Okay, any special language? I don't understand what are those two, the birth certificate and the Social Security. If they're related, they just simply treat them as trust and treat them as accordingly.
Well, I think there are spillover trusts inside us into the Social Security. They spill over to Social Security.
I think it says Social Security, substitute trust.
Yes, the dedicated trust, yes, the Social Security.
Yeah.
One side is the birth certificate. One side is the
So I guess what I said is the Social Security substitute trust. Is that just a good extension for the certificate? Or are there two different issues?
If they're tied in together, if one gets spilled over at the other one, or, I'm going to terminate both of them.
Okay, I was wondering how those deal. You have to have one to get the other. You have to have the first certificate.
The first certificate, yes, it's the Social Security.
So they're tied together somehow.
Well, there would be no trust unless there was a deposit made, and that was the birth certificate. That was the receipt of the deposit. That formed the trust. Anytime that the trust res, the baby, was put into trust to the trustee, once it was delivered, they gave you a thank you receipt, a birth certificate. That's a record or receipt of your deposit. And that's when the trust was transferred to the trustee, the trust res, and that's when the trust was formed.
And that's our record of the trust formation.
But there are two things. And then there's a birth certificate. Which one are you referring to?
Well, the eviction one, the birth certificate is the receipt.
Which is technically a stock certificate.
Yeah. So they're treating it as a stock certificate, but not under trust, under debtor creditor. Because it's talking about corporations and stocks and stuff, that's all Well, I think they're using chattel both ways. One of those portals.
Because I've read somewhere that the birth certificate is actually under livestock.
Could be, yes, that's chattel paper, yes, under code of UCC. Then again, UCC is statutes and codes and treasury. It's public.
Okay. So the one that
You can get an out of time.
okay, so you're not referring.
No, they're not referring. The notice of the filing of the thank you receipt from the deposit made by the special deposit formation of the trust.
Which is totally separate from the live certificate of birth that basically recognizes that a live birth actually occurred. That's different.
Yes, right. That's on the solely on the private side. That one.
Okay. All right. That's what I thought. All right. Very good.
So you got a balance. You got a live birth certificate on the private, and you got a birth certificate on the public, and they're the two titles. First, the two titles. A live birth certified copy is the res for the birth. I would back off catch that. That's the one with the banknote paper. That is the one we get afterwards, which is the receipt for the account. Yes, but if you look at all the trusts are being formed, do an example of say the one in the county. Somebody composite a perfect title that was split from the trust into two titles, and they recorded it in the county, and this trust is now formed with the two titles. But every time you merge the two titles that were split, they come back to the perfect title again. So before 1933, they had a perfect. The first title, the birth certificate, say, somebody in the back, please do that. There's a lady speaking. I can hear you fine. The life title, and we have a fiction birth title. When we merge those two titles, that trust is going to terminate. Wow. We can order out many copies of the death note title. Is there any purpose in that? That represents the residence in there. So theoretically, we could take one of those, sign it over against the court debt or something else, and still get more of them. Yes, look up EXE in your state. Yeah, so that what it is? Connect two words, EXE. NE, first word, second word, XE. EXE. Okay? How do you think? So you have to be fun and confident about it. Yeah, but the registrar is where it all started. The hardest part of the right. The income of other contractors with originally, that would be the state. Yes. Then who's the state? Yeah, right. Agents for the federal. Wow, that just opens up a whole area for me. Now, most people aren't thinking with trust eyes about this certificate, what these certificates are, and what is the actual trust res, and of that kind of certificate. birth certificate that is actually a receipt of the trust res that was deposited in trust, and that's a record of the trust deposit under special deposit, and that was a record of the formation of the trust.
So when we get the banknote version of it, do we want to put that on a UCC as your trust property? Trust res?
Yeah, because you want to merge the two titles. That would be the fiction debt title. That would be the birth certificate, and then it would be the private asset title, which would be the live birth certificate.
Maybe it's not a good idea to merge them until we're ready.
Not unless you're ready to terminate that trust and operate in commerce with no vehicle to interface into commerce with.
That's here.
Okay. That's your LLC or something like corporation. Okay. EXE is in Florida statute here. It's 68.02. Second word, EXEAT. And I'm looking under point 4. We're talking about the surrender of defendant by surety. Now think birth certificate here. Says the surety of the defendant has the right personally or by attorney at any time for the bond, and that's right there, the trust, is forfeited or take the body of the principal and what is principal and trust red term, and surrender him or her in open court or deliver him and her to the executive office of the court, the sheriff, who shall detain the principal as in the cases of the surrender of the principal by special bail, special deposit. At any time of delivery to the officer, the surety shall take a receipt for the body and file it with the clerk. If done before the bond is forfeited, the surrender or the delivery discharges the surety from his or her undertaking.
Hey, Christian, can you repeat the name of that? Was it an N or an M?
N is Nancy.
Yeah.
N-E, and then second word, E-X-E-A-T.
E-A-T. Okay. Thank you.
So principal is really corpus or res. That's the property of the trust. Before the bond is forfeited, you take the body of the principal, that's the corpus or the res property, and surrender him or her in open court or deliver him to the executive officer of the court, the sheriff, who shall detain the principal in its res as in case of the surrender of the principal by special bail, special deposit. And at the time of the delivery, remember delivery is one of the methods of formation of a trust. At the time of the delivery to the officer, the surety shall take a receipt. What kind of receipt? A birth certificate. For the body and file it with the clerk. And if done before the bond is forfeited, the surrender or the delivery discharges the surety from his or her undertaking. Or he merged the titles, made a payment, and it's done. But the trouble is, you never expressed it to be a trust. You couldn't trustee payment because you didn't prove the trust, and you didn't identify yourself to be the trustee on a proven trust, so therefore they can't take your trustee payment. I don't care how much it is.
And use that as your trust res? Is that what you're saying?
Yes, the trust receipt. Your birth certificate.
Oh, birth certificate.
Shall take a birth certificate for the body. Shall take a birth certificate for the body. birth certificate, that delivery discharges the surety from his or her undertaking or the obligation.
Listen, Florida statute, did you mention 62.02 or 60.02?
68.02.
68. Okay, thank you much.
This trust now, you got to claim trust through trust first, and you got to identify yourself as being a trustee in order to make a payment. If you come in there and have a birth certificate, it ain't going to work because you didn't express trust. You didn't claim trust, you didn't prove trust, you didn't prove that you were a trustee, the one who had the ability to make the payment.
So in your claim, you just tell the judge that this is a trust, and I'm going to go ahead and execute my rights under trust.
Yeah, but that's paying as an NOI. Now, where's your SOI to prove that you got trust? I could make the claim if the judge did it, be fine. But if he would question and say there is no trust here, now I've got the barn door open to drive a Mack truck through with my proof. Because that's an invitation to prove the trust.
You're UCC 1, that's one of the elements.
Yes, present the records and in chambers so you don't waive it in the public.
When we turn in the birth certificate, do we sign the back of it non-negotiable?
No, without recourse, in blank, and sign it, surrendered, just like we do on the notes on the mortgage.
So does that work? Oh, I'm sorry. Go ahead.
Look how the bank signs.
Question: If you've got a UCC 1 with a default and a judgment under administrative default process, should that be used also in a trust res?
Yes, I could do that trust right there.
I like that. Okay.
If I went into, I think, a traffic court for a copy of the birth certificate, I went over to the bailiff and said, I drafted it, sent it in. I'm not sure if it will go very easy here.
Yeah, that could work, and then sometimes most of the time it didn't work after that because they caught on the fact that you didn't express it to be a trust, and therefore they can afford your payment.
So a copy of the UCC 1 filing expresses the trust. So the companion with
yeah, that's the records to prove trust.
Hey, Kristen, it's George again. If your mother is the grantor of the original trust for the birth certificate, how do you come in and substitute yourself as grantor in that situation?
Well, that's a good question. How would you? So she's grantor, how can I express to be grantor? Well, isn't everything a right or a title or an interest? Entry, transfer, title. You can't be a co-grantor. Go to my mother and say, why don't you just sign over all your rights to this trust to me? I'll write that. Dad, I do a tacit agreement with her, and she defaults by not answering. But she's dead. And can I transfer all the rights from the trust to me? And then who's the grantor?
You are. I am.
Yeah.
What about just this expression?
But if you could get it by inheritance.
If she's dead, wouldn't she be a permanent resident then?
Sure. No, we're talking about the real person, the real people.
But isn't that what a permanent resident is? Someone who's dead in the ground, they're not going anywhere.
Yeah, so a resident would be, but yeah, I'm not a resident. I'm domiciled.
I know. I'm just making a joke.
Okay.
So if my mom is still living, what I do is I just draw up a short transfer document and have her sign it? It doesn't need to be notarized, does it?
You transfer, it doesn't need to be notarized in your statutory realm because when they transfer the note one to the other, it does not have to be notarized.
Okay.
You generally get your Social Security number prior to being the age of majority, which used to be 21. So that's as a minor, you can put out the Social Security contract.
Yeah, when you used to be up to being trustee and came to majority age, you were supposed to take it over as trustee, and you never did. You never signed it to be a trust, never expressed the trust, never approved the trust, and then you will operate, you sign everything with a non-restricted signature. Your signature, if you're not expressing it, your signature, as signing as trustee. So then you come and you try to make a payment, they won't allow you to make a payment under trustee, they want you to make a payment under federal reserve note. Can't make any private credit payments. You're not expressing the trust. Yeah. Got no right to make a claim against the private credit that you could issue as trustee. You haven't proved he's your trustee.
Yeah. So, but Christian, couldn't you also just express trust with respect to whether or not, your mother is the grantor? You can establish trust about parties, right?
Yes, if I want to be trustee or remain trustee and operate as trust. All I have to do is prove the trust form.
Right, so I'm just saying, if mother's gone, you can write the letters, she's not going to respond, and that's proof that she belongs to. You express the trust.
Yeah, but I would like to transfer the title, grant, or position or office to me. That way, if anything goes down, I can come back in under a misconstruement and straighten things out. That's not grantor.
But wouldn't you be speak grantor if so facto the fact that you're expressing the trust?
Say that again?
If I express the trust, are I not the grantor automatically?
You have to express that trust.
But I'm saying, in this situation we're talking about, if I express the trust, the problem is about the grantor. My mother is not here anymore. Now I express the trust.
No, the trust has already been expressed. You just need to prove that there is a trust.
Well, that's why I have to move the title. Okay.
Yeah.
And how was it expressed?
Your mother deposited the
right, I got it. Okay.
Well, as beneficiary, her transferring that her interest to you would be a natural occurrence.
Yes.
So that's what you guys would by area. But I would like records to prove that. So. Well, record like that, another UCC one, a declaration declaring that to be the case. Yes, I would have to prove transfer of the title grantor to my collateral. So I can think.
Could that be on an amendment? An amendment?
You can have multiple ones for different purposes.
If there's anybody not talking, could they please read out so just want to echo and feedback?
Press star 5. I gotta see. Okay, another question.
Yeah, I have a question. Yes, this is Stu. Would you? Can you hear me okay?
It's kind of breaking up a little bit. Go ahead.
A little bit? Well, there's somebody pressing the keypads on their phone. I have a question. I was in a situation where we have a 4-month-old child
and myself and my wife, and we got a piece of paper from the hospital that's just a piece of paper. Have a receipt of the birth of the child, and we haven't filed any paperwork for a birth certificate with the local registration office. And listening to your prior audio, although I haven't been able to study all the material, it's pretty obvious that it's some kind of trust document. We're the only party to sign the bottom of the document. And I was wondering if you had any recommendations or tips. My knowledge level is very limited at this point. Like I said, I've only been able to listen to a few of your calls so far, but I've learned a lot. Appreciate it.
So you didn't sign a birth certificate document or anything?
Yeah, the hospital never required us to sign any state paperwork. That's all done separately. We actually go to the state office or mail it in the documents for the registration of the birth.
Do that?
But we haven't done that. The child is now 4 months old. It's not done.
Okay, right.
Well, let's see. The hospital gave us the form that we would normally hand into the state offices. We didn't actually receive it from the state. We just got a file copy with the hospital. We still have the form, and the form's not filled out.
You didn't send them anything, you didn't fill them out, you sent them in, right?
Right. The state's received nothing. All we have is like the
What you're going to understand is that by tacit agreement, by you not responding, they are going to fill them out for you and create a birth certificate for you. If rebutted. Did you see my point? What is happening?
I see your point, but the still paperwork's been sent to the state office. The hospital
They don't get this paperwork for the birth do something, and when you don't respond to what they sent to you, they're going to, by your tacit agreement, you're agreeing to everything on the form, and they will fill the form out for you.
No, they won't because of the privacy laws. I don't think that's going to happen. The hospital just gave us the receipt. The way things, I'm over on Germany, and this is a private hospital that's outside of the city where we're staying. And I know that in Canadian or U.S. jurisdiction, the hospital just fills stuff out for you and sends it in without the parents' approval or consent. But here, the parents have to make they actually have to go register the child, and I think it has something to do with the era of National Socialism and the reaction to that.
Better, I would give it a rebuttal with. I would tell them, I do not consent. I do not agree, with anything being done with these forms without my consent.
Right. I totally agree with you. Totally agree with you.
And then some record that you sent them that so you could prove it. You have to remember, then this child might not have any commercial viability and might not have any ability to operate in commerce when they turn 18.
Well, isn't that what these rich folks do? Is they have some kind of LLC as their interface to commerce?
Yeah, they operate on both sides and they have both control on both sides of the ledger. We need to operate on both sides, really. I'm not objecting to that birth certificate being created. I'm going to go with
I'm not either. I'm just trying to make sure that Pam
actually, it's my alter ego. It's my other half, and I need that other half. I can't make a perfect title without it. I really, if we draw it back down to where, you can't have anything, nothing one store-bought hammer, not one screw, not one thing thrown in any store. You can't have a car, not one piece of clothing that you wear. In yourself, while operating private.
Is that for purposes of demonstration? Because I'm not the one that said that I have an objection. Somebody else butted in, said something.
Yes, but I'm trying to point out, fully private, it can't be done because it's going to be done very, very hard. You really need that public interface to get those colorful titles so that you can have possession of those things that you're used to having on a daily basis.
All we're trying to do right now is just try to get information so that when we put the form in with the registration office, there's a lot of background noise. If you mute on your phone, press *5 apparently, that will mute out. Are you still there? Okay, so we just want to make sure that when we, for instance, when we sign the document that we signed by grantor to establish that we're creating this trust for our son.
Yes, you're the one that's going to have to decide, which way to handle it. But, I would go one step further on, just like I said, I would make a rebuttal that they couldn't use those documentations without my authority and create some fiction entity if I didn't want them. I mean, you've got that right to choose whichever way you want to go. But I'm
just trying to get information
about the operating with, because I think we need those realms.
Well, I don't disagree with you. I just want to make sure that when myself and my wife go to fill this documentation out, that it's because of course what they give us, what they give the parents rather, what they give the public is a form that has all sorts of implied consent, meaning stuff with it, and entanglement. Right. And so since it's a form that only we sign, to us it seems like we can structure it pretty much however we want as long as they can still process it.
Yeah, but the trouble is you're a holder of the title. You didn't write across it where, I do not accept and turn it back to them, at a 45-degree angle. So you're holding the document, you're a holder. And anyone who's holder of anything has got liability. If you didn't want those documents, why didn't you return them, refuse for cause? Did you return the document?
Well, there's two documents. There's the one document, which is the official state form, and the other one looks like it was just done on a word processor and has a stamp and a sign across it from the lady that was present at the birth, just to show that there was some official of the hospital present at the birth with the weight of the child.
It could be a thank you receipt for your deposit.
Could be, yeah. Yeah. Right. It's handwritten on their duplicate. It's not like some kind of standard form or something.
Right. It always has to be, written out, man.
Yeah.
Well,
Christian, couldn't you just apply for a birth certificate and see if you get one?
If he wants to operate in the commerce later on.
No, just to find out if he has been certified and he doesn't know that. If you apply for a birth certificate and you don't get one, they haven't been informed on it.
That might be pretty good. But I would like to have some evidence, that I refused those and I had some kind of records created that, somewhere down in the future, I'd be able to prove that those documents that you gave me, I returned them and I don't have the liability associated with them. We don't want to create records to prove the fact, and really, they're creating records, but they're creating records with no, because we're not expressing ourselves. But we really don't know how to do government, we don't know how to do business, we don't know how to do trust.
Well, there's another way to do it, you guys.
get out or get in. The choice is up to him. So
He probably in a hospital, you're going to have to sign a contract for release of liability. They probably can use that. Or they also get the child usually a PK test and they make you sign that. So they've got your signature for however they want to construe it. So the other way to get out of it, to be able to play it either way down the line, is what I did is I went into the county recorder and I changed the name of my child because I never had given the child a name, I requested a search for the name of the child, and I got a receipt from the county that the name was not found in their records. And so I have that receipt that the child wasn't registered.
Interesting. Well, we didn't give a name. There's no name on the document either.
I didn't have a name either. They won't go by that. They'll take your signatures on the PK tab, your signature for release of liability from the doctor that you signed in on the hospital for. They'll take those documents and they probably make documents we don't even know about yet off those.
Oh, I'm sure they do stuff in the background. We don't know. But it all seemed on pretty up and up. I mean,
Did the baby get a PK test?
I don't think so, Jacob. I'll send you what we got, and you can take a look at it.
Well, that's where they prick the baby's heel with a needle to get them to draw a drop of blood to check to see if the next time the two of you get pregnant, if your blood is
this is an anthroposophic hospital. They didn't do any of that stuff. It's all like natural childbirth stuff. I mean, my wife picked it out. I wasn't even there for the childbirth. I waited for days. But anyway, no, I don't think they did that blood prick thing.
They had to have some kind of procedure. They had to make some kind of record.
Yeah. Oh, yeah. They made some kind of record. Absolutely.
So, but did you sign anything?
I didn't sign anything. And I'll check out what my wife did. I'll send you copies.
From the hospital, not sign anything?
Did you accept anything?
No, I'm sure we signed into she signed into the hospital.
Right.
I'm sure she did.
So that could be a way down.
Liability.
And did you accept anything?
Well, I mean, I don't know. We got services from the hospital. She stayed at the hospital. For child service.
Could just be a slow setup, that's all.
Yeah, I don't know.
I'll send you
liability. You probably have gone in there and indemnified the hospital right off the bat from your trust and held them.
Yeah, that was
any damages that would have been caused.
That would have been the form that was signed initially when she went into the hospital that said that, release of liability of some sort. Mm-hmm. Yeah, I fully understand that.
Christian, I've got a question.
Yeah, go ahead.
In Byron Bay, a friend of mine said had two babies but home births and they're not registered at all. But she wants to register them. How would you register them as grantor beneficiary then? They're young kids, two or 3 years of age. They haven't been registered. They were home births.
Thought about that.
That's why I'm interested in this subject because you were going to ask you.
I didn't think about that one,
That's kind of basically the same question I have, actually. If you could answer that question, that would probably answer a lot of my other questions.
Yeah, so now you've got the opportunity. What do? You haven't been registered. So therefore, she wants to do it because the father has taken the children away. And she wants to get control over the children through a trust. Because the father, very wealthy, has taken the children away and moved interstate, and she wants to get them back. So her idea was to get them registered in the trust.
As to whatever documentation you could use as we've been using all along, which would be their website. Now I got the opportunity to come in there and express it and sign by grantor. And I think much better position to express the trust because you sign by grantor
So you sign his grantor and keep the copies and send them, keep the original, send them copies.
Yeah, that's the rule of signatures, the rule of form. Sign restricted by grantor, and then keep the original. That's the rule of form.
Chris, you don't have this. If you can make it straight, we can do it.
They keep the original to give you copies. No, we reverse it. We keep the original, sign as grantor, and then give us.
And Christian, if they won't do that, do you have to make two originals?
You could give it like a high resolution copy and make it look almost. You could take a look at exactly like the original. The technology we got today.
You mean like a color copy?
Yeah, high resolution color copy. You can't tell the difference.
You still have the original.
When you say, I've listened to you about the law of forms. I understand more from Hamilton, Ontario. When you talk about the law of forms, what is that? Where can I reference that?
Well, that's the thing I coined on the show earlier last year, where I came up with the rule of signatures and the rule of form. And the rule I'm making is that you sign by a restricted signature all the time. And that restriction is by grantor or by trustee or by beneficiary, or however you want to sign. And the rule of forms is you keep the original and give right copy.
No, I like the idea. It made a lot of sense. I mean, if you can get it done, it makes a lot of sense. You can just work it to the, maybe like you got to know ahead of time, asking them for maybe two copies, because they can get a little weird when you try to
find trust right from the beginning, and they've accepted trust res, and the trust has been formed. And now we got a problem because you guys are in breach of trust.
How?
Come in with a breach of trust action and sue the pants off of them.
Christian, what if you're in a situation? What happens if you take the rule of signatures across the board on all kinds of different things that you would be signing, and you're in a situation where they're not going to let you have the original? If you
think about what we've talked about in the past in some of the other shows, and I know you've been in on them. What is the caveat for that?
The person who signs has the right to the original copy of their own signature, if I'm not mistaken.
Talk about the signature. They won't.
Is that right?
What is the workaround? What are we talking about all along?
Sign your name.
Right. What do you call that?
Oh, that's absolutely correct. ...
Oh, yeah. Okay.
An incomplete signature.
Yeah, ellipse. UCC complete signature.
That completes the rule of signature.
How do you express that rationale again? What do you say when it comes time to refer back to it? How do you say that was an expression of your? You can basically say whatever your intent was.
Yes, that dot, those three dots before my signature indicate that there's something missing. And my intent was what is missing is by grantor.
That's the key word.
By the grantor.
So the key word is your intent, of course.
Yes, that's right. Just intent.
Chris, can I ask? Go ahead. Well, Christian, so
Go ahead.
I want to ask you a question about thinking about question. I'm experimenting. I get it on the signature card without prejudice per full column and the signature for authentication. And we're starting to call it authentication now as opposed to signature. But he was saying after listening to you, he was saying, well, you go in there, you just pay $10 to get your picture taken, you fill out the application, and you get the signature card. He was saying, maybe go in, and when you pay the $10 and get your picture taken again, put grantor, full column, and the signature, and then on the signature card, because that's what they put on the card now. They put by by beneficiary Phil Collins signature. What do you think of that?
Yeah, any way that you can restrict the signature and express it as a trust.
So that makes sense on the application being grantor, and then on the actual driver's license, copy of the signature, and on the little card. That's how it works here. Actually, the base signature I put by beneficiary.
If they won't let you sign that way, you got a problem.
Oh no, she's pretty good about it. She's like, right, she doesn't put the without prejudice stuff. But if I could get away with it, without
you make it, you got to work out, you got to dot, you can add it.
Okay.
Or even if you put something through with dot, my signature, they might not even question that because they might do it so quick it does.
But in principle, just that they are actually pretty good because they look at the without prejudice stuff. But I mean, in terms of understanding, if I put grantor on the application and then beneficiary, that's the same if I just put grantor technically on the card. Does it matter? Understand it? Would there be some kind of grantor on the application and my grantor on the card? Well, yeah, I'm trying to understand. You know, that's what my friend was suggesting. Put grantor by grantor signature on the application, put by grantor on the card. I was just wondering whether I should just do some of this. Yeah, that's okay, cool.
And you got conflict. The IRS, where they got you down in 1044. Even put your name on your driver's license.
Well, they know they have a signature card. Right? So they sign the signature, and then they basically pay with that.
Why do you do that?
I'm missing it. Why do I sign the signature?
Yeah.
Because that's, I want to take control of it. Or,
you get your girl, that might sign twice.
Is that what
no, I
wait, I'm sure you lost. Okay, let me just lay this out as well. This is in Ontario. Let's say you lose your card and you got to go in and replace it. I notice what they do is you take another picture, and they always like to get a current picture. I noticed. It's all computerized now. The girl said it only costs $10. And I noticed they give you another application. So I thought, cool, because at least I'm writing a new contract, so I can correct any errors from the last one. And then they give you a little card, and you got to make a signature in the box. That gets photocopied, and it gets integrated into the card that they're going to mail you. See what I'm saying?
You only pay once, but then they use the signature twice.
Yeah, so I felt like an application, even though it's just a renewal, but at least I have to go to what is an application? I should have done something head office somewhere. And I said, okay. And I just figured the card must be different. So I'm thinking, well, maybe the card represents, I want to be sort of like, I guess, the beneficiary, but I don't have a complete full understanding of this. Dynamic things. I don't pretend to always be on top of it.
The application, and they're going to transfer the application on the card.
No, they make you sign the application, then they give you a separate card specifically putting onto the driver's license card that they're going to give you. It gets integrated with the photo. It's pretty much heavy with the photo.
You're going to sign that one by beneficiary then?
Yeah, does that make sense?
Yeah, you could do it that way, but then you're locked into that. You know, if you understand how to play beneficiary or how to act beneficiary.
So what would you do? What would you think would be the most flexible thing to do?
Well, see, if I sign just like grantor, then I don't have much more flexibility because I haven't specified the terms of the party bar.
Right. So just I can put technically on both on the application and on the current credit. If I could get away with it. Yeah. Okay.
But do you have to sign your name?
I imagine that they want the signature. Yeah, they're asking for this. I'm trying to make it so that I kind of integrate it. I know the people there are really fun. In terms of I kind of chat about the bed stuff, and she knew about how everything registered is outside of our, like we don't own it. So I thought that was kind of cool. And so I said, oh well, I kind of said I'm going to do this thing. And she said, well, I'll let you do it. I don't know if it's going to go through, but it seems to go through. And we get the card. So I do got a card right now that says on the card.
But why do you even use your name?
Well, because I thought it was okay because I'm like Christian says, I'm controlling it. I'm restricting it.
Why do you even sign your name? Why? I have driver's license. My name is not it. Not signed on it.
Oh, okay. Well,
so why would I want to give them? Why would I want to give them my signature or my name?
Yeah. Well, I thought. I am putting without prejudice per full column and then my squiggly.
Yeah, did you put any kind of mark on that at all, Joseph?
Yeah, I did.
Okay, that was your signature.
Yeah. Oh, I what's on there? It just says, white reserved right on the line. That's what I should use that too. I know you. I just sign all rights reserved right on the line. They think it's your name. They don't look at it. There's something else. And when the cop looks at it, he doesn't look at it either. At least you have a card, so the card you can carry with that. Won't wig out on you. But maybe they don't have your name. You're not supposed to swear. Swearing is when you sign your name.
Even in our speaking text?
Absolutely.
You can't swear. It's protected under the First Amendment. Freedom of speech. Well, we're going to make it clear. We're going to get platform to get public.
And that's natural.
When you sign without prejudice, you're putting yourself in the private, are you not?
No, you're putting yourself under UCC.
Well, I never can't use that against you in court.
Well, I think it's easier. Statutory. And that's still
Can I get in a question?
Yeah, go ahead. Yeah, go ahead.
I'm just trying to know why your website's down.
We jammed it up, checked it up, and the downloads it.
Christian, here's another application. I want to share this experience that some of my friends have been having. We're having a heyday with these signatures. That's how I kind of got hooked on to what you were talking about. We've been kind of experimenting mostly before we got on your stuff without prejudice. So that's what's all out there right now. I know a bunch of people that opened up a bunch of bank accounts. And I got one myself. I haven't done anything with it yet. But they would put on the signature card and application without prejudice per or by full column and the signature. One person said that they got ordered some checks and saw the charge for the checks to the account, and then they came off without them doing anything. And another guy wrote a check on it and didn't have any money in there, and tried to pay off some credit card stuff, and they called him up and they said, they put out, what do you call it, overdraft charge. They called him up and said, take that out, and they took it out, and they said, we didn't have any money in there. And he said, well, the accounts are paid anyways. Well, all I ever did to this guy was tell him that they lost the check. And so we're getting a lot of weird stuff going on, and I wonder if we're touching on something that has to do with this trust stuff. I believe so. Yeah. Okay. So that means that you control or own that account now. Nothing. Do anything.
It doesn't grant them the power, implied power of attorney when you sign without prejudice. Whether I express we get a credit relationship. And I'm putting up a record with them. What are they putting on the line again? They're putting without prejudice and what else?
Just by a per, because I've never been able to differentiate between or per. I always just say that basically means you're signing on behalf of. I don't know if that's right.
Yeah, that means that you're the agent. It implies that you're the agent.
Yeah. I
opened up a business banking account with a commercial bank here, and I didn't really know what format it was supposed to be in the box, but the lady allowed me to write, and then I wrote the all caps juristic person's name, and then I signed it underneath, and then I put down as authorized representative underneath that. She was fine with it as long as the signature part of it was not touching the other text. In other words, so the signature could be clearly seen for comparison with other signatures that I might do later, because that form to open the account, that signature needed to be identical to the signature that was on the passport for identification verification purposes.
That's funny how that works. Okay, they go out and understand it.
I'm sorry, say again.
How was your passport applied for? Was there any special forms or any restrictions on that?
No, the passport's just an ordinary passport, because this is something I got a couple of years ago, but all she was concerned about from the passport was that the actual, signature could change over time. She wanted to make sure, because I signed the passport some years ago, she wanted to make sure that the actual strokes of the pen, were, that there was that they looked similar, because she was telling me that if somebody comes in and they try to forge the signature of the account, that they will want to see the signature in the passport, not the signature that's on the form that opens up the bank account. I thought that was kind of strange, because I always thought that the banks would keep a separate signature card and use that to compare with the signature on new presentments to the bank. But she says actually what they do is they compare the signature on presentments and transaction stuff, authorization to the signature that's on the passport. And there are no restrictions on that passport, but it's the kind of thing where they sort of, at the embassy, they just gave me the passport, and then they didn't require me to sign it before they gave it to me or something. It's just a sheet of paper that has the normal verbiage and then a line. I could put restrictions for it.
Is there any place you're checking on a passport application that you're a United States citizen, or are you swearing on a penalty of perjury?
I'm sure back at the time I had checked that because I didn't know any better. But on the passport itself, it's interesting because it says it's for American national / citizen. It's like it doesn't really imply one or the other. And that verbiage that's for the signature line on that particular page of the passport. Now, there may be some encoding that's in the numbers or something at the bottom that I can't decipher. But on the human readable text, it's interesting. It doesn't imply that I'm a national or a citizen. It uses the term the national / citizen. Like it's kind of a universal verbiage. It may come down to how the passport is actually, or like you said, the application process may end up loading certain information in the finished passport when it comes out.
Then you can cross out the
Citizen and he's the American National. Well, they might come along after American National. And that gentleman is doing a birth certificate for his even while not claiming that on the public law 97 here in the Reagan administration is that the Bible was the word of God. Pursuant to that, you can claim yourself as a citizen of the kingdom of heaven pursuant to the book of Matthew and Luke. We tried to talk with Hillary Clinton accused of Epstein personality state that fact, and they would not even go near it. To be another public political election in the future, so it really comes back down to what was your intent. So any citizenship issue versus national citizenship issue, or America versus the United States, is really your personal choice, governed by what your intent was. And based on knowledge and understanding, with the sense of your knowledge. What is true? Back on trust.
I was going to ask you, this is a trust kind of question. You know Winston Shroud, right?
Yeah.
Okay. The DC bond process. I've been dying to ask you what your interpretation, because obviously, the idea just to cover it, so well, on some pages, trying to specific accepted for values and for money, and I'm learning from this treasury. I think you're saying charge the same to the social charge down account. I was just wondering what your interpretation of what's going on there from this trust view. What would be the interpretation from the trust view? What's going on there? Because I really love the way a lot of things. I understand something. I don't want to say the stuff. I think it's so cool. I just feel like everything I look at now, I see this trust thing. I don't know if it's my mind's gone or something.
If you listen to the 127 download, what's the date? The date, 1 January 27, 2010.
I run your stuff constantly, so I'm sure I have. I think I got past 27, yeah. Yeah, well, wait a minute. 127,
it was around that area in there. We were talking about very same stuff. What I'm suspecting is trust us so come to conclusion that everything we did in the treasury was somebody's older methods that was doing nothing more than creating bigger debt.
Yeah, I would say that.
That's the private side, and they would have autonomous. What they took the receipt of these or whatever they were applying it, and they always come to him and say there's non-existent accounts and stuff. I don't think we were ever successful in touching the private side. And all we were doing was just creating bigger debt, and they were loving us for it. So, none of this stuff that we did into the treasury, the old method was done under trust. It was put on the debt side, and but it's never specified on the private side, which because if you do some study on there, you're going to find that their actual private side of the treasury is with RIOs. The other side, the public side, is with bankers. With bankers, you can put all this stuff in it because you'll smell it all in the bank. And into the public debt side, we didn't do any of it through RIOs or what's her name, Escobar. We did nothing right. We did, number one, put it under trust deposit. We put it on the wrong side. We put it on the debt side. We didn't put it on the private side. And everything I can see we did was a wrong thinking.
The depositing to the U.S. Treasury is considered the public debt side.
Public debt side, yes.
What position is really not enough to do it?
So if you
on the private side.
And what's her position? What's your title? Is that she another? What's her?
Yes, Treasurer of the United States. Wagner is what? Secretary of
U.S. Secretary, and U.S. Treasury Secretary. I got the passport. It's a real short version at the top. Secretary of State of the United States of America, and those terms are with the first letter uppercase. Hereby request all whom it may concern to permit the citizen/national of the United States named herein to pass without delay or hindrance, and in case of need to give all lawful aid and protection.
Now, what color is it on the cover?
Oh, the cover of the passport is blue, typical dark blue color.
Does anybody out there have a green one?
Green passport?
A green passport.
I've read nationals, don't they?
Yes.
Nationals do, don't they?
I left
On Puerto Rico?
Yes, my understanding is green ones are the ones that are the real ones you want to check on if that comes up too much. Very few people have those.
I imagine.
There you get one.
I don't work on the Kingdom of Heaven. Applied under the state and got a state passport issued by the state. And it came up with a green cover. Wow. You run that, it comes up to not the same.
Because the states are republics, or each they're separate countries, right?
Yeah. States are separate.
So did it say something like the Republic of California or something instead of the United States of America?
Yeah.
Secretary of State of the Republic of California.
And who knows this guy that got that?
You know, the World Service issues non-government, non-commercial passports, right? Okay, also too, the United Nations are not just issuing passports now, but they're issuing green cards. I mean, visas.
Yeah, but Chris, they won't recognize the state. That's the key. You have a lot of micro nations out there that issue passports, like the Kong and a few other ones, but it's not recognized by the State Department. It's not so getting out. It's coming back in. That's going to have your problem.
Yeah, actually, that was brought up in one of the conversations with the Turtle Island, and they worked on it and clarified it. And yes, now it's acceptable. It is recognized, acknowledged, and once they start issuing passports, you can get a visa to travel anywhere and not have any problems at all, because the United Nations of Turtle Island has been recognized by the government under Executive Order 13175 that they have every right in the world to self-govern themselves. Asking for, if they do it within a boundary of uniform uniform to not be in conflict with the United States of America. That was under that executive order. They work hand in hand and breaks out that there is cooperation and domination from the United States of America.
How about those ambassador status with special immunity?
Yes, he has mentioned something to that. I don't know the details about that. It will not be a blanket. Everybody can have that. It will be significant, but he did mention that, though.
Yes, this one, this green passport, is the one that's community, and you have a special picture that you're especially recognized as an ambassador. You can be a formal passport and full declaration of that expenditure. That's it. Yes, we would like to make a transfer over to America. There were lots of red carpet and recognition of your expenditure, of your diplomatic status. This is an informal one, but it goes through the formalities. It's officially green passport.
Well, I don't know if you knew about it, but last week there was a news bulletin sent out by Washington, D.C. that they started arresting people that were using anything that resembled a government emblem on their ambassador diplomatic IDs. And yes, it came true that they were arresting people there across the United States based off of that. In fact, we had one of our local boys, which is the county ranger out here. They had the sheriff's department come over there and say, "You know what you're doing here, don't you?" And I told him, he called me up and I said, "Did you put anything on there that looks like it might be one of their seals?" He says, "Yeah." I says, "Oh, you better destroy everything you got. Destroy everything you got." Because they're coming down on this table with this ambassador diplomatic, and part of that article that was in that news flash, ambassadors are diplomats anyway.
Right.
They just deem it as some kind of foolishness that people are running around acting like something. I would be careful with you can't do like what Christians telling you. You might want to stay away from that kind of stuff.
Yeah, what about the civil privacy that was put out by the Treasury? Yeah, right. Or the stripes are vertical. So you see that on Coast Guard boats. The trouble is with those, they have the presidential seal, or the executive seal with the blue eagle behind it. That's the civil privacy that the blue star. It doesn't have a seal on it. No seal. Then it should be okay, I don't think. But the point is that you would really need to recognize it. Without that recognition, you don't have any authority.
Yeah, I should go back to that driver's license thing you guys were talking about. One of the things that we were dealing with was an international criminal charge against somebody that was from a different country. What they did, it was kind of interesting in my time. You look at there, they don't care if you sign anything or not. They've got your number somewhere up around, I guess, the IMF or even higher up. Or even if you're a no, they don't care. They're going to open up an account and start collecting on it. The thing with the driver's licenses and the registration, and last year I had defaulted the whole state of California on this one issue, that what they do is they strike money coming out of the U.S. trust account, open up a municipal fund under that driver's license and or registration, of which they post on the open market for generating cash. And the proceeds, what we found the proceeds go to are the federal, state, county, municipal employees. And so what we found out is it gets into organized crime. What they've got is they've got the municipals market, they've got the mutual funds market, completely exempt from having to be reported to the IRS. They're taking money out of your account to strike value for these cases that they're getting debt bonds, performance bonds, and whatnot, putting it out in the open market, and derivatives are paid back to that, the federal, state, county, the only way that I knew that you can go and get from the tap is to get a hold of the Security Exchange Commission, file Form 15 and Form 25. And by all means, they're going to have to take that stuff off because we're reporting securities fraud ID theft that they put the knowledge to have been perverted or prosecuted your name and your information and put money out of your tax account, which is completely unlawful.
Breach of trust and make personal trust and claim that there's your trust funds drawn against your signature, all those proceeds.
Yeah, but I'm still learning stuff. I'm still trying to get my mind wrapped around it. be able to get enough information here before you. You're going to have to pay your attention with the classes or whatever. Just your science down, so I can't study. I don't know why the science down.
They're trying to get things switched on the server. I'm trying to charge people more, so I didn't sign up for. We're trying to take another plan. Well, I take off I've been talking to Aaron over there at Wall Learners, and I'm sure they couldn't get pharmacy in the spot. We've got plenty of room for me to do that. And so I offer that if you don't have anywhere else to do it, or even if you want to do a secret account, just for the people that are in the group there. I'll give you Darren's number and he'll get you set up. Off-site. We won't tell anybody except for people who are authorized to go in there. Darren can put a password on there and have a secret account. We've got 3 different sites apparently from what he says. One for all the audios and videos, another one for all the documents, and I think he has another one for the newsletters that I put out every week. So,
I'll keep that in mind. Thanks.
Yeah, absolutely. Christian, I was doing some reading on the Public Law 89-719 and H.R. 192. Did you know that the legislation solely the trustees of the Bankruptcy Act, they're completely responsible for everything that
Your trust document that says they're trusting.
I've confirmed it on several different pieces of information. The legislation of the United States of America for originating trustee of the Bankruptcy Act. That means they're absolutely responsible for everything and everything. Who's the grantor? Who's the grantor?
What was that?
89-719. That was the Emergency Banking Act. 1 Public Law Conversion 89-719, and
That's what their trustees are. Okay, so whenever they approve trust, if they have approved trust, who would they claim the grantor and the beneficiary is? If they're claiming their trustee. If they're claiming their trustee, then it's got to be a trust. What trust is it? And who's the grantor? Somebody had them approve the trust. Thank you. How about that one? There's a lot of silence there.
well, I'm looking at this other part.
They're claiming if they're the trustee, then there's got to be a trust, right?
Yes.
But they're not saying who the grantor is and who the beneficiaries are. So if they're claiming they're the trustee, then they got to have an indenture. Where's the indenture? What does the indenture say? Who the grantor and the beneficiaries are on that trust? That would be the proof that you would need to prove that there was a trust all along. And that you probably answer.
Well, I'm just presuming that's the way I'm reading this document out is because there's several different enactments that were done by Congress. It looks like the IMF is the grantor.
That's what's looking like here. And that would be under public law 94 receiving compensation.
Yeah, what's what it says?
Yeah, they're supposed to be filed on the private receiving, separate for supposed to be. But, I'm going when you're in court.
Oh, here it is. Okay. Members of Congress or official trustees
Presiding over the latest regulation of the bankruptcy,
what's that last word?
entity in the world of United.
And this was Mr. Speaker,
Ohio,
James Kraft, and
Holy crap.
yeah, he's the one that gave the speech that says that ultimately the Congress is the official trustee presiding over this great reorganization act, the Bankruptcy Act.
Now, was that under that 95-564?
Now, this would be under 89-319, declared by President Roosevelt, saying that the country is insolvent, and that's therefore they instilled HCR 192 from the 73rd Congress session on June 5th, 1933.
And what you were reading there about the Trafficant, that was in the 89-319?
No, it's 89-719. Yes, that is how he opened up the debut on the floor on that day. The exact date for that would be March 17th, 19, right? That's going to be 19.
The 80s.
No, in the 80s wasn't the typo. They have the 90s right here. March 17th, 1933, 33. He was 1303. This is what the speaker said. The one I just named.
Okay, what's happening in the line?
Yeah, I'm pretty probably accurate. It just got out.
Okay, we can make it out. That is correct. It's March 17th, 1993.
They brought it up.
Okay.
All right, so that is correct.
That's not from 1937. That was a typo.
Is it James Travis?
There was the president. Oh, he went to jail.
Yeah, he was in jail. He went to jail for that.
Was 5 months old. Their representative.
Yeah, it's Federal Records March 17th, 1993, Volume 33, page 8-1303.
Claims on national
03.
Yeah. And it says, Mr. Speaker, you're now in Chapter 11, Never Defined Financial Trustee, presiding over the greatest reorganization of any bankruptcy entity in the world's history.
I think that was all because once you define it.
Yeah. I think it was telling everybody, just like what Chris said, we're all part of a great big trust. You just need to learn how to do trust. And
You can't talk about that. You can't talk about that in the public stuff, right?
You know, let's let out that and we're the beneficiary. And we've got to claim that. But there's got to be an indenture someplace. The trafficant read that into the congressional reading, into the congressional record.
I wonder if they removed that.
What's that?
No, it's there. It's there.
But I thought the whole deal with all this stuff too, like Christian, when we're in court and stuff, if we start talking about this, don't we gotta like get into that chambers or just make reference to it?
We'll talk about the bankruptcy.
How about this? When you go into court and not expressing the trust, and you say that they try to construe it,
working trust. You're saying that the judge just trust me.
Self-beneficiary? Is that correct?
Yes. Yes. They're saying it that way, yeah.
Do they ever try to make themselves beneficiary? Or can they?
They can construe it any way that they want it. As long as they're not anything at all, then it's going to stand that way.
Oh, okay. okay, I get down with my question. If they were allowed to
themselves as spiritual. But the thing about it was, it's constrained trust, and whatever they say, you don't say it.
You know how these movements go. And I was about a year and a half into studying this stuff. And you know, Sam, I try to spread myself out, right? Like some kind of statistical background. But I had to take that. I decided to take that. It was like a born again experience. I went into a highway traffic court, and I said to the judge, I said, do you understand that I'm here as the trustee, grantor in fact, the special interest in the name? And that's how we started. And I was pretty good at jurisdiction. They could not get me to jurisdiction because I spoke in questions. I know how to do that very well. And when they said, you know, sit down or take your glasses off your head, I'd just say like, oh, I'm just kind of studying here, or I got to go to the washroom first, or I just wouldn't give it to them, right? And they'd step through the gate. And she just wrestled and wrestled and wrestled with me. And there was like 4 or 5 security checks. There was not a problem. I didn't have any problem with it because I had a focus. We had a plan. And it was in my head, you know, I was going in there. I really studied the jurisdiction. Nice traps, basically. And so my posture was that I was going there under duress for the sole purpose of seeing to discover recognizing anything. But if there was, I was willing to so pretty much stuck to that. And I asked her at one point, sent a email out of this. Said, she was trying to, you know, they tried tripping all over the place, and they didn't get the last name of I was just hammering her. We were telegraphing so much information. It was like Halloween night. And at one point I said, are you telling me that I don't have the right to be the grantor and trustee? The trustee transfer back to special. And she caught her off guard. She goes, well, why aren't you recognizing the trustee for your acquiescence agreement? And then she said an adjournment, and the prosecutor threw it at me, and then the 4 security chicks ushered me out. But I didn't have any problem. What was interesting was they adjourned it over to a criminal court. I mean, I didn't have the presence of mind to say, well, at one point, I mean, I heard all this stuff come out. Like, there was some really good bits. Like, for example, I heard the recorder. You know how the prosecutor always signals the judge like in a baseball game, eh? Well, they were so out of sorts, he was just saying things out loud to her. For example, the recorder said, well, what do we call his name? And the judge actually said, well, you got to put Larry, because that's what I told him. I said, well, I'll give you permission to call me Larry, because they just weren't accepting the grantor, in fact. And then another time, I heard the prosecutor say, Your Honor, silence is acquiescence. And then I think here's the interesting thing. That was just like I was like a cow in a china shop with that one, and I was really like
in the traffic court.
Yeah, this was a highway traffic court, exactly. I mean, at one point even said, "Is this a civil?" And I said, "Where's the damaged party?" You know, that line of reasoning. I don't got it memorized very well. And she said, "This isn't civil court." And I said, "Oh, it's not?" I said, "Was this criminal court?" She said, "No." And I said, "Well, then what is it?" And she said, well, it's kind of quasi-criminal. And then, you know, I jokingly said, well, is there any quasi-damages? And then she's like, no. I couldn't believe she responded to that. Was there any quasi-injured party? She said, no. So I had her flustered, man. But anyways, here's the kicker. Next week, they put me over to a criminal court. And I was really scared because we kind of ran out of bullets. And I didn't mean to accept the German. I kind of messed up on that. The guy just threw a little piece of paper in my file and he pushed me out. I heard one of the security go, oh, he accepted it. I didn't quite catch on. You know how you pick up all these little nuances. They know what's going on. They know. You know, I was hammering the prosecutor and Eric Breger, all kinds of stuff. I'm beating them up. It was fun. But anyways, criminal court's a whole different ballgame. I mean, Those people are so poker faced, and I was questioning my reality. I was starting to go, wait a minute, maybe this is all in my head. They are that good. But I had nothing else to go on, so I stuck with the same thing. And there's the only stuff they gave away, you had to sort of figure that all by inference, and it was this. I went in, and first thing I started up, he goes, okay, who are you? And I said, do you understand that I'm here as the trustee and grantor in fact with special interest in the name? Well, and there was people in there this time. The other one, the year I was coming and they moved me over to another court. Well, the judge got up and he did this big dramatic thing, got the attention of the whole court, I think just to distract off of what I just said. Then he walked out and he came back in a second and put an adjournment for a few minutes. Now here's an interesting part. When I went out and I was just trying to keep my head straight, I wasn't very focused that day. I was kind of caffeined out because we didn't really have more of a plan than just to do the same thing. We're scared, of course, because it's criminal court. The long and short of it actually is just that they actually respect it more in the criminal court. So while I'm out, a cop and another girl who was actually planted in the seating part, I was keeping track of everybody, and she seemed very disarming and diminutive, but it turned out she was a criminal lawyer. I didn't know. And she starts going, oh, I noticed you didn't have anybody. Maybe I can help you out. She didn't say who she was or what. And I said, well, I'm just trying to get her away. I'm trying to keep my thoughts in my head. But I couldn't really brush her off. She just wouldn't go away like a little flea, And then the cop starts up like, oh, you should talk to her. She can really help you out. And then I kind of caught on like, oh, wait a minute. It sounds like two parties, right? It sounds like little situation set up here, right? So I caught on, and then I was just kind of like more careful, but basically just go away, right? But she follows me right back into the court, and she's whispering in my ear. She's going, it's okay, you can step across the gate now. And I would just be like, would you shut up? I'm trying to concentrate, right? And then we're about to start, and then she just creeps in front of me, and she's doing her little bow, and I said, what are you doing? Like, just, and then she, how when you get them, they cringe, and then they kind of go back under the rug. And that's what she did. And then the judge tried again. He goes, okay, who are you? Or what's your name, I think. I forget. And then I said, what, do you understand that I'm here as a trustee, grantor, in fact, with special interest in the name again? And he just said, okay, basically, from that point on, he basically kind of told me to shut up. And he focused all his attention on the prosecutor. Now, so right off the bat, in retrospect, they were obviously desperate if they planted this cop and this lawyer. I call her the lawyer from nowhere offering free services, right? I mean, how Alice in Wonderland is that? Maybe she's duty counsel, I don't know. What you guys call public protector or whatever, maybe. But she's got a private criminal lawyer card I got later. And then, when I went back to the court, she tried to do this thing, and just just insinuated herself right in there. And I'm almost like, you're trying to ignore on the one hand, but when she stepped in and started to try to represent me, I just said, hey, what are you doing? And then she just crawled back into sit down. And then that's when that was it. They didn't try to beat me up with any more questions. Obviously, they knew what I did last week. And he just went straight to the prosecutor. And another interesting thing was the cop never showed up. But do you think that he had mentioned it? I mean, and by the way, too, there was two prosecutors. She was the head prosecutor, I found out later, and she had a second prosecutor acting as her secretary. You know how they keep the second guy there ready to go through all the books? And I picked that up later. Another thing we did was I took certified copies of my birth certificate and driver's license, and I even had a certified copy of the original signature application of my SIN, and I had accepted them all for value, but I mistakenly entered them as evidence, so I might have destroyed that. But I did make one copy and say private for judge, and I gave the guy shit behind the counter for it. I said, don't look at that. That's private for the judge. I was doing that routine. And I had like 6 cops at the counter behind me, right? So I threatened that I was going to subpoena them all. But, okay, after that, the second time I said, so he goes straight to the prosecutor, and I couldn't quite figure what's going on, but
but it was like they were playing a game of hot potato because she kept trying to say to the judge, you know, we think it's a little bit extreme, but and here's what she did. This is the only other thing they gave away. This is all the stuff. Everything else was poker face. I couldn't figure it out. She said, we're considering a psych evaluation, and it's like she's trying to get the judge to say it. And I mean, he even at one point said to her, he said, listen, you know, I'm here today as the judge and not the prosecutor. Okay? So I started to pick up that he was basically on her case. And then she actually said that this, she said, well, we don't know if he's willing to volunteer to that. Did you catch that? Volunteer. Everybody thinks a big deal about psychopath, but there's the punchline right there, folks. So that was a catch, I thought, because I've never heard everybody say, oh, do this and get your own psychopath, and all you got to do is say, no thanks. But anyways, then he asked her, well, you're not going to be entering any evidence, are you? And she's like, well, no. And she was stumped. And then I added one little bit. There was, I played a nice little dirty lawyer trick when I was coming out of the hallway. They didn't know who I was. And I saw her, you know, there's two side doors, offices in between the vestibule area. The one guy was sitting down, our secretary prosecutor, and she was saying, who's this Shane Moore guy? And he goes, I couldn't quite hear it, but I stopped because she just walked into that door. So I stopped there. I stayed in the hallway and I just pulled out a book, pretend I was reading, so I could overhear what they're going to say. And he said something to the effect of, well, it looks like he's covered every single aspect of the law here, or something like that. And I couldn't quite catch any more of it. And then she said, well, I'm going to try and see if we were planning on trying to take my license for you. But I have a feeling he might have been making reference to me having the certified copies of the birth certificate, the driver's license, and the certified copy of the original signature application of the SIN, all submitted, accepted for value or something, right? But the long and short of it was, she said, and in a real twisted way, so that nobody could understand what she was saying, that they would be contacting the Ministry of Transportation and withdrawing the charges. And I got it recorded when I called her up to confirm that. So, and this was before I knew about you.
Ministry of Transportation.
Yeah, it was a ticket, right? I got a ticket for I don't wear a seatbelt. And we were playing with accepted for value. I've returned a lot of parking tickets. And I didn't realize that there's a jurisdiction everywhere you go, right? Like when you're in public, essentially, even when you go to a parking ticket office, right? That jurisdiction thing's still going on. I just didn't know. Had I known, I would have been able to, what they do, for example, when we get a parking ticket, and I know that we can sign it without prejudice and they never set a court date, right? And then they can't tell you how to sign your signature. But what they do is they give you a piece of paper when you come in. And they say, well, you need to talk to an adjudicator if you want to set a date for, a parking ticket. I was doing a lot. I got 10 parking tickets with this. But the piece of paper is just like an 8.5 by 11. They give it to you. And then on it says the ticket number. So I put alleged ticket, right? I don't write in the ticket number just like that. And then it says your name, and I scratch that name. I put name I have interest in, and put my name. Then it says name of the vehicle owner. That's kind of cute. So I just put the uppercase name again. Dispute, I scratch out dispute, and I put for discovery, settlement, closure. Where's signature, I scratch that out, I put authentication, and I put it right at the bottom. Somebody told me that makes you underwrite it. And also somebody said signature is a word that has connotations of, I'm not sure, but they take it away from it and use authentication. So that's what I did. And I remember I gave it to the girl, and she brought it in, and then it was cool. This guy just jumped out from the office, and he just had that look on his face. He wanted basically to see who wrote it. So I knew it was obviously effective. And when I walked in, the adjudicator guy, who's this old, crusty guy, he was actually the guy that was in the court. And when I was doing my thing with the highway traffic judge, or whatever that was, and he was there, and it was really weird because he just sat there and didn't interact with anybody. And I could see he was real red in the face when he walked out. And then it turns out he's the adjudicator in the parking ticket up. He looks like some guy who's been there for 20, 30 years, you know what I mean? And he had a paper in his hand. And when I went to the door, he was shaking. Okay? Now, I don't know, but I know I blew it because, like I said, I wasn't aware that there was a jurisdiction thing. I knew he's kind of like, have a seat, asking me questions. And then I could see he got control right away. Then that's when I started to think, oh, geez, you know, there's this jurisdiction even when you're sitting in their office, isn't there? So, but I was putting with accepted for value, returned for value, I hereby waive the contract to offer on the tickets. So I just thought I'd kind of share that because to me, these are kind of, without my really knowing it, I think I was basically doing some applications of what you're talking about.
So if you had to do it all over again, how would you treat it? More on a trust dynamic?
Well, I think somebody putting by grantor, I would be assuming jurisdiction is, you know, because the whole thing with jurisdiction is just a constant ongoing thing. They're just constantly trying to ask you questions. They're trying to put you into that position. And I would probably sign by grantor and the signature. What would I do different? I don't know if I'd do too much different in the court. I'd be more confident. I don't think I'd have to be fighting so much. I think sticking to, you know, do you recognize it? I was kind of concerned about the understanding of should you go in as trustee and grantor, should you go in as beneficiary and grantor? Because, you know, they say trustee is liability and responsibility. But I guess if you're responsible and you're there just to settle and close the accounts, I think that's all right.
Yeah, if you understand it, right? Beneficiary or trustee, you know how to play both parts. You got to win this situation.
Yeah. Okay. All right. So I was saying trustee grantor. I don't think there's much. Well, I wouldn't enter those docs that I said the certified copy with the accepted for value and signature. I'd be putting grantor on those, and I wouldn't be entering them into filing them. I wouldn't have to waste all that money. God, I spent an hour at that counter trying to force the guy to do it. Eventually he did after an hour and 6 cops standing behind me. And, because obviously, you know, I've heard, you know, from whence the interest stuff and evidence it goes public. So those are private things I'm saying, right? So I just bring them into court with me next time and maybe just give them to the prosecutor and say, here, this is private for the judge, right? Because, but I don't know what else because I mean it was effective. But mind you, what was going on here, I don't know what actually. Maybe I was wondering to get your feedback because one, I know I was staying out of the jurisdiction. They couldn't catch me by name. They wouldn't get me to step through the gate. I spoke in questions. They didn't catch me on the little. It's all Mickey Mouse stupid stuff too. This jurisdiction game. It's quite fun once you understand it for what it is. But I was more or less, and then, like I said, he just basically dealt with the prosecutor, and I called her up, and she was just nice, seriously nice, and just told me very plain English that they would be contacting the Ministry of Transportation, and she kept saying it would be as if it never even happened. There won't even be a record that you were given this ticket or something like that. And I was just like, this is bizarre.
How you on the ticket in return?
Well, originally, our thing was to just do the 3 days, return to process, right? So I was going to basically go into the ticket place and put accepted for value, exactly, return. And what I usually have is this phrase called accepted for value, return for a fair and lawful settlement, based in truth and fact, not color of law. Your offer of contract is hereby waived. I do not consent to this offer. And then it'd be a signature. And what happened was I said, I need to speak to JP. I was getting kind of bored. And I thought, I'm going to just go straight to the guy and I want to see what his, I like to see what the expression on their face is. And she said, well, you can't see the JP. So I stupidly at that point signed a notice of appearance. Now I did sign it again without prejudice, and that's another interesting story in itself because I think they gave me a fake document in the court. Because when I asked to see it, I didn't see without prejudice, but I hadn't seen it for they set the court date for exactly. I got them to stamp it, but I realized I hadn't delivered the thing, right? I hadn't given it 10 places. Stupidly, to cover myself, I said, well, I've set a court date just in case, right? And that was stupid. Obviously, I signed a notice of appearance. But I did sign it without prejudice, and I go through it with a fine tooth, and I make sure I don't do anything that, even on paper, I won't sign pleading or, any of that kind of stuff. Every one of those lines is trying to get you to some kind of jurisdiction. And so, but they set the court date, interestingly, they set the court date exactly 93 days after the stamp that they put on my ticket. Because I said, I want to stamp this because I want to show that I was here in 3 days. And I thought that was interesting. And then, like I said, when I was in court, one of the things was, I did a Sam Kennedy routine. They said, well, you signed a notice to appear. And I was kind of worried about that because I couldn't think back and didn't have it with me. And I forgot my copy and I forgot with it. But I always signed without prejudice, per the signature. And at the time, I didn't know. I hadn't seen it for 90 days. And I was a little bit doubting. And they pulled like that head game. They play head games, like serious mind F head games. And I said, I pulled a Sam Kennedy and I said, well, let me see this document. And he gave me the document. They were really acting weird. And I swear I couldn't see the per on my name. And I think they faked something because they tried to write accepted for value on it. And they ripped it out of my hands. And the security chicks ripped the pen out of my hands. And I just laughed and I kept going. But, yeah. So, that's how it got started. That's how I got kind of screwed up there. That's why I ended up in there. And then that's why I tried to send did all this certified copy stuff with accepted for value. To just say, I'm here that maybe it was a misunderstanding, right? Like intent, like you said, I understand that principle. Don't try and double track and lie. Just say, well, if there was, it was a mistake. Let me correct it, right? So, but yeah, that was that. But, yeah, I was just wondering if, again, what you think was going on there.
But they're really trying to get you back under the debtor credit then,
Yeah, they were trying to put me in there, but I don't know. Like, yeah, what would you say? Would there be anything else to do besides signing my grantor to let them know? I mean, just to let them know, that would freak them out. I know when I go to the parking ticket office, I won't accept any of their offers or questions. I'll turn it just like in court, just to let them know.
But I think you set all the trust lines and started creating evidence that would be in a trust and use that original offer they gave you as the debt title and then turn that into an asset title in return and making it a special deposit back to them under a misconstruement, returning it back to their being state trustee, if you want to play it that way. Or you want to turn around and say that was the payment and you are the trustee, depending on which way.
Yeah, yeah. You're the trustee. I'm going to appoint you as fiduciary trustee.
Well, no, not just fiduciary trustee. I'm just plain trustee on the trust. And if I'm trustee, then I have the right to make a payment. I'm making a payment per special deposit, which is really the return asset of their offer back to them as a special deposit, which represents both the debt title and the asset title. And when you merge the two titles, you make a payment.
Maybe that's why he was so scared. That's interesting.
And you merge the two titles, the trust terminates. There's no case, no charge, no nothing.
Well, yeah. See, I was doing a return process, so there was like no contract. But I wouldn't mind doing something that wouldn't. Obviously, they get really pissed at that, because it's like, you're wasting all their time, and they know that I'm trying to play them out to kind of feel them up to see what they're doing.
I terminate the trust. Any other associated bonds and things that they generate off of my signature, off my trust res, that's mine also, and I would order those proceeds back
Schultz and those guys got something going on like that. I want to get there. I don't quite understand that yet. But can you kind of run through that again? Like you're saying to get evidence of the trust. Can you start reading from
big records that you've formed the trust with your special deposits, because the special deposit is going to be an in-kind segregated trust res, and that the moment you gave them the res, that was the formation of trust.
You can do this with a ticket, you're saying?
Yes, because the ticket's going to represent both the asset title and the debt title simultaneously.
Whoa.
When to you, it represents the debt title. When you give it back to them, it represents the asset title. Now you got to create a record that there was an asset title, create a record that there was a debt title, and then merge the two together in one entity. When you merge one entity with a merger, that's payment. Trust terminated. Now, upon termination of trust, they should disperse the funds, and the funds is the remainder that's left from the payment. And that's all the bonds and everything attached in the background. Those proceeds are mine. Because they're generated off the special deposit, which is really my signature, which is trust red.
Now, like the man said, what would be the first way to show evidence of the trust then? Are you doing the acceptance for value and expressing it on the document? That's an instrument too, right?
The case number on the ticket or whatever, that I'm going to claim it on a UCC1 and give the county recorder, create two records that I claimed it. Now it's mine. It's mine to do something with. So I'm going to turn it into trust res and turn it back to them as an asset now. I'm going to move it on a 3, transfer it, and also do another county recorder. Now I've got 2 records to prove that I claimed it, 2 records that I moved it or merged it. As long as I got purpose parties and specific res and one of the methods of formation, which would be this case transfer on the UCC3, now we've got a trust that made a payment.
The two records that you're moving is one is the asset and one is the debt.
But you said that's both of those are in the same instrument.
Yeah, they're in the same instrument.
So again, you said it's when it's in your hands, it's an
I think what you do is a debt title, but when you give it to them, it's an asset title.
Wow.
Once you put your signature on it as grantor and then gave it to them as trust res, that became an asset title. It became the counterpart of the offer for the debt. It's the counterpart became the asset. So the ticket was an offer for a debtor-creditor contract, but I expressed it to be a trust. I didn't accept their offer. I re-expressed it to be a trust with a special deposit. And special deposit, by definition, is a payment of an obligation or a debt.
That's why I think what you're saying is so cool, because it follows that principle, which is how they operate. I noticed 2 things about I look at the legal system like it's a big computer operating system, and all the default settings are like presumptions.
That's all true. That's side and the asset side. What we just call them a title. Title to the asset side, which is the offer that they sent you for the debt. And then I go return it on the other side, being the asset side, title that's the counterbalance to the debt.
Well, I'm kind of wrapping my head around that. He mentioned something interesting to me. He said, this is all liability. Does that make any sense?
All liability?
Well, I was asking, he's kind of sitting me down. He's trying to kind of look at me, it's kind of like going to another planet the way they act. But he said something about, when I was sitting there, he's trying to get me to explain what I'm doing, but I'm trying to say, well, hey, isn't that your job, right? But mind you, it was just like I said, I was doing more of a return of process. But I would like to say, except for guys, go ahead and process, go ahead and charge the counter, get your funds, whatever. I would like to do something more accommodating. But but he said, well, something about this whole ticket business and everything municipal is all in liability or something like that.
Yeah, which is all public, which is debt.
Yeah, so I guess that's what he was just referring to. And that's, of course, why they come to us, right? They need our signatures or something because they're trying to create, this is how they make their funds, basically, off our signatures.
They won't violate the Constitution that, we're the ones that make the money. So they need our signature on it so that it can't be held liable for making the money because they didn't make the money, we did.
Yeah, so I could call it, and that would be honorable because I'd be, taking his ticket, I'd be accepting it through value, thus expressing the trust. Then you're saying,
they don't have to accept value under trust. We have what is called merging of the titles, and under the Gilbert handbook, I don't know if you got that or not.
It's on order. I just ordered it today. I just got my Amazon email. But yeah, I'm trying to.
And in court, you just hand them that paperwork?
Yeah, you can hand it to them in court, yeah, but you want to create the record that you did that.
Right. I mean, when you walk in, you say, here's the record, and you just hand it to them.
You got to go. Is there any? You got to go to
the lienability of beneficiary interest. There's the transferee's right under section 442. That's likened to, but it's not except the value in a trust. It's likened to it, though. It says that the beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust itself, but only of an equitable interest therein. Whatever conditions or limitations, that would be the lien, attached to the beneficiary's interest prior to the assignment apply against the assignee. So I'm returned it to them. I really have transferred or assigned it to them. But that's what the formation of trust and simultaneously acts as a trust says special deposit and a payment.
So if you got a ticket and you brought it home and you claimed it and returned it and you kept the record and you sent the whole thing back to them, so you don't even have to go to court, would that suffice?
Yeah, because it was paid.
Yeah. You wouldn't even have to go to court.
Wait, what is that now?
Expressing it as a trust, as a trust by creation of the record that refers to the title. And the merging of the title was the payment. And the title is the same as under section 59 of Gilbert.
And how did you prove that your the title? What process? What application were you doing there?
Proving titles platform, which is one claiming it with a county recorder. So there's your two records. And then merging it, moving it, or transfer with the three. That's the merger. And also create another county recorder. So you got two records to prove that you purged the title.
Yeah, we got one problem in Canada. It's hard figuring out what our equivalent of the county recorder is. I even heard that they removed it in 2002 or 3. So I'm trying to figure out.
Notification somehow.
Yeah, public notice.
Yeah. Thanks. Yeah.
How about the Providence Registrar? The Registrar of the Province.
I'll write that down.
State of Ontario or, Manitoba, that's one.
Because, yeah, that's always been a bit of a stopper. This county recorder sure sounds like a real convenient thing, because like what you said, all you're trying to do is put it in there so you got a record, so you can use it as evidence in court, right?
Yeah, that's all you're doing. And
the
province of the county is a non-negotiable.
Then I wanted to throw the story out about a traffic court that I just went into, and it was a trial date, and I was sitting in the seat, and the police officer was over there on the other side, and the judge, or whatever you call the guy, magistrate, he calls my name, and I and I stood up and I said, Your Honor, I said, really, I said, I can't be under your jurisdiction because I'm a Hebrew priest and I'm not allowed to swear. So I'm going to walk out of the courtroom now. And I know that you have a debit against my so-called name, and I'm going to replace it with a credit to zero off this account. And I said, I'll see you later. That's all I did.
Well, technically, is it your name?
Doesn't really matter.
Well, you just, that puts you right there. Like, you're trying to say ownership of something you don't own.
No, I just,
That's why I say name that I have interest in or legal holder of the name. Anyway, we kind of taught that to stop saying it's our name and our sin and our driver's license. It's not.
Or if you have a common law copyright
Straw man.
So I'm just wondering if you could do that under trust, Christian. Under biblical law instead of all this other stuff.
Well, it's all about trust. It depends whether or not you're expressing it as a trust.
How about claiming you're a Nazarene?
I'm not. I'm actually an Israeli.
Christian.
I'm an Israeli priest.
You are. Will never close down anything.
Not you, me. I claim I was a Nazarene, an Israelite.
But then that would be outside of the jurisdiction, wouldn't it?
The point was is that I wasn't able to swear. I wasn't able to use my name.
Right.
My point was is that I'm not able to use my name in your courtroom. I'm not able to swear. Therefore,
James 5:12. If you would go with that, I'm the Old Testament.
Christian, is there anything that has to do with the trust in there about not swearing? A trust with God?
James 5:12.
Yeah, there was a trust for God right in Genesis, right in the beginning.
Yeah, absolutely.
So that's like another roundabout way or another way of expressing the difference in jurisdictions, isn't it? So are you getting it?
Yeah. You're forming a trust. It can't be oral. It has to be written.
You're saying I got to trust with somebody else, not you guys.
Yeah, it's all about trust.
I said I can't bow down to your court. I cannot swear. I'm an Israeli priest, and therefore I'm going to leave the courtroom. And I know that you do have a debit against me, and I don't mind getting rid of it with a credit. And he said, that's fine. See you later. I just was wondering how that thing was under trust, but I couldn't figure out how you could repeat it.
When you said about a debit, you said about a credit. There's two titles.
Yeah, I did. I just spoke it. So, yeah. But Christian, I didn't use I didn't merge the titles. I used a piece of paper that goes out.
Trust can be oral. It must be written.
So that was basically an oral trust I was making, right?
Everything is.
Okay.
And then in his case, it sounded like he was expressing a trust with a different party.
Yeah, a lot of everybody doesn't realize what they're doing. They're talking about saying a debit title or debit or credit. You've got two different titles. When you try to make the adjustment, you totally converse the two titles.
Yeah.
It was an oral expression.
Right. I really didn't know what I was doing, but I just did it.
What's the debit title again?
The bill.
Okay. And then the credit title?
You said he had an asset in there.
Okay. How did you say you had an asset in there? How did you say that? In what way did you say
They
that?
had a credit. You got a debit on your books, and I got a credit. Just take care of it. I'll see you.
So in other words, he was giving a settle the matter.
Two titles and zero to 10.
Now how, and then how could he more clearly express the trust maybe if we can go back and do it again? What might he do differently to make it more articulate?
And there, we were setting the records up, and before we go in, having the records up.
And I could have just handed, if I had that set up, I could have just handed that to him.
Well,
That's special deposit. Here's the special deposit. I'm making a special deposit.
Yeah.
So it's accepting the value of expressed trust, and then we still have to make a claim on that, what is it right there, that debit title.
Christian, is the county recorder the only place where you can have a record? No. Do you have a record that's not?
You can put it in a miscellaneous file in the federal court and tag it, pull it out after it with the stamped, copy from the court to that court. Yeah. Didn't you mention that once before?
What I think
Put it in the miscellaneous packet in the federal court that got certified. Right.
So now, if you're taking on the ticket and still writing accepted for value on it, right?
Oh, no, we're not doing accepted value on the trust.
Oh, okay. Oh,
The
okay.
fact we're just getting the title and returning it. That is okay. Returning it for value. But
You're kidding. Oh, wow. Okay. That's interesting.
I don't say except for value, return for value. I'm not doing except for value, returning value. I'm merging two titles.
Actually, yeah, you got me, because I thought when I was listening, I got some stuff going back to June, maybe, because I know on the site, November 7, but now I was getting kind of confused because I thought that you started out without prejudice stuff, and then I think you were talking about accepted for value, and then I've heard that you kind of gone, were you kind of evolving your thought process or different kinds of topics?
I finally switched over to 100% trust right around November 1st.
Okay, I mean, I'm just curious. I'm new. Like, I mean, I'm really new, but I'm trying to immerse myself essentially.
Christian, can you publish that notice in the paper as well?
Yes.
Sure, public notice. You can put it on a telephone pole, Winston and so.
Another thing, when you put something in the county recorder, a notice, can you use a trust to put the notice in? Instead of using your name, you make up a trust and you put that, you use recording on paper.
U.S. registration number that you can't do for yourself.
Just use that number.
Just reference that number in the note. Nothing else. That number points to all your privately held documents with all the details.
Right. Oh, okay. Reference the number in the notes. Okay. Yeah, I remember you saying. Right. And okay. Is there any?
Let's go back to the transfers right again. Back when there's section 442 on page 1.7 of the book. What I read. Yeah. The beneficiary will sign only such interest in the trust that she has. The transfer is not a transfer of the trust read itself. It's not a trust read. That's somebody good title. But only of the equitable interest. The equitable interest, that's the beneficial title. There's your two titles.
Wait, the trust read, say it again, the trust read is which?
Page 127, section 442 of Gilbert. A beneficiary can assign only such interest in the trust res as she has. The transfer is not a transfer of the trust res itself or legal title, but only of an equitable interest therein. That's the beneficial title. Then whenever conditions or limitations attached, that's the lien they're trying to put on you under debt of creditor for the next whatever it is, number of years. So whatever conditions or limitations that attach to the beneficiary's interest prior to the assignment, that would be prior to the return, apply against the assignee. That would be the person who you returned it to. The one place that it gave the offer. So you're accepting it, so like accept for value, and then you're returning it back to them, return for value, but it's not that. It's trust. It's two titles. That's off her. The title, which was the original bill they sent you, along with the equitable interest, which is the beneficial title, in the return, those two titles, and you're terminating it to the merchant, and termination is payment.
Wow.
So when they give you an offer, they're giving you an offer under the assumption that you're the trustee, and they give the bills to the trustee. The trustee puts the rest of the bills. They also make the payment. So they're looking for a payment. They want your signature. So now I say, all right, I'm the trustee. I'm going to make the payment. I'm going to do a special deposit as payment for the debtor, the obligation. I'm going to return it back to them.
So you have to sign it a second time?
No, I just expressed it in the grandson. Okay.
So as soon as you sign it as grantor, there you have expressed trust, right?
Yeah, expressing it on the trustee. The trustee has the right to make the payment. If I make that payment, then I'm going to be trustee.
So you put a trustee by trustee signature?
Yes.
But you're the grantor. Created it with your signature in the beginning, right?
Yes, so I can both be grantor and trustee.
Right, I understand.
How I do a declaration, because how can I transfer trust responsibility within myself into two entities only by declaration? Because nobody would know that I did that unless I declared it.
But what
Just myself, grantor, to myself as trustee, made a declaration that I did that, and then as trustee made a payment to the one who gave me the offer.
And the payment, just the return, it doesn't have to be signed in return.
Yes, it has to be done by grantor. You never give an unrestricted signature. You got to sign by some kind of restriction, by grantor, by beneficiary, by trustee, whatever party you want to take.
So in your mind, you're the grantor, and then you say to yourself, I'm making you trustee, and then you sign on the thing, give your signature to the document as trustee.
You got to make a declaration, because by declaration, then you're forming the trust, because you yourself will trust when trust res property is transferred to the trustee. So trustee, how does anybody know when you transfer trust property? You have to make a declaration. In that instance, when you want to play both parties with grantor and trustee. But now you express yourself to be trustee. Trustee is the only one who can make a payment. So now make a payment by trustee, make a special deposit as a return, which is payment.
What's the declaration?
So the declaration is, on a 1 or a 3, that transfer was done between me as grantor and me as trustee.
Okay.
Correct. That's been done. And I use the trust. Now you go as your trustee. So I make a special deposit. You're the one who gave it proper, returning it back. They're the same thing as they gave me. But now as a asset title, and put down the balance of the debt title they gave me. And that made the payment, and I merged the two titles. Now I do another 1 and then 3 again, and prove that merged the two titles making the payment. Now that was all my intent and my purpose, and now the trust could terminate because I've merged the trust res, and there's no other trust res, and it's all terminated.
That is, that would be an excellent exercise to learn. because it's got the practical element and the understanding. You go through all the whole process, and you got the whole package of understanding there.
I've been here for that last 5 months.
Well, I know that I just showed up, so I'm gonna. Is this part of your course? Would this be an example of one of the exercises and you know
we're actually not going to put together in the workshop for this.
Yeah, I gotta get in there. I like this because it's got a practical element in there. I mean,
Did you start the class?
That's what I haven't put a deadline on.
oh good. It hasn't started yet.
No. But send me an app or a request for an application registration to get into the workshop.
I did. I sent out signatures.
Okay.
Pardon. So yeah. I ordered the book, and we need law summaries. I see the copy of 13th edition. That was 2007. Okay. Okay. And the other two books was oh crap, what was the other books we had going? Well, I got Black's Law 4, but I thought you use Black's Law 8 a lot too, right? 8 is the one you're using.
Yeah, yeah.
Okay. What's the third one?
UCC.
There's a book on UCC, or can we just get stuff off the internet, or?
No, it's going to be the official comment.
Oh, okay. That you can get that off the net, off the web.
I don't know the net that's got the official comment. You can get the UCC off of like Cornell Law, but it doesn't have the official comment.
Right. Now, one more maybe it's the official ESPN or if there's additional numbers or anything like that.
Yeah. Or the Gilbert's Law Summary.
No, for that UCC book. Well, I was thinking Gilbert's Law Summary one just in case.
Yeah. Well, a Thompson West version of the UCC with the official comment. I've got a 2000 edition, but I think that there's 2010 out now.
And you want to do, okay, cool.
And somebody was talking to the editor, also and the UCC with the official comment also, which is a little cheaper, I think.
Which one was that, sorry? What other version of the UCC you said?
The debtor creditor book, I think the title of that one was.
Debtor creditor book.
Yeah.
That's another Thompson West.
I believe that one somebody said had the official comment.
Cool.
I had that UCC book about 9 years old. They made a lot of changes. I had 2004. They've changed things. They're always moving things around on this thing.
Oh, it's nice to compare.
It's another $100.
Yeah, that's going to be the expensive one, isn't it? Anything you
Yeah, but that's what somebody said that the commercial debtor creditor law book was a little cheaper, plus it contained the official comments on it.
Cool. Commercial debtor creditor. Who's the publisher on the commercial debtor creditor book? Is that Thompson West too?
No, that was
ISBN or author publisher.
Foundation Press.
That's going to be one of them. Christian, are you familiar with the word recognize, recognizee, and recognitor, and recover?
A while back, I did it under the creditor stuff, probably about 2 years ago. But I don't remember what
I was thinking in terms of one thing I got burned in my head is we're are entitled to be recognized.
I'm not following it so much.
So the vital statistics I was talking about birth certificate. And it's sitting there, one of the lines, which we analyzed to death again, said, you are entitled to be recognized by the name. That's why you can go into a court and say, like, I don't consent to be, you can't say I'm not the name, right? Everybody knows by now you can't just walk into a court and say I'm not the name, that's just silly. But, you can say I don't consent to be recognized. And then I didn't realize, like, all the levels of meaning that comes into, recognize. I thought it was just another word. Every time you think it's a normal word, you find out, no, the legal dictionary's got a different meaning. And, I didn't know.
Your mother put an informant on you and gave the information, so that was the charge. And that's all on the birth certificate.
Yeah, that's what she started last you said.
Yeah, I ended up with that. But that was really a trust receipt.
What was? Which was that?
Yes, the birth certificate is the receipt of the special deposit that your mother made forming the trust.
Okay. And what do you consider the statement of birth itself?
It is a trust receipt. Trust deposit, which is the record of the payment.
Okay.
They take the birth certificate in under NEXT and make a surrender of the birth certificate that makes the payment. But you have to express the birth and I need to trustee in order to make the payment.
Wow. That's pretty substitute between the statement of birth, the statement of life, and the birth certificate.
Those are the two titles. One's on private, one's on public.
Oh, is that how they work? Oh, okay.
Because those two titles make the trust.
No. You know what's interesting? Here in Ontario, because those things a lot. And if you buy, like, okay, how is this a little different? As I even understand when they said your birth certificate is set up because of red stamp number. I always thought the red engineer stamp and everybody's saying it's QSIP and account and all this crazy stuff. But anyways, on a normal birth certificate, you got a registration number and a certificate number, and then on our birth certificates, we got the red engineer stamp on the back. On the statement of birth, you've got the dates, you've got the registration number, and you've got the certificate number, and you've got a file number. And what's really interesting, I thought, is when you buy the statement of live birth and the birth certificate together, I noticed that the registration was consistent, but you might see a little difference, like a -001 and -10, like that, but they're basically the same, of course. That's the one that doesn't change. The file number on the long statement of birth becomes the certificate number on the birth certificate, and I thought that was really fascinating. That you'll never see that and make that connection unless you buy the both of this is here in Ontario. And I always wanted to know it's like an extraction level, so it's an extractive derivative of. So that's I put trying to that's what you two sides of the same coin.
Yes, right. The live birth certificate here is the private side title, and the public side title is the certificate birth certificate. Emergency. And you terminate the trust and you protect the title. We all started out as perfect beings, but a trust came along and created two titles by splitting the perfect title. And now you've got a beneficial title and a trust. The legal title would be the birth certificate, and the beneficial title would be the private will and a woman's live birth certificate.
How does legal title apply to us, though? I mean, we don't legal title. They didn't give us the legal title today.
Trustee, that's in the public.
We got the legal title?
Yes, as the fiction trustee, yes.
So you said it's the one trustee?
The legal title is the trustee. As official owner.
Okay, all right. So, but we're only the trustee, though, which is the responsibility, liability part.
Beneficial title in the beneficiary.
And we also have the beneficiary.
So it says that the beneficiary can assign only such interest in the trust as she has. The transfer is not a transfer of the trust residue itself. That's the legal title, and that legal title is held in the trustee, but only of an equitable interest therein. And that equitable interest is the beneficial title held in the beneficiary. So there's your two titles. The legal title in the trustee, that's the brain block here. The legal title is the trustee title, and that's the public side. That would be the birth certificate. And the equitable interest, or the title, in the private, which is the live birth certificate.
And that sounds like the whole thing. We can get both of those and be in possession of both of those. But we have to go through the process of expressing it, of some presumption.
You have to create two records that the public can see of what you have representing your act of virtual titles. Give public notice that they can see. And that's what a UCC 1 or 3 is, public notice. And then that's what a county recording is, public notice. But then that reflects back to what has been done and held in private, which is all the documentation that you claimed it and held it.
Wow, oh man. I love the way that sounds. I have an ear for those things. Pretend that I totally grasp it. I get the gist. The other thing that would catch that those copies, because they're not, I have a certain of the words that would show up for me. Right away, I suspect Mickey Mouse non-legal terms for something so important.
There's always that duality. We don't think in multi-dimensions.
Yes, well, I like that. I agree with that. And we have to, duality, or even, like one thing we can do it in course is to get people to think, like you said, gather Crowder, which itself is
duality. How did they create this duality? How did they bring in this public realm? What created it? The trust in 1933.
Well, trust is
perfect title in the two. There was prior to 1933, all land had perfect title. You could get a allodial title, a perfect title, representing the real true ownership of the property. But after 1933, they put a trust on it, and a trust splits the title into two: equitable title, or beneficial title of the beneficiary, and legal title into the trustee, or possession title.
That's, you know what? I'll just to add to that. I went to a registry office, and I never had the
perfected title because there's a trust blocking it. A trust with the title, and a trust is blocking you from perfecting a title. The only thing for two titles, think of it like a circle. That was a perfect title. Now draw a vertical line down the middle. Now you got a trust with two titles, two sides. And anytime you merge the two titles again, you take the line out. You got a perfect title again.
I understand that in principle, sure, that makes sense. That part. It's just the application of the process that would be involved to bring them together. Obviously, which is what, of course, you're talking about.
That also forms the liability side and the creditor side.
when you're assigning, if you want to be too specific in that, like saying you put in a trustee, you sort of committed to saying what you're going to become a trustee, or do you want to make it a bit more general so you can change it depending on the circumstances? Because you can go to court and you want to just be a trustee.
Well, it depends on what you're doing. If you're making a payment, you have to be trustee. Only the trustee can make it. So if you're going to put the trustee hat on, you're going to have to sign by trustee in order to make a payment. But then if I want to be a beneficiary, I got to take my trustee hat off and put my beneficiary hat on and now sign by beneficiary. If I want to make a payment as a trustee.
So if I'm playing the court case, like I've got one coming up with a council where they want $200,000 in fees, I'll take them to a tribunal, but I'll claim the court case. And I'll become the grantor, but under that I want them to pay, so I want to make them become a trustee.
Okay, you can do it. You can be grantor and trustee, make a payment, close out the case. Or you can be grantor and beneficiary and appoint somebody else trustee and make a claim as beneficiary against that trustee. We're just terminate the trust. I don't care which way you play it. You got to win this situation. If you don't understand how to play both parts, whichever part you want to play. You can't be trustee and beneficiary. You can be grantor or grantor and beneficiary, but not at the same time.
Are we in the same session?
What, say again?
In the same session, like the session. And then, is there some formal way of saying, and then as the grantor and beneficiary?
I want to play through all the way once I set it up. So you'd have to make that before you get in, decide which position you want to play. Either going to be grantor beneficiary or grantor trustee. Okay.
Kristen, this is just taking the trees off the tree, though, isn't it? But then the banner here, I'm talking about the stuff we're talking about now. Court cases are basically just getting off.
That's good practice.
Yeah, right.
I'd say you could do it. You can get your head around it.
Christian, you're also using the term making a deposit in the trust. Is there an objection to using the word deposit? Deposit, doesn't that mean you're removing something? Deposit meaning you're accepting it? Well, then again, I'm going to use their terminology in there in the Black law. It's special deposit, trust deposit.
A special deposit.
Well, trust deposit is synonymous with trust deposit. They both mean the same thing. Okay.
Christian, can't you be trustee and beneficiary?
No. Yeah, you can, but then you can't be both simultaneously and have to be written in the indenture.
No, I know, but when you're going to get something other than the trust left back, the interest on or something, don't you have to be a beneficiary to receive that?
Yeah, benefits. First one from the trust is when the time the trust terminates.
That what?
The beneficiary receives from the trustee anytime the trust is terminated.
So if you give the trust lands to the trustee to terminate the trust, and you're the grantor, you become the beneficiary to receive that.
You get the disbursement as beneficiary.
So okay, so then you're just grantor and beneficiary.
But if you look at the scenarios that I've spelled out and you understand them, I don't care which position that you play, you're in a situation. If you know how to play them up.
I'm just trying to think. You just said, you just only gave two examples. You just gave grantor and trustee and grantor and beneficiary, but you didn't speak about the trustee and being trustee and beneficiary at the same time.
That's the course thing. Let's keep it simple. Play one or the other.
Yeah.
Okay.
That's why when I've seen in a land registry office, this girl was trying a technique. It was kind of crazy, but she was trying to do the signature.
This service is provided by freeconferencing.com.
Well, it kind of reminded me of the university professor, and kind of sat us down and very composed. And he starts first off to take control by asking the questions. I let him just blow all that off and got right back to asking him the questions. And then he kind of laughed because he said, well, you're trying to make this decision of, we did the whole notice age and notice thing. It's kind of irrelevant at that point. What came out of it was, I'm kind of studying big tech stuff. I'm kind of throwing your stuff his way because he's kind of like thinking in your terms, but he's in, like you say, the debtor creditor model, I think. He wants to be right out of it. But anyway, getting back to this thing here, this guy says, well, this is kind of silly because he's trying to ridiculous thing. It's just like everything they say in his textbook. He says, because like your signature's not on the document. And I mean, I knew from Vic that, the signature equals, well, contract, or I guess in this case now I'm going to change myself to say trust. So I immediately jumped on that. I said, well, wait a minute. What do you mean the signature? There's no signature. I said, where's this contract? Right? What obligates a person to be to the house or whatever, right? And I stupidly answered the question for him. I said, is this some kind of an assumed contract? Because he was kind of stuck and flipping through the document. She got out a certified copy of the transfer of key and everything. And then he wasn't satisfied, and he said, here's your signature. And I said, well, wait a minute. I thought you said there was no signature on it. And he said, well, what you signed is I think he called it a tax receipt at the time. And what came to light for me, like it set off a light bulb, and it kind of shot me back to stuff that Winston said, like over here in Canada they say the Queen owns everything, right? So what turned out was, I just get right to the point. Sometimes I like to play with people and say, well, who do you think signed the deed of transfer? Actually, I play that. What do you guys think? I hope I laid that out enough, because this is kind of really, you got to see this. Is anybody still with me?
Yeah, it's the same thing we do here in the county. We're the ones that are implementing everything.
But he was right. Like, her signature wasn't on the deed of transfer. It was just on this, I guess some people call it a tax receipt or some kind of affidavit that you're obligating yourself to pay the taxes. And like, this is huge. I thought this was incredibly profound because nobody really understands this. I guess when people buy houses, there's millions of people that own houses, but nobody knows that they're not signing the deed of transfer.
Well, the grantor granted that was the person who sold you the property, and then you're setting it back up or recording it in the county as trustee. And now you got the liability as trustee and the county's beneficiary.
Well, I don't know how those
trust. So when people know they're funding a trust when they recorded their property in the county.
Well, yeah, I mean, this is the whole thing, but most people, let's face it, don't even know nothing. I shouldn't even say it that way, but excuse my English grammar, but they are just, they're sitting there googly-eyed in another cloud space while an attorney's doing all the work or a lawyer's doing all the work, right? Because that's what it was. They're the ones.
Or when you buy groceries in the supermarket, you're forming a trust right there.
Well, but this is so blatant because what I got from this guy didn't realize that where my focus, I guess, was at. But the whole point that he gave out was, and nobody seems to catch on to this until you tell them, the attorney signing the deed of transfer on behalf, and the reason why that struck me,
on behalf
of the Queen, the Crown, the state, I guess, in your case, right? This and see, I remember Winston saying
under debtor creditor.
Well, I thought that's kind of a trust thing because there's your two parties, right? They're taking, obviously they're signing on behalf of, the lawyer doesn't own it, but he's acting as a representative of the Crown, right? Everybody's admitted to the same bar, right? So you guys got the same lawyers as we got, and that's because it's the Bar Temple, the Temple Bar in England, and in the inner city of London, and they say the U.S. is a colony too, but but the whole thing that killed me was, I mean, I don't know enough to really question things because I never bought a house, but I don't think anybody really knows that they're not signing on the trust, the transfer. I mean, even think about the name of the document, transfer of deed. Like, that's just too funny, right? You know, because Winston was saying, the Queen owns everything. Say what?
Deed is an act.
Right. Well, this is called, I mean,
I don't recording of your act, which you did, that you purchased the house, supposedly.
So what's a transfer of deed? A transfer, well, transfer, that's one of your trust words again, right?
Yeah, that's trust is form on transfer, yeah.
Transfer of deed. So, oh man, I got to get into this. But I just thought it was fascinating because I can't find a person in my country who's even aware that they are not signing the transfer of deed, but the lawyer is, and that they're just signing some kind of document that obligates them to pay the taxes. And I just thought,
they're doing it themselves.
They're doing it, but wait, sorry, what do you mean? Sorry.
Somewhere along the line, they signed a document, an application which gave them power of attorney to appoint maybe somebody else to be trustee to do the transfer.
Well, yeah, the lawyers, they always have lawyers involved in this stuff, right? And that's what I'm saying. I mean, what I'm getting is I would love to sit down now, be a fly on the wall or put a hidden camera and watch this process, because what I suspect is, what I'm getting at is, I believe that the lawyers, because my experience in court, what I learned was that they all know about the name and they know that it's a legal entity. That's why they're always trying to hit you with the name. They know that. The recorder knows, the judge knows, the prosecutor knows. I even got the duty cancel guy behind the counter. It turned out that he must have been some young kid working there. But he knew as well, because I started saying stuff about the name. I got the better of me. I should have telegraphed. Because then he said, oh, yeah, we heard people trying to do that. That never works. And he threw some question at me, and I answered it. I could just tell from his expression. He was like stunned. It was that like, oh, my God, I know that you know what I know kind of thing, you know. And he, like you said, that was at 5:30 the next morning when I showed up. And the attorney was really on it.
Transfer value and the transfer value under debtor creditor scheme. But now let's even go one better. Let's go trust, because that's controlling it all.
Well, I'm trying to get there, yeah. I mean, this is an example of trust. But what I'm suspecting, and it was getting back to these lawyers, is they're doing a magic trick in front of these people. Look, think about it. These are just working class people. They don't know legal stuff, quote unquote. And they're excited, and the lawyer's probably thanking them and congratulating them. It's an emotional moment, and they have to trust. Obviously, you know how people are in front of lawyers and doctors. I've never had that, but other people, I've watched them, and they just get stupid. I mean, literally, they just get stupid because they're in the presence of a lawyer or doctor. I don't understand it. I guess I just didn't get exposed to the same thing.
Bear with me. That's okay. Can I ask a trust question? Yeah, let me finish this one. The key is that no entity in the trust needs to know or understand that a trust.
Exactly. That's what I'm saying. And that's why he purposely misleads them. He just basically, while he's talking and moving the papers, like I said, I haven't seen this, but if this was filmed, I'm sure this is what they're doing. If they're doing what a magician does, they just distract them a little bit and they just say, sign right here. They think they're probably signing it. Not, they never heard anybody say their
relationship.
Say what?
They distract you by the debtor-creditor relationship, and they get you to put your signature under these documents, creating records for debtor-creditor support or proof.
Yeah. Well, like I said,
we're not getting the records under trust to counter the debtor-creditor stuff.
You're not even getting your signature on the actual document that represents the property to begin with.
Can a trust be a signature?
Well, that's what creates the trust, isn't it?
Right. No. But instead of signing your name, you use a trust as your signature.
Actually, that's a good question. When they sign the affidavit of obligation to pay the taxes, that's the trust that they're signing, isn't it?
Under statutory law, yeah.
Oh, yeah, but then there's that difference between statutory trust and private trust. But it's like, basically, it's not the lawyer signing for the property on your behalf. in a private trust, and you're just signing the statutory trust with the tax?
He's liable for beneficiary payments, which is the taxes to the county. The county is the beneficiary.
And that's a statutory trust.
County property, then we owe the county the taxes, the rent on the POP uses, because it's nothing more than a feudal thing that's been set up.
So what's the difference again between a statutory and a private trust?
So a statutory trust is formed under, pre-United States statutes and codes.
Okay. Do you think the lawyer is signing because obviously the lawyer is signing on behalf of the Queen, right, or the Crown, right, a corporate entity, right?
Well, I believe that they're operating under a grant that you gave them the property. You gave the property to the Queen. You abandoned it. You granted it in the trust, and the Queen has it as beneficiary.
Well, that's everybody in Canada. I don't know how they do it in the States.
No it or not. The United States owns everything held in trust by the grantor giving it to them.
So I'm curious then.
Because you never realized for grantor, you never realized you were setting up a trust. Now go back in as grantor, claim it as a trust, and correct the mistake or the misconstruction.
Do you think you can even do that when the only signatures on it is the lawyer who's representing the Crown? Like, I'm trying to figure, I think they got this thing so sewn up, it's like, how do you even get back in there and say, hey, wait a minute? You know what I mean?
It was your power of attorney that you gave this attorney to sign for you.
Oh, yeah, okay, I got you. Right, I got you, that's right. And in power of attorney, you can remove it just as instantly as stating it.
Yeah.
Okay. Wow.
And the United States does have patents too, which are in a little different category.
Well, I think that was a good trust example, I thought.
What about the land patent? The land patent is a higher title. That's a whole title. And it's a title in the United States that we have. And Roosevelt set up the trust we gave them. That's the one we gave them. So we can still go back and call it up. Yeah, we can cancel it. We gave it to them in trust, granted it to them in trust. Yes. So somebody had a whole title, they turn around and use a grant deed, which put into the public trust. A few people out there who still have land patents that have never been transferred, still have the whole title. Roosevelt did not have the capacity to negate those, according to Supreme Court rulings. So that's all we're subject.
That's a good point, though.
What we're working on.
That's that principle: the game is won or lost in the first move.
Yes.
Everything's preemptive. I find with these guys, they do it right in front of your nose, right before you even realize that the gun's been shot off, and you've already lost. You know what I'm saying? Like, just look at the way they do jurisdiction in the court.
At all, and you had the right to go back in and practice, and you were the one with granting it. You got all the power. All you have to do is just like the Wizard of Oz. Dorothy was wearing the slippers all through the movie, and the slippers was the knowledge and understanding that all she had to do to get back to Oz. But she never knew or understood until the end of the movie. She had the power all along.
Yeah, we knew that was sort of in the story there. Yeah.
She never believed it till the end. But then the treatise on the practical application of the trust here by Lewin, it's talking about the interests were new and original estates here. They're talking about trust and cannot be said to have been impressed with the use. So the Lord, who was in by his chief, a deceiver, a baiter, and an intruder, were not amenable to the subpoena for the first deputy king claimed by title paramount to the creation of the use as the trust, and the three last were seized of the tortuous estate and held adversely to the POP uses.
What page is that?
That's on page 3.
Volume 1 or 2?
Mm-hmm.
Volume 1. Page 3.
We have a higher trust out of Torah that was back to Old Testament times. When God gave the land and He marked the corners, and that was a grant that was investment to our posterity. And these kings that come along are nothing but usurpers. Okay, so we hearken. We hearken back to the original covenant for the king, that would be the state or the United States or the queen. Nor was it competent for the king to sustain the character of trustee, for it was thought inconsistent with the high prerogative that he should be made responsible to his own subjects for the due administration of the estate. Well said. You notice they're talking about the king being trustee. The queen and the state today is not trustee. We have appointed them beneficiaries.
Oh. Right. I think Winston was kind of talking about this, because is this what you call converting to trust? Or what he was attempting to do at the time when he was talking about accepting for value as a form of converting to trust? I mean, I'm still coming from there.
Maybe so. I don't know what his thinking was at that time.
Okay, well, I've heard a lot, like even, I think, like, because I'm still coming from commercials, and, let's face it, your stuff is unique, so, but everybody's Brandon Alexander and Creditors in Commerce, and he said, when you do an acceptance for value, you are becoming the title holder, he was saying. And then you're giving them the copy, and because he was kind of like saying the person who's holding the certificate is kind of like, the possessor, the legal title, he's the trustee. Yeah, the trustee. But when you do an acceptance for value and then give it back to them, then they become the trustee. He was kind of using this terminology and saying that now you become
actually formed by you, the grantor, and you made them the beneficiary, and you as trustee now owe them the disbursement of the funds. And we're not giving it to them. And they're all going to jail and breach of trust, or we're all trustees in prison.
Yeah, I've heard of this, and I like the sound of it, and I agree. I get the gist of it, and this is where I go. Yeah, I know that's truth. I don't completely understand it, but that's where I want to go, because that makes sense. There has to be a symmetry. It's not like they're just all evil and.
But the fact is, we appointed them beneficiary because we were the grantor. We were the only ones who have the power, the authority to set up the parties. We can come back in on a mistake or misconstruement and correct that to be something else if we understand it.
Yeah, there's got to be something there, because sometimes they just step on you, and other times they shit in their pants, and there's got to be a reason for that.
We had a foreclosure going on the sale, and 2 hours before we came in with the expression of the trust, and the sale got pulled off the sale block. Because court misconstrues you to be the trustee, and we came in and expressed us to be the beneficiary. Now there's a conflict of interest. The court says we're trustees, but we're coming in saying we're beneficiary. Now, they pulled the sale off because we also gave them notice. They could sell the property and give free title, free and clear to the bona fide purchaser because we've given notice. They couldn't pass a clear title. They had to pull the sale off the block. They did.
So in the act of giving,
with the NOI, followed with the SOI, the material fact, to prove the expression of the trust or claim the trust with the evidence, the SOI. So therefore, in 30 days, it's timed out. They put the house back up on the sale block and sold it. Now, the next time we went in, we did it with the SOI. In that case, got closed down.
They were on to you the second time.
So we got to do it differently.
What do you mean they closed it down?
Then with the title. That we merged the title.
Oh, you were successful the second time. They closed the whole case and just dismissed, didn't proceed forward with it. Yeah, I've got to get this story because all your critics say, they don't respect the fact that you just basically come on the scene 5 months ago. They're putting you side by side with, Sam and Winston and all these people. So give me a break. The guy stumbled upon something and
let's look at it this way. Let's look at it that debtor-creditor relationship has been out since 1933. And we've been trying to seek a remedy against debtor-creditor relationship by, say, doing redemption or except for value, terms of value, or any other kind of methodology for the last, 20 years at least. Now, in the last 20 years, debtor-creditor relationship, whatever methodology is used to try to get a remedy, is only less than 10% successful over 20 years, when I would think after 20 years it ought to be closer to 95%. I think we're on the wrong trail.
Sure. And when you listen to what people are saying, they're talking about trust when they don't even realize it. Like Brandon, when he's talking about that example, he's talking about trust and he doesn't realize it exactly.
A lot of them are talking about they claim they know trust, but they're mentioning that you're the trustee on a necessity trust, and that's as far as they go. They go right down the debtor-creditor rabbit hole again.
Yeah. And I think that's what they're doing in the courts. Like, you talk about different levels. Well, even if you're smart enough to figure out the trustee, the beneficiary, and now I could be mistaken, but it looks like what they're doing is they're kind of hiding by non-attention, if you like, just like what they do in the media when they want to kill something. They just create a media vacuum. They don't pay any attention to it. People don't see it. But in a court, people don't see the grantor.
The longer you see this trust material, the more clear it's going to become.
Yeah, I believe it. I absolutely.
Dive under creditor and redemption and all that other stuff. All of a sudden, you're going to see they dovetail in and join together under trust.
Well, it superimposes. But I'm trying to say, like, one of the angles, try to see what their game is. It's like people think they're getting to a higher level by even getting into the thought process, the duality thought process, debtor-creditor. But, I mean, it's in reality, it goes yet the more fundamental or higher, whichever metaphor, but it's actually, it's not
very simple compared to all the other stuff.
Well, fundamentally, but if you're not looking for it, like I said, the hidden grantor, because like in debtor-creditor, it makes people think.
You're walking around every day, you never look at it.
Well, and they're making people think in terms of either or. Like, I mean, everything in our system, right? It's Democrats and Republicans. It's good guys, it's the bad guys, it's black and white. But it's like debtor-creditor, but actually it's beneficiary, trustee, and grantor. It's a three-party relationship. That's the way. When I was first introduced to trust, I don't know anything really. But we
used to look in the opposite direction. We used to have Sen Toto over to pull the curtain back and expose what's really going on. There's a little guy in the back there that he's controlling the whole thing, and that's trust.
Well, I was told there's two kinds. There's two-party contract, and then I said, well, how do you explain trust? I said, well, think of it like a three-party contract.
We can't have contracts today because there's no money.
Well, exactly. Where a contract is paid, that's where the contract is made. But if you can't pay it, then there's no contract, right?
That's right. So what takes place? Gifting. That's trust.
Yeah. So that's, in a way, that's what Winston was trying to get at, because he said that. He was trying to get at the fact that, maybe he didn't go far enough again, but he did mention that.
Nobody. I think I'm the only one. I don't hear anybody talking about this stuff that was in depth that we're doing.
No. But the funny thing is,
Christian, and I've been through all of them. And what he's talking about right now is a much better understanding. Before Christian, I have a quick question. If you're in a court situation when they hand you the charging instrument, and you take that into the trust, is there language? You say you take it in by transfer, you take it, you receive it. Are there particular words that are better than others? Is receiving a document implying some other relationship? Okay, I'm not quite following you. Could you say it again? Okay. Use an example of a district attorney to hand you a charging document. And you take that and you accept that, you receive it, it's done by transfer or by delivery. You can use any of those words.
language like receiving it.
But I want to avoid precatory language. I always want to be commanding, ordering, and directing.
What is that word you're using? Precatory?
Precatory language, yeah.
How do you spell that?
I wish, you should, or you can, it's weak language.
How do you pronounce it? It always doesn't sound like I'm not hearing it. You said precatory?
Yes, hang on, I can tell you exactly where it's at in Gilbert.
But I remember you talking about that too, and I agree with you. It's not, somebody was asking me, should I say command? And you're like, well, just avoid basically, can you, or would you, or please could you, and just say basically, do it this way, please. Like I direct you.
I always direct or order or command.
So you do use command, okay. I like direct. Or, yeah.
That's more like universal. I direct you to make my special deposit.
They always make fun of us Canadians because we're so polite. They're always saying, well, can you do this?
That's precatory language.
Yeah, you avoid precatory language,
right? Yeah, that won't get you anywhere. So he was explaining about his, I forget what we were talking about. You're talking about the indenture language, right?
He's saying, should you use the word receive or transfer or what was the document you were referring to?
Well, I think he was talking about writing an indenture, which is part of the expression of the trust, which can be oral or written.
So he was talking about receiving something from a district, from an attorney.
Right, and then returning it and what particular wording to use on it.
He was wanting to know how to accept it. How do you accept it with certain language? Do I receive this or do I not receive it? Or is there particular language that you use?
I'm not doing acceptance. I'm doing a special deposit, which is the return.
Well, he wanted to know what to say to the attorney.
On the incoming. You don't have to send anything. Just get rid of it. Make it as a special deposit. Express it to trust.
How do you, what's involved in directing somebody to, do you do the special deposit? You're telling them to do, how does special deposit translate?
It's as simple as saying, I give you my pen in an action, and then I say, I want my pen back in, say, 2 weeks.
So you gotta tell them that you want your pen back before you give it to them, though, right? Obviously.
Well, it has to be a segregated trust res, and even though there was no trust wording used in there when you said, I want my pen back, the fact that I wanted my pen back meant that you had to segregate my pen from all of the pens.
Oh, right. That's the principle, right?
That was a special deposit, but I didn't put any in there telling you I want to make a special deposit of my pen. I just said I want my pen back. That was a special deposit.
Even if the other party construed that you were deposing yourself of it, as long as you come back and say, all right, I need my pen back, I need the same one with my initials on it, then you overturn their construing and training.
Well, again, it's the intent. Yeah.
Right? Is that correct? Okay.
Expression of trust is a manifestation of the intent of the grantor.
Even if it wasn't previously stated, like in that example, they could construe that you're deposing yourself of it. But you can still come back and trump that.
So if the dealer still has your document, would you write that as the following title, I received the trust, trust res?
I'm making it too complicated.
What's on that?
I'll find my phone here. Let's find it. That's on the other side. The language.
I think we have to Christian, of your that that is sort of like a seminal, you know, and your followers need to have that story so that
some details go along with that. How to probably come in with the proof in the court.
Yeah, and it's a learning. Obviously, it's a learning thing in itself. So we can be out here wrong. He doesn't get what's with. I just started with 2 months.
Hang on, let me look at the thing he's looking up.
Okay,
The answer.
so I came up with this one with a little expression of trust, which contained the word direct. So I direct you to separate my original records for future return. Or I could say I direct you to separate my original property for future return. So the only way I get back my records or my property, I could leave out the word separate, really. I direct you to
Return my original property.
return my original records and in the future. Now, in order for you to return original records, you're going to have to make a segregation of the property. That's a trust.
That makes sense.
So I could add in there, I direct you to separate my original records for future return in time after use. Now I can keep adding there depending on what I want to do. Narrow down. You put a special date in there, or I could put instructions that want you to make the payment after you reduce trust res to say cash. In other words, I ordered a conversion, or you can convert trust res property and make a payment. That's what I want.
What email should I send? Could I send that to you? I think you'll find it interesting.
Send it to the Hotmail account.
Okay, so moving titles of Hotmail?
Yeah. I like it all here under this page 9 of Gilbert. It's talking about in section 43. It gives an example here. This was an example under debtor-credit relationship, by the way, though. But the example is really of trust. It says transferor hands transferee a bundled $20 bill totaling $500 and indicates that she wants the money returned at a specific date. If, as is likely, the transferor does not care whether she gets back that particular group of bills or even property directly traceable to them, the arrangement cannot be a trust, but it is a simple debt. So thus the transferee can repay the transferor any $500 and is free to dispose of the particular bills received. Okay, take the inverse of that. If I ask for the particular $20 back that I paid in $500, then there has to be a segregation. There has to be a separate deposit made, and that is a trust. That's a key to formation of the trust, which is page 28, segregation of res, under section 104.
Just like in private banking.
That is private, it's not negotiable.
So it all fits.
Yeah.
Yeah. I could never make sense of this stuff until listening to you, basically. This is why I think it's so great. Just even, doesn't matter what you think of, all the questions I've always had about private and public and what the hell is going on. I've never seen anything touch it. You know this is so fundamental when it can, it just keeps coming up in your mind on everything. to look at that reference you were saying in a practical treatise on the law of trust by Lewin there. I got the Google PDF. You were saying it was on the third page. It was part of the introduction.
Page 3. That is the rise and process of trust. The introductory view. Yeah.
Okay.
I read 2 sections. I read on page 2, right there under the confidence in the person, that was talking about the king. And then on page 3, just before the privity as regards to the dedicated trust.
Oh, okay, cool. I see it. There it is. Okay. I'm gonna get this printed out. Old book too, eh? 1919, I think.
Yes, if you jump down to the page 3 there, and under privity as regards to the steady key use, it says, the end of the first paragraph says, and for the like reason, the use was not asset, was not subject to forfeiture, and on failure of heirs in the inheritable line, did not cheat the Lord. And
Sorry,
the Lord,
what's
the Queen, or to the United States, then it does cheat to them. And it doesn't.
well, I forgot what's his key again.
As beneficiary. If cheat means the king is taking it because he's king. He's cheating you.
Literally. Holy crap. Yeah, I knew it was one of those words that just doesn't fit my head right.
They're
I
doing
looked it up.
feudal trust law on you, and you don't understand it.
Yeah. And for like reason. Use was not, and for the like reason, the use was not assets, was not subject to forfeiture. And on failure the heirs in the inheritable line did not escheat to the Lord. Did not escheat to the Lord. Okay, so there you go. Failure of heirs.
All right, now on page 4, it's talking about the trust applying to the chattel, or trust applicable to the chattel. And it talks here about the definition of a simple trust. Oh, excuse me, it's on page 2 there. Trust simple or special, where it talks about simple trust defined. A simple trust, and then jump it down a line, says, is a confident, or the confident is a relationship, not issuing out of the land, that's the title, but as the thing, that's the res, collateral, annexed in privity to the estate of the land and to the person touching the land. So that is to say that the tenant use should take the profit and that the tenant should execute an estate as he should direct. But anyway,
wow.
What I pointed out was it is not issuing out of the land or the title, but as a thing, res. That ties in with what we just read there earlier about the king. And for the like reason, the use was not an asset. Not an asset, it's a thing. And it doesn't have to have a value. Under debit credit, it's going to have a value. But under trust, it's not a value, it's a thing. It's not an asset, really. It's chattel. And that's not subject to forfeiture. And it can't eschew to the Lord either.
Because it's not the beholders to give.
Yes, it's the grantor.
Yeah.
And
there's a three-party. Okay, so it's like you got to think in terms of three-party relationship. This guy was sort of right.
Yeah.
So we won't use the word contract, but a three-party relationship.
There is no contract. Every time they talk contract, it's trust.
Right.
Welcome to MGP.
into the
about relationships they were forming, not contracts. They're all relationships. They're all trust relationships. They're not contracts. They're colorable contracts. They're functioning. They're trust functioning as colorable contracts. It's a colorable contract hiding a trust at the core.
What would be a good prerequisite thing on general trust? Obviously, besides the books that you got here with Gilbert's and the UCC and so on, is there anything like a real simple, stupid on my first book of trust or something like that?
Well, you couldn't read Carlton Weiss's Handbook on Trust.
Yeah. Okay.
By Albert Adapt that he has come out with. That was years ago. I first read that. I thought I wrote it.
Albert Adapt. What's it called again? Trust.
Yeah, just look up and do Google for Adapt and Alfred Adapt and just type in trust and you'll probably get it.
Alfred Adapt. That's the Andy Shyster guy.
Yeah, Andy Shyster, right.
Well, I think I got his there's a little PDF with it. I just picked that up.
He's written about 4 articles concerning trust.
Yeah. I got something like a 30-page PDF doc somewhere.
Yeah, that's about the longest one. The other ones are shorter.
Cool. Oh, yeah. Okay, great.
That's done. Oh, man. If I get the website back up, in fact, let's go off my website then.
He's the Alfred Dask. I remember him. He was the guy in Winston, Texas seminar. He said he said he's a smart guy. Because I think I got good grammar when I read stuff because I've read so much I can pick out grammar, typos, and just jumps out at you kind of thing. Although these second English language kids, they know all the words for it, like adjectives and pronouns. Yeah, I have no clue what they're talking about, but I can just read it. But he's the guy who said you can't use the word man in court either because he said, am I reading that right? Man and other animals? And he had that big case.
Yeah.
So I stick with living soul and stuff. That's another thing. I won't say I'm a man in court unless you define it specifically.
Well, that's too much truth, and I can't hear that.
Yeah.
You have to get a CCI information.
But they've redefined the word man even. So you can't use human being, individual, person, not even man. Don't say you're a living man because you just put yourself as an animal. But I just get really caught up in all the little. Now that I consider myself a jurisdiction dude, I just keep digging. There's always a little bit more.
I keep just expressing the trust and merging the titles. I don't have to really put up with all that stuff.
Wow. Yeah, this does sound. What was really interesting, I was trying to say, is like, I even though this is a whole turn, I don't feel bad for all the stuff that I've learned because, like, it's giving me frames of reference and I can see the superimposition of it.
Right.
And I'm going, whoa, something can't fit this well on so many different things without. And it actually brings clarity. It's like a secret code or something. It's really wild. And yeah, it's both simple, but it's subtle. I use the word subtle. It's not complex. It's subtle. Because it is fundamentally simple, I believe, once I'm gonna get this. I know I'm gonna get this. But also it's very dynamic. That's another aspect that confuses people. They just want to know, just tell me the one thing I got to say over and over, that one piece of paper I fill out and put my name on it, and it's never going to be like that.
Well, that doesn't understand it. That doesn't get you there.
Yeah.
It's fiction if you're not censored. If you don't know and understand what they're doing under trust, then you're the fiction. You're operating as the fiction and don't know it.
Yeah, that makes sense.
They're tricking you into commingling the trust and breaching the trust and throwing you in jail for breaching the trust.
Yeah, it's always contempt, isn't it?
Yeah, and in fact, you're even doing it yourself by fixing sometimes apples and oranges.
Well, this gets back to the thing, though, the vital statistics. I'm trying to This guy he's talking right now is focusing on his interpretation of what he thinks is going on with the what they're offering us. You know, when they're saying, when you think about the volume of meaning in terms of the words entitle, recognize, and the name, you know, when you're entitled to be recognized by the name, that sounds to me like we know that recognize, one of the things it means is well, I can't say contract now. Oh, I got so many people telling me so many words I can't say anymore. Somebody's telling me not to say money anymore. Can't say that it's my birth certificate. Now I can't say contract. But it's inferring, an offer, an entitlement to, a trust, I guess, right? It's another trust, is it?
Well, they're giving you entitlement. Entitlement's really nothing more than a benefit under the UCC. Article 9, 500, I believe it is, talks about entitlement.
Okay, let me look up this word because they're using the word recognize, and it is a big court word, recognize. And I wrote an email and I pulled out all the definitions on recognize there and entitle, and just because I was focusing on this BC thing. And cognizance. Okay, just maybe back up a bit. Cognizance, jurisdiction, or the exercise of jurisdiction, or the power to try and determine causes, judicial examination of a matter, or poser, and authority to make it. All right. Now, if you go to Black's Law 4, the only words you got for anything based on recognize is the cognizance, recognize, recognized, and then recognizee and recognizor. So it all basically goes around with cognizance. And it says here, it's a little bit hard, but I'm getting it, that an obligation of record entered into before some court of record or magistrate duly authorized.
And debtor creditor obligation under statutes and codes.
So, okay, so what you're saying then is in the Vital Statistics Act, they're hiding again the trust with debtor-creditor language.
And how about the Black's Law identification of interest? Identity of interest is under civil procedure as a relationship between two parties who are so close that suing one serves as notice to the other so that the other may be joined in the suit.
Sorry, what was the word?
Identity of interest.
That's a term in Black's Law?
Black's Law, yep.
Identity of interest. So wait a minute, now it makes sense because...
What relationship is that? That's debtor-creditor relationship.
That
is two parties who are so close that suing one serves as notice to the other so that the other may be joined in the suit. That's debtor-creditor relationship.
Wow. So, and the reason.
Now, what other kind of trust? Well, what other kind of relationship do we want to have? We want to have a trust relationship, not a debtor-creditor relationship. And the elements that are there for the debtor-creditor is missing one to make it a trust. And they all look similar when you're looking at it, unless you knew what the elements were. And that's where Gilbert was talking about relationships in there early on at the beginning. Trust distinguished from similar relationships and the characteristics and the terminology that control it. And it talks about on page section 27. Section 27 is the similar range of rights and responsibilities, including fiduciary duties and obligations, may be found in a variety of other relationships that are, in varying degrees, somewhat similar to trust. That are credible, but which lack one or more of the essential characteristics of a trust. And it is often difficult to ascertain where the parties involved intended to create a relationship that is recognized in law as a trust because the use or the failure to use trust terminology is not conclusive of the parties' intent. And then they talk about bailment. They talk about the principal differences between bailment and trust. And then go into agency. And then they go into the debtor-creditor relationship. And a few others then.
So I just fell off. What terms were you reading there?
The terms? What was the last thing you heard there?
You're just saying that it was like a trust, and they're basically talking all around it, basically. They're giving you the pseudo trust, essentially, knowing that you're going to play with it and never figure it out.
Yeah, it says it's somewhat similar to a trust, but which lacks one or more of the essential characteristics of a trust.
What's that you're reading?
It is often difficult to ascertain whether the parties involved intended to create a relationship that is recognized in law as a trust because the use or the failure to use trust terminology is not conclusive of the parties' intent. So you got to know the elements, what forms the relationship, whether or not it's a trust or whether it's debtor-creditor. Because if you're missing one of them, it's not a trust.
I always say that you got to learn even how to read the definitions because, these books are written by Masons and they don't really want to come right out and tell you exactly what's going on. They kind of talk around issues sometimes.
But the two relationships look very similar. You can't really look at it on the surface. It's the characteristics you got to look at.
Which they're kind of telling you there. What is that term, though? What are you reading from there? What is that?
I'm reading from page 6 of the book, Trust Distinguished from Similar Relationships.
Oh,
and this
okay.
is number one characteristic, not terminology, it's controlling.
That's another book, is it?
No, that's Gilbert's Law Summary on Trust.
Oh, okay. Sorry, page 6. Okay. Oh, boy, I got to get that book. I'm going to have it in a week. I should have got it earlier. It was hard at first. I wasn't sure which edition you're talking about. And the thing is, I just realized too now, this guy that's the Vital Statistics Act. So the acts are a layer basically designed to make up all this debtor-creditor stuff, and it's a cover.
Yes, it's hiding the trust.
So, yeah. Acts are laws.
Okay.
So how do we find when somebody's giving me, because actually he was going on about all this recognizance and recognizance. Now I see what you're saying about debtor-creditor. But then I just realized, we're shuffling around inside this act, which is fine. And I'm sure that if we analyzed it and we knew what the underlying trust was, it's going to superimpose again. But so where is where is the fundamental? I remember you talking about, and that was another big wow. You were quoting out of the text that you can have a trust is a thing. It's a concept, really. It's just like a fundamental principle of civilization or something. The trustee, the grantor, the beneficiary don't necessarily know. It just comes into being, right?
It's a relationship.
It's a relationship. Yeah, it's like an observation of something in the real world.
The relationship between trust res and the trustee, granted by the grantor for the benefit of a third party, the beneficiary.
When you say the res, are you just talking about some kind of real physical property?
No, the res is the signature.
Oh, the signature. Oh, okay.
Under debtor-creditor, it's the signature.
Okay.
They're all the signature.
Oh, yeah. I know it revolves around the signature. That's for sure.
That is the trust res. So by trust, you can pull out debtor-creditor, pull it away from debtor-creditor, and treat it as a trust. Pull it right out of the debtor-creditor realm, use the trust. They're not even in their law form, which is that law on the public side. Now, trust is operating in equity, an equitable
page 16. It says that legal charge as a, oops, that's not right. One more page.
What page? 16?
19. Equitable estates and rights are now to be noticed and acted upon in all courts where there is any conflict between the rules of equity and the rules of common law. The rules of equity are to prevail. That's your higher law form. Equity is higher law form. That's where trust operates.
That's almost the opposite of what Winston and those guys were saying. Oh, we're starting out in admiralty and they're always trying to drag us into equity.
That's trust. They're getting into the trust because they're dragging it into equity and using the trust enforcement.
Yeah, that's see again. There you go again. You see, this is the crazy thing, isn't it? It always fits.
Page 2, it says here, in order rightly to understand what was meant by the rather technical description of what we talked about in this above, we shall briefly consider the principles that were recognized in courts of equity, for these had exclusive jurisdictions of trust.
What page you on, sorry?
Solely in equity. Trust is equity.
Sorry, what page was that?
Page 2 on the...
Oh, okay.
Right in the middle before the confidence in the person. 1, 2, 3, 4 lines. Courts of equity. For these had exclusive jurisdiction of trust. The trust operates solely in equity, and that's how admiralty is enforced when it goes into equity. It's in trust, really. So here we're on the admiralty game. No, it's trust.
So he was right again. Winston was making these observations, but he wasn't putting the whole thing together. Why they were trying to drag him into trust. I could never understand. I was trying to learn all this, learn all these words, and so I keep these things in my mind because I know someday I'm going to go back and I'm going to retrospect these things. You know what I'm saying? So this is so cool. I'm just a creature of logic. But I can't wait to, well, I'm just going through all your stuff. I'm going to go through all your hours and catch up to you in real time. And I hope, that exposure, plus I'm going to read this, Alfred Dask. Somebody just sent it to me, so that's karma right there. I just got that 2 days ago.
Here's where the real kicker comes in. This is real power comes in trust. The burden of proof issue. That's one of the most significant distinctions and characteristics about trust, is the burden of proof issue. If a beneficiary makes a prima facie case, which is easy to do, all you need to write an affidavit, make a claim or charge. The burden of contradicting it or showing a defense will then shift to the trustee. Part 871 at 156 and 57, and also Scott on Trust in section 172. So the party claiming trust must satisfy the threshold burden, and then there's no obvious transition from the threshold burden phase to the substantive burden phase. However, when the party claiming the trust is the beneficiary, what happens is what is referenced as to a shifting of the burden of proof. Thus, where it is the beneficiary who's asserting the trust, or who's claiming the trust, then the beneficiary is expected to be the party who files the suit of the claim, because the threshold burden of proof is on the beneficiary. Once the beneficiary satisfies that threshold burden, the burden of proof shifts to the alleged trustee. And what does the trustee then have the burden of proof? The trustee then has the burden of proof compliance or non-breach. So the point to make here is about the evidence that the burden of proof is that once the threshold burden has been satisfied, the law of trust presumes that the trustee is wrong or is guilty or has breached the agreement, as it were, and the trustee he must prove that what he did was consistent with the trust agreement, the indenture, or the grantor's will, and with the applicable trust law. So thus in the civil context here, under debtor creditor, for example, the trustee is quite literally presumed to be guilty or presumed to have breached, and he must prove
within the terms of the trust and within the applicable trust law and not guilty. And the only way he can do that is if he has a record that he made a payment. So all I got to do is come in as beneficiary, make a claim, and the court of equity automatically assumes he's guilty and I'm prosecuting on that basis alone. And the only thing a guy can say is, did you make a payment? Where is your record of a payment? When are you going to make the payment? That's all they're doing in court today. They're doing that to you, so we're using that against them. We're using trust. Welcome to NTT.
Wow. I don't know. I hope. I think, I don't know, how do you phrase it? When you have an ear for what sounds right, an ear for what is true, you know, I guess there has to be some place I don't think some people have it, I guess. I don't know. People get too many preconceived notions or something. That's a lot of logic you're throwing at it. What reference were you making with the supremacy of equity law over, was it contract law you were saying?
Yeah, that's just burden of proof civil law that really it shifts.
Now, that's almost a maxim, is it? I take it. I mean, that's not even to argue that equity is.
Yeah, that comes into the trust law and Bogart and Clause, and they're restatement of seconds on trust law.
Okay. Wow. And then you make a lot of reference to. Well, you make earlier. I don't know. Again, like I'm just sort of getting into up around November. You were making a lot of reference to UCC a lot, but then you're talking about black and white or something. So, you know, you're still making reference to UCC a lot, right? For reference?
Yes, I do. Yeah, because UCC is nothing more than debit-credit relationship. So that's what we're fighting all the time. That's getting us to form under our law venues. That's how they're proposing them.
And I'm going to guess that UCC just fits perfectly over top of this thing.
And a bunch of other relationships too, like admiralty or.
Well, they all do, exactly. Like, yeah.
It's all revenue.
Yeah, okay. Yeah, because it never said in the four types of law, I forget what you said. There was natural law, and then there was common law, and then I forget the third one, but then there was commerce, and then I guess admiralty or something like that, political law. Nobody ever told me there was a trust law.
Must be decades. We're like the bull fighting a bullfighter, but the bullfighter keeps on dangling this red cape in front of us, and we keep on charging the red cape. If we're the bull, if we would ever get in that our problem is not the red cape, the debtor-credit relationship, but our problem is the bullfighter, which is the trust, then the bullfighter is dead.
Yeah. Well, yeah. No, I look at it just, for what it is. It's, it's these, I'm a bit of a conspiracy theorist, and I think of the Vatican and the Romans, and people have a hard time grasping that the Romans never actually, the Roman culture never, it's not like Rome ever went down. It just transmuted itself into the Vatican and the literal wolf in sheep's clothing. And, these Romans had a philosophy, and it was the right to Say what?
Look up Tacitus Diminutitus.
Yeah, that has to do with the signatures and the uppercase, lowercase.
Yeah, capitis is capitalization, and diminution is diminishing of status by capitalization of the name. That's Roman law.
Oh yeah, it's Roman law. In the courts, in the hospitals, wherever they use doctors, everything we're doing is Roman law. The banking system.
They're operating under trust, and they're getting us to operate under Roman law.
Yeah, because they're really smart. They're not to be underestimated.
Or thinking they're playing baseball, and they're really playing football, and you wonder why you're getting beat up.
Well, they were the world power at one time, and they made a science just like the U.S. does out of militarism, and they came to the stunning conclusion that, hey, you know what, like, we are superior, and we've proven it, and we've got all this stuff going on, but, you know, they were economic geniuses as well, and they said, hey, you know, wouldn't it be cheaper if we just deceived everybody? You know what I'm saying?
Well, those that don't have those that don't know this way.
Yeah.
And you've been born all your life, and you were raised in a barn, and somebody comes in and says, hey, things in here, you don't believe them. So we've been born on the debt of credit of brainwashing, and we've been in this game so long, when somebody comes up to you and says, hey, you know, it's all about trust, you don't believe them.
Hey, Christian, that's exactly true, because I told somebody about you, and he said, well, I already am familiar with you know, what you're doing, and he said that he has an important part to the puzzle. And I didn't get a chance to ask him which part is the important part. That secret one-word concept, and you just get it, and then everything's magically figured out. Well, as far as I'm concerned, Christian has the last part to the whole puzzle. Oh yeah. It pulls it all together. There's nothing underneath trust, is there? You can't get underneath trust, can you? I don't think so. No, it's that concept, that one concept, I have to admit, that is pretty far out, because it reminds me of the Ayn Rand concept. Like, you know, where did man start from? Consciously, it was an objectivist epistemology, but it was like man's ability to impose a unit of measure onto nature. And that was sort of like the beginning of the whole conceptualization math process. And so these, I'm going to call them the Romans, because that's what I like to say. I see Rome everywhere, especially over here. But they conceptualized this trust relationship, I guess. I guess it's like, as long as you're in a civilization, there's always that hidden third party somewhere, I guess. You know what I mean? Does that make sense? Because it's not a contract, a two-party relationship. It's always a three-party relationship. And that's ingenious, because once they have that as the basic unit of this whole thing, right? Yeah. So they conceptualize that, and then the rest is just them building the whole math on top of this thing.
If God did that right at the beginning of Genesis. God was the grantor. He granted trust res, which was Jesus Christ, to the beneficiary.
Well, yeah, I mean, and this is it. Like, it's not like it's created. It's not purely fictional. It's a very fine line between a conceptual fictional reality and a representation of something in the real world, I guess I'm trying to get at. So I don't know. There's something very profound about the idea that this can come into existence without any parties being aware of it. In other words, it's kind of like it's like almost like a scientific concept.
Also, the administration, not just form. You could be administering a trust and not know about it. Formation and administration is none of the parties need to know.
Well, think about it like this: how long were we on the earth before we realized that the scrolls existed that put together the Bible?
Okay. But now, to enforce the trust, somebody would have to know that. So something has to change to enforce the trust. You would have to know and understand that there would be a trust.
It explains why they're so deceptive. They've overdone it, but they certainly they justified it. You know, although that's a very Roman thing again. But I guess it's kind of like a gun. It's really the user. And there's some aspect I haven't gotten into this deep enough to understand it. Like we got to go back to Alfred that, but there's a leveraging aspect of this, which is probably not a bad thing either. You know.
Well, come to realize that actually you're holding all the power before you have actually more power in forcing somebody not to breach the trust than afterwards. You have the power in your hands to prevent everything that's happening by trust. Because you go into a court of equity and give the equity to compel them not to breach the trust. That gives you more power all along.
Is that where you say make the claim as a beneficiary?
Yes, because if the trustee was going to breach the trust, the beneficiary could make the claim against the trustee that he's going to breach, and a court of equity would force him not to breach.
The highest or most comprehensive loss of status. This occurred when a man's condition was changed from one of freedom to one of bondage, and he became a slave. It swept away with it all rights, citizenship, and all family rights. Capitis diminutio maxima. So there's your slave status on the uppercase name. Is that
right?
So, but that uppercase name represents a trust, right?
Yeah. Right.
Now, true to debit creditor.
The trust, and you never expressed it to be a trust, and therefore you can't make private trustee payments with your private credit.
And if you handle that properly, though, I like the idea that this is interesting. Okay, because the way Dick Beck, he's a very insightful guy. He's an iconoclast. At least he's an original thinker. I respect him a lot, and he's brought me to this point, so I can't complain. And he's always talking about the concept of the signature and how, when there's one of his things that he studies a lot and uses as a reference. It was a case of a guy. This is a really interesting story because it always comes back and just, it hasn't quite been reduplicated like all these unique events, but I think he had an issue with the landlord-tenant thing. I think he went to whoever the government office looking after that, and he submitted, I guess he was getting kicked out, but he entered his birth certificate as interest into the record accommodation. Okay, he didn't have to move out, and they didn't nail him or nothing. And all because we started to focus on this and think, hey, there's that weird, there's always. I always said to people from day one, the best stories are the ones when the birth certificate shows up in the courtroom, right? Because all these what I call supernatural events happen, right? And they're just, you can't get enough of these. Sometimes they screw up, but some of the
Earlier tonight when we talked about the DFC?
Sorry?
Were you on the call earlier tonight when we talked about the DXE?
The EX, I can't hear what you're saying, the EXE?
Were you on the call earlier when we talked about DXE? Two words, DXE.
No, I think I got on around 10:15 about. What time did you guys start? I thought you guys were starting at 10 tonight.
At 10 o'clock we started, yeah.
Okay.
68.02 in Florida statutes and state in the United States. But number 4 says surrender is defended by surety. Says the surety of defendant has the right personally or by attorney at any time before the bond is forfeited. So with bond, we're talking about insurance, which is trust. Anytime the bond is forfeited, to take the body of the principal, and principal is really corpus or res trust property, and surrender him or her in open court, or deliver him or her
to the executive officer of the court, now that's the sheriff, who shall detain the principal, that's the res, as in cases for the surrender of the principal by special bail, special deposit. At the time of delivery to the officer, the surety shall take a receipt, maybe the birth certificate, for the body and file it with the clerk. If done before the bond is forfeited, the surrender or delivery, now that delivery is the formation of a trust, not a method. The surrender or delivery discharges the surety from his or her undertaking.
That's kind of maybe
Made a payment under trust. Special deposit.
What part of statute is that, Christian?
68.02 EXE. Number 4.
That's this. I don't know, but this federal guy come in and he said to the judge, "You don't have jurisdiction over this guy," basically. And Rick's interpretation was he removed himself somehow out of the equation, and of course, because the issuer of the birth certificate is the person who's responsible and is in fact the one being charged, so they had to pick up the tab.
The only one who can make a payment is the trustee. So if he's making a payment with the birth certificate, which is the record of the special deposit made by the mother, that's the receipt. Now, a certificate of deposit under bank handbook law says that the bearer of the CD, or if it's negotiable, which is private to public side, which is what the birth certificate is, that private public side birth certificate is the payment. It is payment by the bearer.
Well, there's this aspect though. I think you are entitled to be recognized by the name, and then let's look at the corollary. I'm trying to see how you translate this, because my current understanding of VegSuit is if you are entitled, and he said there's no law that's forcing you to be okay. Look at it this way: in a contract, I have to say, if you're entitled to be recognized by the name, when can you break that contract?
It's fine.
Any time, right? Well, maybe that's what it is. Maybe it's hiding. You're not breaking a contract. Maybe you're shifting into a different position on this trust thing.
Yeah, because I did not express it as a trust. Their offer turned into a debt under debtor creditor.
So this guy somehow pulled himself out of the trustee position, and I'm still looking. I have to still look at it from two different.
Trustee, because the trustee is the only one who can make the payment, and as trustee, then I can use the birth certificate as payment, because the birth certificate represents the trust res.
Well, these guys were at the time of I'm not the name, so he was basically submitting it or surrendering it back to the rental board, I think it was.
Mm-hmm.
And then when he went into court, he signed in as the alleged tenant. And then they asked him, and of course he didn't attach himself. So I know that's kind of debtor creditor talk. But and then apparently this is a real story. Like another guy walks in, he's a federal agent, saying to the judge, "You don't have jurisdiction over this guy." And then whatever happened after that.
You have to prove trust some way, because that would give him standing to make a payment as trustee. Because when a CD is a negotiable CD, the debt of the bank is to the legal holder of the certificate, and not the depositor. But you have to be able to claim a trust first and prove a trust, be able to make a trust deposit, which would make the payment represented by the trust res, the birth certificate.
What do you think happened? Then he surrenders it to the rental tribune. They get him into try to make a charge in court. He shows up, signs as the alleged tenant, thereby not accepting his entitlement to be recognized by the name according to the Vital Statistics Act. And then all of a sudden this guy pops up saying, "Okay, you don't have jurisdiction over this guy." And they're paying his rent. And I don't know, like I heard last week, he was living in his apartment for over a year without paying rent. Like not just a one-off. Like something got settled there somehow.
You take that birth certificate and endorse it just like the banks endorse a note, put on there without recourse, paid to, and leave it blank, and then sign your name, and then restrict it, and put your title in there and all that.
Really? A certified copy or the original?
Oh, the original.
Oh, wow.
Endorse the birth certificate without recourse, pay to, leave it in blank, now it's in bearer form, whoever you give it to, that's payment. Endorse it with your position, your office, by trustee. Just like the banks endorse a note, they make it in bearer form so they can deposit it into a securitization trust.
So now you know why. Now you know why the birth certificates are on security paper.
Mm-hmm. Because that trust res, the original deposit made by the mother. That was the receipt, the thank you receipt for the deposit. And that CD, that birth certificate, is in bearer form if you endorse it in blank.
Endorse to blank.
Or you could put a name in.
Or you could fill it in, but then when you give it to the other party, they keep it now in some kind of a security, some kind of safe, some special deposit maybe.
Well, that's special bail.
Special bail.
The surrender of him or her in open court or delivery of him or her executive court, that's the sheriff, who shall detain the principal as has been cases of the surrender of the principal by special bail. That's special deposit.
You could, that would almost be, oh my God, you could do that like if there's a literal example, like you bail in a court. You could endorse it, you pull out your birth certificate, endorse to blank, or endorse to the court.
But you gotta express a trust, prove a trust, and then claim your trustee in order to make the special deposit payment.
Oh, which is a UCC 1 on the birth certificate.
All right, look up Black's Law trust deposit.
Trust deposit.
Are you talking about the addition, the one out of the fourth Christian that has the word special deposit in it?
Let me find it here.
I bet that's what you're shooting for. Is it where money or property is deposited to be kept intact and not commingled with other funds or property of bank, and is to be returned in kind to depositor or devoted to particular purpose or requirement of depositor or payment of particular debts or obligations of depositor, also called special deposit?
Okay, excuse me. That'll clarify things for me, but I mean trust receipt.
Oh, trust receipt. Okay, well, you're looking for the one, the pre-UCC device definition, right?
Yeah.
I see trust deposit, trust fund, trust deed, trust receipt. Well, you know what? This whole Black's Law would be a study of trust. Holy crap!
Yes, it is. Yes, a pre-UCC security device not governed by Article 9 of the Code, consisting of a receipt. Everybody knows a receipt is a record of payment. The receipt stating that wholesale buyer has possession of the goods for the benefit of the financier. We're talking about benefit, that's trust. Today, there must usually be a security agreement. That's in a trust indenture, coupled with a filed financing statement. That's a UCC filing. And that is a payment.
That's where Winston must have got this from.
If you express it as being a trust, that would be a trust receipt or a trust payment. But if you don't express it as a trust, then they're going to construe the UCC filing as being a debtor-creditor relation for the next 33 years on your mortgage.
Oh. So he would...
All along it was a trust payment, but you never expressed it to be a trust.
So they're actually, well, they're doing something of a trust thing because they're doing the UCC 1.
You're in the first example of the mortgage, you're being offered whichever path you want to take, and you're choosing the path.
Yeah, I heard you say that.
Or you can choose the trust path.
That's scary.
He was paid the moment of closing. If you choose a debit or creditor path, you're going to owe for the next 30 years.
Yeah, there you go. Simple as that.
But your UCC filing was a record of a payment under trust. Or simultaneously could be a record of a debt. You choose.
Christian, I got a question.
How you doing, Eric?
Great, thanks. I was going back to the basics of it and reading methods of creation, and I understand declaration and transfer really well, but by appointment, where might we run into a situation where we might do it by appointment? And I was just wondering if you had any ideas that you could turn us on to in a private situation. For example, would we want to appoint anybody, for example, in a court case, or would we just want to do it by transfer? Would that be just a better method for claiming and proving?
Well, the proof is one method I want to use the UCC transfer method because that's a record of payment under trust receipt definition.
So for that reason, appointment is a poor method of creation.
I think so because I don't see too much in appointment or contract. I see more in transfer and declaration.
Yeah, I wasn't even looking at contract, but in thinking about appointing or ordering, for example, the clerk to be the trustee and leaving the judge there for enforcement instead of assigning the judge as trustee. I was thinking.
That's kind of weak, though. The appointment's kind of weak because now I've got no records say that I've created that could prove send him an appointment. So like I said, the UCC 3 could be the assignment, and by assignment he's already got it. And I got a record, so I'm simultaneously doing a lot of things with the transfer where appointment doesn't have all that available to me.
Okay. And of course, when I read appointment, I think about how when we get people elected into office, or the Electoral College elects people into office, forgive me, and then they make appointments. Well, those are all just trust relationships, aren't they?
Yeah. Right.
Okay. And in thinking about appointing the clerk, and when I say the clerk, I mean the elected official, and I hope I'm thinking of the right person, for example, in a court case to be our trustee, in order to utilize the judge to be a neutral party that can still help us enforce. And the reason I'm thinking about that is because the clerk already has our special deposit, our res, our signature, in their possession, because that's who the custodian of the records is to begin with. Would it be appropriate to think of the actual elected official as the person that we want to appoint or that we want to transfer res to?
What was the last part of the question? What?
Would it be appropriate to transfer res to the elected official? For example, let's say we have a guy that's named Phil Smith, that is the elected clerk by the body politic, by the voters in the area. Would it be appropriate if we wanted to transfer res to that individual instead of somebody within the clerk's office, for example, as trustee?
And trustee, or just give him res?
Well, let's give him res and assign and order him to be trustee. Because he's already in possession of it, because he already has our signature, because he's the custodian of the records.
I'm looking at that closer to the bank.
And I think I would rather be trustee myself so I could make payments to the bank, say, and then notify that I made payment to the bank, the other entity that wanted payment, and tell them, hey, go check with the bank. It was done through the court. That way I'm trustee. I have expressed the trust. I've claimed that I've the trust. I make the payment as trustee.
So I make the payment to the
Clerk, who's the bank.
So who's the party that really wants payment in a court case? How do you actually even determine that?
You're the one making the offer. And who did pay?
the offer, for example, would be the sheriff's department when they give you a traffic ticket.
Yeah.
Okay. And the sheriff himself being a officer of the court, right?
Yeah.
So then, him being an officer of the court, that would mean that the court would actually be the one demanding payment.
If we're going to the prison because we didn't make a payment because we breached the trust, why don't we just stop going to prison and make a payment? But the only way we can make a payment is as trustee. In order to make a payment as trustee, we got to first claim trust, approve trust. Then we have the office as trustee to make a payment. Make the payment, you don't go to jail. And I can make all kinds of credit payment as trustee. Otherwise, if I'm trustee in a debtor-creditor relationship under consumer, then I'm going to be required to make Federal Reserve payments, which I don't have a lot of.
Oh, that's where you want to become grantor and appoint yourself trustee because you give yourself more powers?
Well, I don't have to appoint myself trustee because I've already appointed myself trustee on the 1040 form, except I've never claimed trust, so I can't claim I'm the trustee. But I really am. And that's what the courts are assuming. And they got the evidence to prove it because I've self-appointed myself trustee. I make it on the 1040 self-assignment, etc. I've appointed myself trustee. And they got all the documentation to prove that. And I am trustee. If I get into the debtor-creditor thing under the guise of debtor-creditor, but they're going to get me under trust.
Where's the point? Sorry, where's the point where you can allow yourself? You're saying like if they construe you, you've got to pay Federal Reserve notes. But where's the part where you get to? You know what I mean?
Where's the part where you get to make a payment? Is that what your question is, sir?
Well, but as in the form of a trust type, instead of using Federal Reserve notes, instead of basically signing it back to them or transferring it back to them.
Yes, although we're trustee under a misconstruement of debtor-creditor, we don't have the right to make trustee payments until we make an expression of the trust and prove the trust.
Oh, yeah.
And we are trustees, and then we can make the payments under with our private credit. But under the agreement, since we didn't express it to be trust, they know we're trustees. But they're coming at you under debtor-creditor, or whether you're doing it yourself, and then they're going to throw you in breach of the trust because you didn't make the payment the way they're required with Federal Reserve notes. They're going to send you to prison as a trustee.
Because they got the prima facie case to do it.
Yeah, you're creating all the evidence you're on the debtor-creditor. You don't have any stuff to prove wrong.
And they can jump back and forth between debtor-creditor, construing that, and then still basically incorporate enough trust there to say you're the trustee, though.
Right.
Well, but they never reveal that to us. They leave us under debtor-creditor. They leave us thinking under debtor-creditor.
Right.
Right. Of course. Oh, man. It's just, you are consistent, if anything.
And another thing I was looking at under creation, under inter vivos and present versus future transfer, Christian.
Inter vivos transfer. Okay, what about it?
Well, just thinking about for creation and when transfer actually takes place compared to future, is there a case where we would want to employ future transfer in the context that we're talking about as an offensive strategy instead of a protective strategy?
The contract.
Not the future. So what you're talking about, that would be a situation. Future transfer would be by contract.
Yeah.
Okay. So that's really not it's not really appropriate for our offensive methods here.
You need a present transfer now or in the past.
Okay. I just wanted to make sure if that applied, if it did or didn't apply to future transfer, and obviously by your statement it doesn't.
Until the trust was formed, you couldn't claim breach of trust because the trust hadn't been formed yet. So you got to come at them with breach of contract. Now you're under debtor-creditor.
Right, you put yourself right back on there. As we find out again and again. And I got to say that with all the time that we've spent talking and listening, go back to the most basics of this and still glean more questions. So for this new gentleman on the call, please keep going back to the basics because I promise you're going to keep gleaning questions out of it.
Sure, that's what Yogi Berra used to say, wasn't it? I'm a big believer in that. I'd rather just spend all my time in the fundamentals. And if I can get that done solid inside out, I mean, I'll figure out the rest, you know. But I was just thinking of another fit. That's what's going on when we say, do you have an oath of office to the judge? And I guess I accept your oath of office as still a form of contract, is it?
No, that's a trust.
Yeah, there you go. So that's another thing, right? That's another big deal thing I never understood. You know, why is that such a big deal, right? But you know how they talk about that, and they say, oh, you know, did you ask them if you had an oath of office? And I think you got to do the same thing. Funny, you made me think of that too, because you were talking about some like the government official. Again, they say these people get away with it because we don't ask them if they have an oath of office.
Yeah, you have to be very careful about the relationships because they all look very similar.
This is what's going on. Yeah, this is what's going on. They have hidden themselves under many different levels, it looks like.
Eric, I dropped off when you started talking. I forgot what you were saying there about.
I actually had about a 30-second drop out myself just now, so I heard the last thing he was talking about oath of office, and then I don't know what happened after that for about 30 seconds. So.
Yeah, you dropped off there, and you were talking about everybody was studying the book or something.
Well, it was just some basics I was going back to that I was reading over recently, and I'm good right now. It was certainly that oath of office is the trust, and it actually made me think about if the judge is actually acting, because let me say, is the oath really a private instrument that the judge does?
It's a colorable oath.
Oh.
He doesn't have to have an oath.
More deception.
Yeah.
He doesn't have to have an oath, even though the Florida statute says they're required to have one.
But that's exactly what it is, a statute. As Menard always says, acts and statutes are not laws. That's the whole gimmick. It's just another layer of crud.
So unless we make a prima facie case under trust against them, it's all colorable is really what it is.
Yeah, right.
Okay. So it's for their purposes in the moment, for their corporate gain.
Yeah, and I have to learn how to operate that way too. Everything is a fraud, yeah.
Okay.
We're
not true. Fraud's not illegal, right? If it doesn't harm a real physical living soul. Because I remember that was one of Winston's favorite things, right? Because this is all colorable and it's all fictional. We're somehow harming ourselves, I think.
Yeah, we're the ones doing it all. We're empowering them to do whatever they do to us.
By failing to express trust.
Yes.
By failing to express sentiment.
Yes, right. They construe it under their own bias sense to do whatever they feel like they want to do because you didn't express and give them the rules. Because you are the case law, but you never express it in the trust.
So you still hold to the earlier stuff where you're talking about the constructive trust and the implied trust. That still all stands, right? That's still all part of this understanding, right?
Yeah, they're implying a trust to be debtor creditor.
Oh, you can have you can have a. Oh, right. They're implying, right? They're construing the trust into a debtor creditor contract type thing.
Yeah, well, they're really tricking you into it.
Yeah. Okay.
You're expressing the debtor relationship. They got all the documents you signed.
oh man, oh man. This is cool. I guess pretty soon it'll become a mantra, right? To always be looking for where the trust relationship is and how to establish it and how to express it. And
that's your go to the signature.
That's when the present transfer takes place.
Yeah.
So even if it's a previously signed document, and you can always say in court, can I see the signature document, right?
Yeah, who signed it? Did I sign that? Yep, that's my signature on there, all right? That's my signature. Except for one thing, I'm a grantor on that. In the private.
Oh, yeah. Just like that. Just like that. And then if it gets too heavy, you can always say you need to exhaust all your remedies, right? And you can go out and do your UCC stuff.
Put an in-camera hearing, and I'll show you why, I can make a payment.
And then if they deny you that, Kristen, then they deny you due process, right?
Yes, right.
Now, one of the things you just said, one of the things I was thinking about a few minutes ago, is we haven't talked about the Steady K Trust in a while. And when you say go to the signature, well, when we were babies, we didn't sign anything. When, for example, our mothers or fathers applied for a Social Security card for us.
Mm-hmm.
So when you say go to the signature, are we going to their signature on the SS5? Is that what we're doing?
Well, you can always correct the Social Security and make it your signature. Just fill out another SS5 form.
And the SS5 is your SIN, or your SSN.
But that's also proof that I'm a beneficiary on that trust.
You were talking about the birth certificate, right?
Now, I'm talking about Social Security now.
That's the Steady K Trust.
That's your proof that the grantor and beneficiary, because now I can come in and I can make out that application form, sign a grantor. When I get the little card back, I sign the card. How am I going to sign the card? My beneficiary. So now that's the proof I need to establish that I am a beneficiary on that trust.
And you're still the grantor?
And now I can come into court and make a claim that I am beneficiary when they construe it that I'm trustee.
Steady K Trust, he who has a right to a beneficial interest in and out of an estate, the legal title to which is vested in another. When they say in another, who are they talking about?
That's the beneficiary.
That's confusing.
There's a lot revolves around your social card.
The Steady K Trust, because it's the beneficiary trust, because the beneficiary is the real owner. And the same thing as what they put on the W8 bin on page, 7 of the instructions.
Right, but the thing I don't get about the definition, it says, he who has a right to a beneficial interest in and out of an estate, the legal title to which is vested in another. When they say another, who are they talking about? That's the thing I'm missing here.
Trustee, that would be the trustee. That's possessory title, legal title.
Okay. Now I understand. Because it's under the three party. Okay. So,
it's that 11 on some.
And that was what?
Page 5, I believe. Yeah, page 11.
Oh, in Gilbert's?
Under definitions, under the W8 bin instruction.
Okay. So,
my official owner.
Oh, okay. So the Steady Key is Social Security and the foreign situs is the birth certificate.
Right.
Okay. And these are two types. Pardon?
Birth certificate is the foreign situs trust.
Which is the private and the Steady Key is the public.
Right.
The duality that we talked about before.
Right.
So with all this understanding that I have now that I didn't before, maybe we could talk about this. And so you were talking about that we want to terminate the titles on the Steady Key, or merge the titles to terminate that trust to disperse it.
Right.
Okay, so then that way we don't have a public face for them to go after.
Right. That's why you need an LLC to interface back in with, or a corporation.
Okay. But we can't merge the titles on that until we claiming something besides being trustee as we've done on our 1040 by correcting our IMF.
Yeah, you need two titles to merge, and you just said the two titles, the foreign status and the city key.
Well, when we say two titles, these are two separate trusts.
There's a relationship between them, isn't it? Like, isn't the SDK created?
One's in a private.
Yeah, one is derived from, isn't it? Like, I mean, it's the basis of the foreign situs that allows you to create this SDK in the first place, right?
Yeah, it's either that way or this way. The foreign situs is a spillover trust, which 18 spills over its assets into the city trust. And then on the private side would actually be the live birth certificate compared to the birth certificate on the public.
I mean, they're starting to assign your social insurance, social security number for you guys, I guess, right when you're born now.
Yeah, so the foreign situs, which is the birth certificate on the public, then spills over into the social security. So if we merge the social security and the live birth certificate, it could be that way also.
Yeah, I've heard of that. There's more consistency there.
But I'm confused. If we're talking about, we got a setting key as one trust and the foreign situs trust, so foreign situs is a separate trust, then each one of them has a grantor, benefit, and trustee, or beneficiary and trustee, correct?
But it's a spillover trust. It spills over upon maturity into the other one.
So does it, because it spills over, does it terminate because it spills over, the foreign situs?
Well, I'm not sure whether it terminates or whether it just transfers all its assets into the social security.
But what you've been consistent about all the way since the beginning of November is that we want to merge, for example, beneficiary and trustee or grantor and trustee in order to terminate to disperse.
Right.
Okay. So if we're going to...
Title. Is it going to be the live birth certificate and the social security, or is it going to be the foreign situs birth certificate and the social security?
But I'm confused. If the foreign situs is a trust that stands by itself, and the static key is a trust that stands by itself, then each one...
If there's a spillover trust, they're connected.
Yeah, I don't think they're separate. And I just thought, I was looking at it before like it was like a chain of logic that you know, you've got the statement of live birth, and that is basically a record of an event of the birth, right? The measure and the weight, it's all the information. And then you've got the birth certificate, which is derivative or derived from. That's all I'm just sort of putting out there. And then obviously, you know, what you use to get your social insurance is they want to see the birth certificate. So, I mean, you've got the chain of connection. That's kind of one way I look at it.
So if they're connected, then they're really one and the same? Is that your deduction?
For me?
No, Christian.
That's what it looks similar to me, that with the spillover, they're one and the same. If not, then we'll have to treat it differently and merge the other titles.
Okay, that clears up a lot, because I was thinking these were two actually separate organizations or trusts, and each one of them had the three parties.
I think they did that to make it so that they could get another trust going and they could create some more benefits and get you to sign on that one, and they could create more assets and things under the debt system.
So
to go back and to terminate those, if they are one of, however you want to say it, what you're like, I guess what you're saying is it's really one trust where the assets for the private really spill into a public account, but they're really one and the same.
Yes, right. And to take care of it all, what we would do is merge all three of them in one.
So you're using res as the assets in the private again. I thought you were saying it was a signature again.
That is the assets in the private.
Yeah.
Your signature is assets in the private?
It comes from nowhere but from the person who sent you.
Okay. Well, okay. I thought, all right. Do you guys look at the birth certificate as the whole thing about being a bond and a security? Essentially, it was a bond created against some kind of actuarial value of your lifetime of labor, right? Are you guys looking at it like that?
It's the signature.
And then your signature is like the representation of it, or
For my future labor. Yeah.
Right. Okay. Yeah. What's that saying? They used to say, my full faith and credit.
Yeah. My bond is my word. That's my trust.
Bond is my word. Okay. Wow. Okay. Gotcha. All right.
So we could use the word bond as another word for bond is obligation. So when you sign, you oblige yourself.
Bond is the trust. So the promise.
Bond is, yeah.
I promise to pay. My bond is my word. Bond is the trust. As a promise.
I asked a banker once what accepted for value means, and he told me that it meant I promised to pay.
I don't know about that. I promise to pay on accept for value. No, I think you're creating a counter debt that you're going to agree to use a discharge with. You're going to discharge the public and do a set off on the private.
Okay, that's what he said, though.
Do you know if that's in Black's?
How can a debt be created and pay another debt? So all we're doing is double debt. We're just mounting up more debt. So we're here again, all wrong under the debtor creditor split.
Yeah, then again, he's a banker, right? That's his whole world. So to him, debt is money.
Yeah, that's what they're using as money. That's two fifths. And money credit velocity out of the Fed Federal Reserve.
So our signature is more powerful than their debt money.
So that's what creates all the debt. Our signature.
If it wasn't for our signature, there'd be no debt.
Ocean.
Winston, what did he used to say? Your dishonor creates the funds in the involuntary bankruptcy.
Yeah, that's debt relative.
That's debt, yeah. I never quite wrapped my head around that, but what he's getting at there. Well, I guess when
debt creates and pay more debt that was, so just double debt. It just amounts up, and they love us for that.
That's right. When we pay with cash, we're dishonoring them. Because the cash is really, those currency notes are really just debt notes.
That's right.
And they love it for us because they can continue to enslave our future generations, and that's their goal anyway.
Oh, this thing's got to bust. It's going to bust. They want it to bust. The U.S. economy they're going out of their way to try and bust it. So that's the question is, why are they doing that? What's the game there? Anybody been looking at the macro picture here?
Yeah, it's obvious. I know exactly what it is. It's because if it busts, then they get to steal our wealth all over again.
Yeah. They want to bust it. Yeah. And then put it into a barrel and leave the Chinese in the Middle East on the hook and then own everything. Yeah, like that. Please stay overnight. U.S. China, Middle East on the hook. Less holding the bag.
Just like when Rothschild's messenger came back from Waterloo and said, we won, but Rothschild sold, so everybody sold.
Yeah.
You know the old story, right?
Yeah, right out of Endgame.
Then there's always the prescription that the act of establishing authoritative rule, and it's also the extinction of the title or the right by failure to claim or exercise it over a long period. That's what they're doing.
Yeah.
They're going to use your right for payment.
And people got to learn that this is the antithesis to this whole thing you're saying, essentially.
Oh, now what's the solution to that?
To what? What do you mean? Sorry?
The solution to the prescription.
Well, I think this is expressing the trust and standing up and taking control of it again.
Yeah, but there's something comes in before that.
Okay, first of all, let's define what the problem, because we were talking about a big, giant macro thing, but essentially we're saying, they're making us pay with debt notes, and they're fooling us, and everything is a deception. Let's face it, everything, right? I mean, everything. And it's just health, science, nutrition, government, banking, history, everything, right?
Well, what kills prescription is acknowledgement of debt. An acknowledgement of debt is recognition by a debtor of the existence of a debt.
Oh, yeah, you were talking about that in one of your...
Acknowledgement that interrupts the running of prescription.
Because as soon as you acknowledge debt,
there's no controversy.
There's no controversy. But then you're still on the hook then, right? Because it's like, okay, great, you acknowledge debt, now you owe us.
Okay, now express the trust and now make private credit payments as trustee.
Because you can't make payment with debt notes.
You can't make payment at all. That's right, because there's no contract or there's no money. Right.
Well, there's no trust. You're not expressing the trust.
Yeah, so it's a two-step process then. Is that what you're saying? Is that the step? The acknowledgement of the debt?
Acknowledging the debt and issuing an order for payment.
We're an entire nation living in denial. What is one of the biggest things going on right now? I mean, I see it and it sickens me, right? We're in a spiritual bankruptcy right now.
Yeah, we're insolvent. We're not making the payment. Acknowledge the debt, make the payment, but first express the trust.
Everyone lives in fear and denial. Is it not true?
Sir, what's your first name? I'm sorry.
Shane.
Hey, Shane, I'm Eric.
Hey, Eric.
And I'll tell you right now, as Christian has stated before, they will never acknowledge the debt.
Can't.
Yeah, they're on a trip. It's like a religion. Everybody's on this satanic religion thing because everybody's afraid to admit, because they think, the carpet's going to get pulled out. And, yeah, we can't admit the debt because we've been brainwashed to think that would be the worst terrible thing, just on a mini level right up to the whole national level.
Actually, Shane, if you think about it, they can't acknowledge the debt because if we go back to the word of the Bible, when the Messiah died on the cross, he paid all our debts. There is no debt.
Right. I see the fit there a little bit.
So that's why it has to all be fictional because so now I'm connecting the dots. That's why we have the feudal system alive and well today, and they can only cloud our titles instead of actually cloud us, but trick us into answering for the cloud on the title.
Right.
Well, the whole thing. Yeah.
Well, when they work on the public site.
Is that Dan the Man?
No, this is Floyd.
Hey, Floyd, say it again.
I said they can only work on the public side, so that's why they keep expanding the debt, and we keep helping them to expand it by not giving them the res. Like
we're the only ones operate on both sides.
That's right. We have to operate the other side.
Did you say we're the only ones that can operate both sides?
That's right. We can operate both sides.
No.
Yeah. The public officials can only operate the public.
So look at the definition of legal fiction. It says it is the mask that you must wear to interface to their
Farmers. Yeah, well, that's what the name is, though. That's what the BC is. That's what the birth certificate.
It's a corporate. Learn how to operate the mask, the trust, the straw man, and then the conference.
Because you can't. A living soul can't interact with a fictional corporate entity. That's why we have it. But the birth certificate is a special kind of corporation. Because that's our own personal one that we can talk to or operate on our behalf.
It's not a piece of paper, man.
Well, but I'm talking in the conceptual, this fictional environment that's created. That's what it's there for, right?
But Shane,
you can't go into a court as a living soul. They can't see you as a living soul.
Right. So How do you talk to a fiction though? Answer the question.
Through the birth certificate.
No.
Move it. No?
You can't talk to a fiction. It's impossible.
Well, you put it on. It's your mask. Isn't it? Is that not close?
You got to get it into the private where your substantive rights are shaped.
Okay. But where's you got to bring you as a living soul, bring your birth certificate into chambers, and then you're talking to the judge now as he's still a judge, isn't he?
Wait a minute. There's no need to do that. You've already transferred res when you sign the presentment. There's no need to bring the birth certificate. You've already proved that you're sent here by signing the document. You've just got to go ahead and express trust in order to let them know that you have the ability to command, order, and direct.
You guys sound like you sign a lot of stuff over in the U.S., and that's always been a question of mine, actually, now that you bring it up, because I've never seen anybody, they never really have anything to sign. I just see a lot of people going to court and they get talked down and beat up and all this stuff, but I never seen them signing anything. You guys always sound like there's something to sign.
They're big on getting us to sign stuff over here, Shane. I don't know where you're at. Where you at?
I'm in Hamilton, Ontario.
Oh, okay.
Well, it's by Toronto.
Oh, but you know why? Because they get your signature by accommodation up there, I bet.
Maybe. What's that? How does that mean? What does that mean? I can't wait. Assume it? Just that we showed up?
If you signed something in the past, you gave them a power of attorney.
Oh, yeah, maybe the notice of appearance or something like that. But then, yeah, because, when I sign for tickets now, I've seen a lot of people do this now, so I got a lot of samples of it. You get a ticket, right in my head, $500 ticket, parked in a stupid hospital parking spot, and he put notice of appearance, signed without prejudice per, it never got back to him. But that's just because, obviously, you can't use the notice of appearance now in the court, right? I guess they couldn't charge him because he said he was going to have the court date, but he signed without prejudice, and I'm just trying to think of that because without prejudice they protected. They didn't have his signature in essence, and then somehow it still worked out that they didn't go after him.
I mean, everything is per agreement, really. So I'm going to debt
per as well.
If you can get them to, if they're going to handle the debt some other way, then it's paid.
Okay, well, if you said you're saying that when you sign, that's when you're expressing the trust right there?
That's what starts, yeah.
That's where the res gets transferred, Shane.
Okay, but then you still got to do, because everybody obviously signs, so what's the extra thing that you guys are doing that truly expresses the trust? People are signing it without understanding.
You got to create a trust receipt, right, Christian?
They've got to create a record that you can prove your claim that's for trust.
Right, this is happening.
Get to the public.
But this is happening real time in court, for example, isn't it? Is that what you're talking about?
No, actually you can set it up before court.
Oh, okay.
For example, tomorrow you get a ticket for running a stop sign, for example. Okay? You sign the ticket, you transfer res. And then you go ahead and you file your UCC1 to claim, and then you do the 3 to make to prove that you made a transfer. Right. And then you do your protective order to get into chambers and express your rights there and order them to make the payment for the rest.
How do you get into chambers again? That's always tricky. You just ask them, like I can, this matter, I believe this matter's been settled in the private. If not, that might be an opening.
I wouldn't say anything about the private in open court.
And you need to put a callable motion on the public side and ask for an in-chambers hearing because you have CCI confidential trade secret information to reveal.
Yeah, we're already making all those terms. Yeah, okay. Yeah, that's tricky to find that way to get into the private, though. Yeah. So but not hard. Once you get a few gimmicky things you can say, a few, one line power phrases,
Right.
So, yeah. Interesting. Wow. That's amazing that I can actually, I'm not memorizing all this, but at least I'm getting the job. I only started this whole game 2.5 years ago. Oh.
Shane, are you on Skype?
Yeah, I'm on Skype. Oh, is it sounding crunchy?
No, I was going to say, give me your Skype name and I'll send you some stuff if you want some stuff.
Ask Sigma 6. ASA Sigma SIGMA 6.
Let's see if I can find you real quick.
Oh man, I know this guy in Canada. In Canada, BC. He started this thing, and he was trying to build up a private trust company because they were getting all the mortgage people, and they were getting judgments against CIBC, and this thing went on for 3-4 weeks, and he got together with this Indian in Michigan, and he was like a paralegal guy, and they set up their own bank, I think. They got as far as that. But anyways, he ended up issuing checks to us. And I got this check for like $700,000. I've been trying to figure out how to cash it. Of course, no one's been successful cashing it, but I've held on to it. Mind you, it's over a year. But I was trying to figure out doing acceptance for value, and that's when I opened up this bank account without prejudice. But I haven't invested. Just trying to figure out it.
I wouldn't do it that way at all. How would you trust receipt, paying a special deposit? If you're trying to negotiate that instrument, in other words, it's a negotiable instrument, you are on the debt side and you're under the statutes and code.
Okay.
I can't help you. I'm not charged.
Well,
trust, then I'm going to pick a different law form. I'm going to use it for, say, pre-statutes and codes here in the state. Pre-1791, which was the formation of the United States. Pre-statutes and codes, pre-debtor creditors. I'm going to claim a law form, say, 1776, my Declaration of Independence.
Someone was even saying if you do it right, it won't matter that it's older because, you're going to be taking control of it anyways, But, if it's a big amount of money and I don't want to practice on it 700,000. I'd rather get someone, someone wants to do something with it and I can give them a donation in the equivalent of a percentage.
There is no money. What are you going to get me?
I don't know. Whatever, give Romans things to Rome, right? But, I have all the documents scanned. I mean, maybe you can take a peek at it, Christian, and if you think you see anything there. I've been sitting on this thing for over, December 8th, so it's a year, 12 months now, watching everybody else.
Treated as a non-negotiable instrument as a special deposit and deposited as a special deposit under trust. Now it's private.
Yeah, that's the whole thing. I guess it's going to be, but if it's deposited privately, how do you access the funds? How do you use it after that? Because there is a private-public thing going back and forth. One person was saying get the court to sign it or stamp it to make it public.
Yeah, under deposit, plus deposit.
Yours sounds like the other way around, though. It's keep it in the private.
Yes, I make a special deposit, say into the court or into the treasury, but as a trust deposit.
Well, I still want,
and then tell us to disperse the funds. And who are we going to disperse the funds to? The beneficiary. Aren't you the beneficiary on that?
Disperse the funds. So again, I could turn that into, you're saying that could become a trust day all over again. No way. Would it matter that it's over a year in that situation? They come back to, this check's over a year now, and
Well, instrument, it's not negotiable. It's trust. Negotiable is debtor creditor, and they got all the tax
code that it follows rules and regulations it falls under. Non-negotiable trust and doesn't fall under negotiable instruments. Doesn't fall under statutes and codes. Especially like Clean Law Form 1776.
Okay, because the way, yeah, it's interesting. The bank is in Michigan, but the P.O. box was in D.C. This was these two characters, Pat Holly, Michigan, and John Dempsey in D.C. As you're in the next.
Yeah. Take your special deposit, make a traffic ticket payment with it, and then tell them to pay the debt, and then give you the overage back.
Oh, yeah, right. Change back. Oh, they're traffic. Oh, wait a minute. I gotta wrap my head around that. I gotta completely understand this though if I'm gonna do this. I don't want to just go through the motions of an instruction. But you're telling me the way you're talking though, like you see very simple potential in this.
Yeah.
Come on. I mean, I've been sitting on this thing 14 months and watching, like I said, everybody basically, get blown off the runway, essentially.
Well, the study trust more, give us a better handle on it. And
well, time is very short for me. Is there any way maybe we can get into some private consultation?
what are you going to do, die?
No, I'm just at the end of my rope, I've been pushing this thing and putting everything into it. Like when I first come onto this whole commercial redemption thing, I just went nuts on it. And, maybe a little bit, I'm really, get caught up in something and I can't get my head out of it,
You're closer to understanding this than you think, Shane.
Well, I know. But I don't want to make a silly mistake on something like this. I just maybe, run through it a few times with somebody just to make sure I got this thing straight. I mean, I found you, right? And I have a sense, I believe that. I don't mind thinking my own thoughts. I think that's why I'm here listening to you. I can't believe this conversation, by the way. This is just, you're so down to earth, Christian. It's mind blowing. But, yeah, I mean, I just felt like I've been running this marathon. It's just for
you watch and see what's trying to at a treadmill. You're not watching. But look at it, and you're going to be surprised how much you're going to learn in the next 2 weeks.
Why? Because I'm reading all this trust stuff. Putting my mind to it. Yeah, and listening to you. I mean, I'm just listening. I just put your stuff continuous. I run all my computers and I got an HD TV. It's just hooked up to a dedicated computer. Google videos my CD and I've mastered that. I don't know, 10,000. I got like all Winston's DVDs. That's where it started. I got 2,500 Sam Kennedy MP3s, and I mean, I can, I know how to look after. I build my own hardware computer system, But I just arrived here, so to speak, and somebody turned me on to these Christian Walters things, and I remember when I first listened to it, it almost like was going right back to the first day Winston Shroud Fort Collins, like, what the hell is this guy talking about? I mean, and too, it's another thing, like, Canadians in general, I just have a hard time. I'm starting to get a grasp on bonds, right? Americans got a whole different thing. It's like they've got income tax and bonds right in their faces, I guess, all day since they're kids, and it seems like they got the bondsmen and bail guys, and you get all that. They don't really do that stuff unless you go to jail or courts or whatever. And I haven't really done that until my own experience. Everybody has an experience that throws them in this way. But so I learned about the whole, I don't know if you watched Winston Shroud Fort Collins, but he basically started off. That was the very first thing that I got my hands on. And he basically, I have to admit, I'm really glad that I invested a lot of time in Winston, even though I didn't understand what he was talking about. He, talked about the Foreign Situs Trust and little Johnny No Name and how that he filled out the SS5 and got into the SSTK Trust and he just goes through the whole thing, right? And he speaks very basic. And I was loving it because I wasn't getting to the application level yet. I knew I had a lot of ways to go through that. And then he starts talking about subrogation and bonds, and I was like, what the heck is all that stuff? So now I got a better sense of that. So, I mean, you can talk to me about philosophy, you can talk to me about computers, you can talk to me psychology, you can talk to me, basic math, English, science, that kind of thing, statistics maybe. But I never got into paperwork. not that kind anyways. Income taxes, business, this banking, insurance, never touched it my whole life. You know what I mean? So I've been jamming this. Sorry?
All that. Insurance and bonds and all that, if you start thinking, contracts, every time you hear that term, it's played.
Well, yeah, trust, and even the concept of subrogation. That's such a cool concept. Is that a trust concept, by the way? That's what was indemnifying, right? When you indemnify, you're subrogating the rights of the person and indemnifying is essentially insuring. And insuring is you're placing some kind of bond. You're creating some kind of paper thing, which is a trust, I guess, saying I promise to look after this person. But of course, the other side of the sword is you also take any benefits, so insurance companies will go after somebody and sue them, and they're hoping to get money out of them, right?
That's what subrogation is.
Subrogation means, well, according to Winston, I'm just like I said, I learned from him, so he's my appeal to authority, but you have usurped the rights and defenses from the other party. Winston will always say, you get into a car accident, what does the insurance company always say? Shut up, because you don't have any rights or defenses. They do. They're the ones that insured you. They subrogated your rights and defenses, so that's what subrogation means to me. I hope that's right. Does that make sense?
They bought everything out, they bought all the debt out, and you were the only one. You just subrogated it.
Well, that's what it means when people buy insurance, isn't it? That's what they're doing, right?
Yeah, but insurance is trust. Bonds is trust.
Okay, so from a trust point of view again, how would you look at that? John Smith goes, gets a
the trust. Are you using a debit or credit, or are you trying to do a payment on your trust?
Well, I'm still trying to, like I said, I just got here, so I'm trying to get examples from you, how you translate stuff so that I can see, I don't see the trust in everything yet, but I see it in a lot of things, because I see how it fits on all the stuff that I had questions that was sticking in my mind. But, here's a practice.
We got to look at that since there is no money, there is no ability to make a contract, and if there's no ability to make a contract, then how are we paying anything? Then everything has to be gifting, and gifting is trust. So everything has to be a trust. No matter whether I go to the gas station and buy gas, I'm forming a trust. Whether I go to the grocery store and buy groceries, I'm forming a trust. Everything is a trust.
Did you say those little dollar bills, the little FRNs are like little trust notes?
That's exactly what they are. Yeah.
I love it. So can I send you some stuff, Christian, and I want you to look at this, and it's the check, and there's a couple documents I think we were supposed to fill out to let the government know that we had these funds. I was very fortunate because a lot of people didn't get their checks. I forget, somebody asked me to sit in and give my opinion on what I thought. Next thing you know, you got all caught up with them. And
did you listen to 127 downloads from 2010?
Oh, wait a minute. Somebody's trying to send me something here. Oh, wait a minute. Imagine. Who's Imagine what? Oh yeah, the one, I downloaded all your stuff, Christian. I download everything.
The 127 is laying everything out from A to Z, and it's really pointing out the safest method of how to get interest on the public side that you're going to generate, and you're going to pay all your bills with the interest. That's the safest method because that looks like everything else and nobody can tell the difference. Rather than $100 million debt or creditor thing was created and try to negotiate it, or even taking a chance of maybe even using it as a trust and making it as a payment and try and get people overage from it.
Well, I mean, if I could get anything out of this check, I'd be laughing. It'd be a term for life.
Problem under the trust thing yet because we haven't pulled out the main group because we're really under a discretionary trust and it's for discretion of the trustee on the bankruptcy whether or not anybody gets a remedy in anything. So until you express the trust, you claim the trust and prove the trust and then terminate that trust and then make the crossover from the private to the public with this LLC and then give them the instructions to generate the interest from the trades from the privately held assets. And then deposit that interest to the public side into a checking account in this LLC that nobody can tell the difference because it looks like everything else.
That's a heavy point, sticking point with a lot of people. They think that you're going too extreme when you try to terminate the existing one. But that's essentially what you're trying to go for here, right? You want to terminate that one, basically get out the res, which is our actuarial.
We're going to pay the debt, present, future, and past debt. And we're going to take the remainder that's in the trust and form another trust with it, and it stays on the private side. And the private side then is the one I set up, that I ordered set up. It's mine. They didn't set that one up for me. I ordered it set up. And all the assets are put into that are not used up. Now, I'm going to cross over into the public and create an LLC there. That straw name doesn't exist any longer. That LLC is now going to function in the public. I'm going to order them to generate interest from the trades held based on the assets held in the private. And that interest is going to be deposited in that LLC in the public. I'm going to live for that the rest of my life on that interest. And that interest,
nice.
Everything else, it looks like debt because it is debt. But I didn't create it, they did. You got to look at the W-8 Ben instructions on the publication 515 in the IRS. I forget what page it is. But anyway, it says you need a broker in there. And that broker is the one who generates the trade or the interest for the trade. That way you're not effectively connected with the United States business or trade, and you're not taxable, you're a non-resident alien, and you're being held strictly in the private. But you're interfacing on the public with this new LLC, this new strongman entity, so to speak.
That's a lot.
You've made a circle or a circuit, and now when you complete the circuit, the currency or the current flows.
I don't doubt that there's some people that must be operating that way. That the wealthy must teach their children something like this. Or these elites. I mean, let's face it, the families behind the Federal Reserve and people like that, because they're the ones who created all this. This is child's play to them, I'll bet. But if you created this LLC, would you make it like just basically your name?
Well, it could be my name with a different number that they're going to give me as recognition. Under a number 98 status under the IRS.
You want to create you want to terminate the other one and create a completely one because you don't feel you got enough control over the existing trust?
I'll eliminate all vestiges of that entity strawman. That account, wipe that account out. Eliminate it.
Right.
Everything that's attached to it is now, and all the records gone.
Oh, because it's just a lot easier for them to try and go back and catch all those signatures?
Well, all the records that are associated with it. Let them terminate it, and now there's no connection to all that stuff.
does exist.
Yeah, isn't there something you can do with the existing one though to do that?
Yeah, form enough, terminate this one, and then put everything that was in the other one into this one, and then get a new identity.
Oh, but I mean, not just that. Like, I mean,
Walters, instead of being the old Social Security number trust account, is Christian Walters with the new account. Has anything looked like it's changed? No. What you've done today?
You don't feel there's a way to clear out all that account without terminating it?
No, that's how you make the payment of the debt. Got to terminate it. Got to merge the title.
In a way, termination is actually a word for paying it.
Yes.
Okay.
Oh. Yeah.
Zeroing the account. This is almost getting back to the Christ and the cross and the left and right ledgers and the redemption and everything.
Mm-hmm.
But I can't see that they would set the system up unless they were really, in a way, maybe that's what they were trying to do. They're making it so hard that
when you know what's going on and you understand and you issue the orders, they've got no other out.
They got no other out. Yeah. It has to come from your knowing and understanding.
I'm going to ask them, because asking as king is asking questions. I'm going to ask them, is there any other form that you need to complete this task? Yes or no?
Are they obligated to tell you?
If they say, well, you need this and that, well, okay, give me the forms that I need so I can make them out. If they say no, well then I order you to terminate the trust.
Right.
Now, when the trust terminates, what does the trustee, what must he do?
You say disperse the funds.
Disperse the funds. So now I'm going to give an order to disperse the funds into this new trust that I'm giving an order to create.
Yeah. Yeah, if you sat down with the banker in private and let him know, he'd probably be pretty happy.
Yeah.
As long as it doesn't get outside of the bank, so he's happy because he's still in he can still operate the fictional world. The only thing he's doing is he doesn't care that you're no longer under the power of the government because you'd probably be his best customer.
I'm not taking the money out of the private, trying to commingle it by putting it in the public. I'm leaving it there in the public, the private. But I'm creating a separate entity, a new entity, and I'm going to operate through that on the public side. Now, nothing has really changed except I have instructed everybody to do what's being done instead of them duping me into this debtor-creditor thing.
Well, yeah, that's for all the other people that want to be left in the matrix, basically. Have you know about private banking hours?
Yeah,
stuff like that.
Yeah, back office banking.
Back office banking, yeah. I heard somebody told me that they said they wanted to speak to a private bank manager or the private something. They wanted to talk to, so they actually, after the bank was closed, they brought them inside and they locked the doors and they had to make an appointment to actually talk to somebody. They were trying to talk about the birth certificate, right? I don't think they got very far, but just the fact that went down kind of blows my mind, right? Anybody hear that?
Oh, I'm trying to figure out what they were doing.
Mm-hmm. So, but just as I'm sitting right now, I never did. I learned a lot. You learn by doing. So I remember I figured out very quickly ahead of everyone around here that at the time, we had to do the VC bond process because everything he was talking about was based on that. So, that's where I learned about UCC1. And, mind you, there's two different kinds of UCC1 financing statements, right? There's the national form of the UCC1 and there's the state form. That was a big issue. I was so hated because they kept pointing out people's mistakes and stuff. Nobody knew that UCC1 financing statement national form was just a notice of claim, not a lien. Well, we went through a lot of learning curves, but at least it exposed me, right? It was all, I have this saying, everything's grist for the mill. You know what I'm saying? It's all grist for the mill. Remember everything, even if it doesn't make sense. Because you don't know when it's going to come back, like what's happening here.
Well, this stuff all ties together because you're going to use it too. If you're going to make LLC into the public and do the debtor-creditor relationship again, but it's not effectively connected with a business or trade as long as you don't generate a profit.
So you're going to have funds in a holding company set up as an LLC. I think we don't have an LLC. There's some kind of equivalent, maybe a limited company or something.
Yeah, corporation.
But essentially, it's a corporation, a holding company, right?
Yeah.
And then, which kind of makes sense. I mean, that's basically, in a way, what the birth certificate is. That's what we're doing. We have something of a corporation in the birth certificate. You're just formalizing it. And you kind of like the clean start concept. There was a story, this reminds me of the story Menard talked about, Arthur Menard, Rob Menard, our beloved Rob Menard. And he said there was some lady, and she went to court, and she fought because she basically wanted to get these funds out, right? He was on a trip about security of the person. You guys have the pursuit of happiness, freedom, I forget. Ours is something to do with security of the person. And his sister's actually a corporate government lawyer or something like that. So he can ask her questions, but she can't answer directly. So he plays his little game with her. She doesn't respond. It's considered like that. So he said that he found out this person, the security of the person is an actual document. Lo and behold. And then he related the story, but he never got into much detail about it because it seems like maybe it's just an urban. But he went to court and they pushed the government and basically they cashed out for $8 million. Probably got screwed by the government, it sounds like. If there's as much money as Myth would have it. But you know what? I'd take $8 million right now. And you know, I would probably convert it into gold or something, tide myself over until what happens in the next 4 or 5 years. But that's the story anyways, that he kind of fell off the wagon. I don't know exactly what happened. It almost looked like he got too close to it because it was this little bogus thing in the media where he was having a big fight and he wanted to go away and be in the forest or something like that. It's just like, what happened there? This guy was hot. He was chasing down his birth certificate, treating it like it's a warehouse receipt. We just got to find a place where we can cash it, claim it. You know, I just thought he was basically catching up to Winston. I talked to him about this stuff, and I told him I followed Winston a bit. He said what everybody says. I mean, all the critics always have the same comments. But, you know, he's so boring to listen to. And I said, well, I kind of like the Southern accent. You know, I think Winston is a good man in his own right. And you know, he did blaze a trail. You can't untwist all the ties and all the things. You look at all the people who've influenced you. I look at all the stuff and all the people. My God, it's never ending. Now here I am talking to you. I can't believe it. But with a certain amount of presence, I guess. But yeah, that was the story. There was somebody who apparently cashed out for $8 million.
Can I say something? Yeah, go ahead.
Yeah, I got an email the other day from a friend of mine, and there was a fella that actually tracked out his birth certificate, and he shows how you can go in and find it. The only thing is, that the Fed have gotten wise to it, and people had actually tracked down their birth certificate, and the value it's in a mutual fund is they put a block on it so that now when you go in and follow the formula to get into it, it shows that there is no match. But before that happened, he found out that his birth certificate was worth $28 million, and he was born in the 1950s. So there is a lot of money
doesn't even sound like a lot. Like it sounds like they've been really hitting on the account. If we only had 28 million, I'd say. But I've heard somebody else say something kind of similar. A very credible person, very serious study, research people. I don't do the research that well. I try and get stuff in my head. But yeah, he said something similar about going to a site and putting it in and one of these investment sites, and then they changed it up, I think. So you couldn't access it.
The people that found out what their value was worth on their birth certificate tried it again in a week later, and they couldn't get back into it. It came up with no match, just like mine did.
Well, I'll tell you a story. I knew there is stuff like that, man. I knew this is kind of off topic, but just to show you that there's things that go on. This guy, he knew a guy who worked and started about, and this guy had a special code. They changed the number. It's just, you know how you put in a 16-digit number for like if you want to pay, if you got one of those bell cards?
Yeah.
For long distance. Well, they give this guy 3 numbers, and then the last 12, what is it? 3 minus 16, 13 digits just repeat. And he did it, and he called anywhere in the world, and it didn't show up on my phone bill. And then I figured out it can only be so many combinations, right? And so I said, because you can't do 0, can't be the first number. And so I just figured it out in my head. It could only be 1,000 different combinations. So I started pressing on this phone and trying it. And all of a sudden one hit and it went through, because I had a repeater on the phone. So I could just do 1, 2, 3 repeater, 1, 2, 3 repeater, right? And I made this call, and then I think I tried that same code the next day and I couldn't get through. And I just figured they probably saw it, and then they probably saw the couple hundred tries previous to that, and then maybe just close that door. But I just thought that's kind of fun. Technically, you could do that in an emergency, I guess. Sit there on the phone. Yeah, I did. That's fine. So they change the code every few months, so it protects them. But these guys can just go around and get their code. They just 1, 2, 3, bang, make a phone call anywhere in the world on anybody's phone. There'll be nothing show up. So I should have tried to let somebody else do it. Not really much.
Well, I'm getting tired.
Yeah, can I say this? Just before you go, kid, so you're saying basically that as I'm sitting here, I don't necessarily have to do anything besides like my knowledge and understanding, but you think I could do something with this check?
I'll say the safest way is to terminate that account, set up the whole thing like I described.
Oh yeah, you mean the whole the birth certificate?
Yeah.
That's huge, though. That's. Yeah. Okay. Fair enough. Yeah. Pretty much. I think that yours sounds like a more holistic process. I never carried out Winston's because I got stopped at the concept of private and public and a few other things. And yeah, I said I'm not going to do it if I don't understand how it goes. I'm not just going to have half the work. Sorry.
I say I've used that. I know it works. I've had some discharges with that. I've discharged over $500,000.
You've done this process then?
Yes, I have. Yes. It went using similar to Winston's stuff. Yeah, I've done discharges.
Oh, okay. Yeah. Yeah. But what you're talking about is not that.
Over $500,000.
Well, yeah. I mean, people are doing Doug Little's approach right now, which is sending kind of stuff to U.S. Treasury for deposit. And actually, if you look at what Doug Little's doing, it's the exact same wording that's why I wanted to ask you originally. It's the exact same wording that Winston put on the PC. Accepted for value by drawee, exempt from levy, the whole thing, the exact same thing.
And we're doing negotiable instruments, and then that's that. So what we've done is we just here we thought we were doing set off discharge, but not. We're mounting debt up. We're actually not accomplishing what we thought we accomplished.
Most likely, yeah.
the right side. We came in on the debt side. We didn't come on the public side or private side of the treasury. We went through Geithner. Oh, awesome.
Well, this is part of your course then, I take it.
Right.
Okay. So do you got an estimated time when this is going to be up? And
well, I had planned on releasing it shortly here, but then on this website kind of set me back a little bit. So we're getting there.
Do you think there's any kind of immediate process I can do with this check, though? And you can see the forms and see if it makes sense to.
Well, it's probably a little more different than what we've been doing in the past. It's all debt or creditor stuff. That's the thing.
Well, I for now, I just think, I just want to put food on the table and continue in my, my study. I don't want to make a living out of it necessarily, but I'd rather take it and use it to fund more learning and more meetings and groups and people who are doing this kind of research, right? That's all I see going on, and I don't see anything having any relevance anymore once you realize, about the matrix and stuff, essentially. You know what I'm saying? You guys must all have more fun being at sea, I'm sure.
We're going to do it all. We're going to the workshop when I get the workshop on. We're going to terminate the whole thing.
Okay, well, I'd like to, if I could, I'd like to send this to you. Maybe you could give me a couple of suggestions of flyers. Just have a look at it. You'll see it'll just be a whole bunch of JPEG scanned images.
Yeah, you can send it to me. I'll take, if I got the time, I'll take a look at it.
Yeah, I imagine you're pretty busy too. Okay.
Here's the thing, if I get stuck on one person, I'd rather on a call, I can reach thousands. Tens of thousands, a lot of people.
Well, if there's something in this check thing, though, I'd like to, obviously I'd like to give you a donation or whatever, right? And I don't know if it means anything to you. It's not about money, but, let's face it, money is keep the roof over the head and the food on the table for now, right? I'm still pragmatic enough to
It might depend upon Federal Reserve notes for the everyday sundries, yeah.
Yeah. So that's what it's all about for this is. But yeah, I mean, I want to figure it out properly. I don't want to always be having gimmicky little things with weird checks. I mean, this guy, a lot of people lost their houses. A lot of people put too much trust in these guys because people reason they don't learn anything. They keep waiting for, the magic bullet, but it's never going to come.
What you just said, they don't learn anything.
Yeah. No, I know.
That's how to do it for them. And when they go into court, they're deadbeat.
Yeah. Oh, yeah. Yeah. It happens within minutes. That's too funny. I had the fortune to be able to go in and watch some of these people. And it's just stupid. They just they don't understand. It's like, just like the same way people when they go into investing in stocks and Forex and stuff. I mean, I did a little bit of that, and it takes a huge amount of study and discipline. And then you still got to practice it.
The technology. Like Sam said it out on the technology.
Yeah. People get involved in too much magical thinking.
So it's superficially parroting terms, and they don't know well enough to go into court, and they're deadbeat.
Yeah, I don't know anything about court. All I know is how to stay out of it. That's all I learned. That's it.
Out of court.
Yeah, exactly. Well, gentlemen, you're right. It's late, but it's been a pleasure. Great talking to you, Christian. I mean, I am so looking forward to your future calls here. I was just lucky to get into this one. So Saturday's your kind of your public call. I guess this seemed more like almost like a little private session. I felt very intimate conversation here.
Saturday's more of a teaching thing, although I haven't been really teaching the last month or so. I've been using more of the question and answer now, but if I get back into teaching, that's the one I usually do the teaching on. Tuesdays is more or less an open forum for question and answers. Monday is the Trust to Bachelor's group, more in-depth stuff. And Wednesday, we go over Gilbert's law summaries, and then we have question and answer afterwards. So Saturday Tuesday and Wednesday.
Saturday, Tuesday, Wednesday, yeah. Well, then I'll most likely maybe catch up with you guys tomorrow. But I don't have my book, but I'll have that in a week.
Do you have the number? Because that's a different number. That's TalkShoe.
Yeah, I got a spreadsheet here. I've been picking up stuff from, well, I mean, I got you running in the background right now. Just going, I just do that immersion thing. Wednesday, I got the TalkShoe at the 41,875.
Yeah.
Yeah, and I got you 2 emails, Christian moving titles and moving titles at Hushmail. You got a preference for either email?
Hushmail fills up pretty quick, so.
Okay, so the Christian.
It's no longer Hushmail anyway, is it, Christian? Yeah, I still think I have it. I don't know if it's been where it might be jammed up by now.
We got different emails, hush.com, Hushmail, all that kind of stuff. I just stick with, we try and keep private, I guess, if you're at Hushmail. Hey, Sam?
Yeah.
I don't blame you. Okay, well, no, I got you. I got that, and this is just a phone call. There's no website associated with this call, is there?
Well, the website was movingtitles.com, but it's not up right now. I'm planning on getting back up.
Yeah, I've been to the site there. That's where at least I downloaded some of the downloads. Your NTT and moving money banking and trust stuff.
Right. Moving titles.
Yeah, that's a good 100. I think I got a good 150 hours. I just figured I'd expose myself to all that to get into the concepts and ideas so that if I take your course, I'll be hit the ground running, you know?
Right. Okay, sounds like you've got the numbers then.
Very much. That's great. Again, I think this is just, I didn't expect to have the chance to even be able to talk to you because I thought, oh my God, how are you going to talk to this guy? Because you are fast and complicated and I mean, like, you know, I think that's what it is, man. I think you're intimidating a lot of people, eh? Let's face it, people, like I said, I think the whole world operates in fear and insecurity. And people don't want to admit when they're stupid, right? I don't mind saying what I always say to people, don't pretend to know what you don't know. You get yourself a lot of trouble.
I think there's a lot of people that are teaching acceptance for value that are afraid of trust because it's infringing on what they've been teaching for so long.
Right. Well, I mean, look at got somebody like Doug Riddle, okay? Nothing wrong. Seems like a nice guy. And I mean, this is all, you know, it's not about judging and I treat it like science. But, I mean, what he's doing is a completely pragmatic approach. He's not pretending that he really understands the mechanism. He just said, basically, I do this, and this, and this comes out the other end, and I don't really want to know how this black box operates. And,
a lot of people say all I'm doing is teaching theory. This is not theory.
I know you said that a lot, and I mean, that's when when I first heard you, I thought, this is cool, I like what I hear, my ear did perk on it, and I really dealt with that intuition, but I looked at the massive amount, and I thought, whoa, but I got a good friend of mine, and he's a serious research guy, I can't do it myself, I have certain people that are smarter than me, and he said, this guy, man, all he's doing is he's reading from a book. And I thought, what do you mean? Like in a good way or in a bad way? He said, he's reading from a book. He's like by the book. He's laying it out and he's not just making the stuff out of the top of his head. So it's like, yeah, actually that makes sense. I mean, you're teaching it like a teacher, you know, as close as you get. And, so I started to go back and then, like I said, the more, I turned somebody else onto it. Certain people get attracted to it. Reasonable, self-balanced people, I think, Christian. Most people aren't. And you know, like I think when I'm screwed up, I'll be the first one to admit it until I find my center again. Most people don't have it. They're not willing to admit it. So, you know, I tried to talk to Nick Croft. I have a big list of what I call big names. And I correspond with Vic back and, I'm kind of just trying to tease the idea and every time, because like I keep seeing what you're talking about and things, and I'm not really articulate and intelligent enough yet to make a good argument, obviously. I mean, I'm just a student myself, but I know, like I said, I think I have an ear for truth. I think I do. I think I have an ear for logic. Because, when something doesn't sit right, it creates a question that never goes away, right? That's how my brain works. I mean, I'm a computer hack, a hardware hack. I build my own computers because I can't conceive the idea of having somebody build my computer for me. You see what I'm saying? And I see a lot of them now. I always use the computer metaphor in the legal world. I see it, there's a correspondence that the legal, it's almost like the legal system was a kind of a computer that they were operating. They created an environment and they put these functions into it and they were operating it.
The only thing that I've done is I've taken a box with a lid on it and just pulled the lid off and showed all the worms that are in there and how they're crawling around and how they're doing it all along. And that's the actual proof of how they've been operating the trust all since history and how they're doing it now. And they're going to continue to do it tomorrow the same way. I'm just showing everybody what has already been done.
And I've always believed that true genius is seeing the simplicity in things. And I think that's what you've done. You've got this so basic and fundamental. That's what I think it is.
I wish I'd have known this 12 years ago before I went to prison.
There you go.
See, I mean, I've been there, done that. And I'm not going to do it again. Well, I'm going to say good night, guys. So, catch you tomorrow. You guys.
All right. See you tomorrow. And nice meeting you guys, Greg. Good night, all.
Night.
Excellent talk.